Check one, two. Good morning, everyone. I'd like to call to order the Tuesday, March 3rd, 2026 public hearing of the Human Services Committee. We have an awful lot of folks here to testify today, starting with our Department of Social Services. But before I do, I'll just make the following announcement. In the interests of safety, I would ask you to note the location of and access to the exits in this hearing room. The two doors through which you enter the room are the emergency exits and are marked with exit signs. In an emergency, the door behind the legislators can also be used. In the event of an emergency, please walk quickly to the nearest exit. After exiting the room, proceed to the main stairs or follow the exit signs to one of the fire stairs. Please quickly exit the building and follow any instructions from the Capitol Police. Do not delay, do not return until you are advised that it is safe to do so. In the event of a lockdown announcement, please remain in the hearing room, stay away from the exit doors, and seek concealment behind desks and chairs until an all clear announcement is heard. With that, I will call our first speaker to the day. She's already there. Commissioner Barton Reeves from the Department of Social Services. It is good to see you. Welcome back to the Human Services Committee.
I am glad to be here. Thank you for having us. Good morning, Chairs Lesser and Gilchrist, ranking members Perillo and Case, and distinguished members of the Human Services Committee. I am Andrea Barton Reeves, Commissioner of the Department of Social Services. We've submitted written testimony on many of the bills before you today, and I'm pleased to offer remarks just on a subset of those on today's agenda. I'll start with House Bill 5355, an act concerning fuel pricing in the Low Income Energy Assistance Program, otherwise known as LIHEAP. So this bill updates the statute to remove references to outdated language with regard to the CEAP program, the Connecticut Energy Assistance Program fuel delivery model. So following the passage of Public Act 24145, there was a convening of a working group that was comprised of legislators and state agencies, stakeholders, and industry experts to identify best practice for reimbursing fuel vendors while also maximizing the funding for recipients. And we were tasked with developing a new program delivery model based on the recommendations of that working group. So through that effort, we have identified new pricing standards no longer tied to county-based pricing, which is considered undated and is not used by any other state. The department has, as approved by the legislature in our 2025 LIHEAP allocation plan, now has regional pricing standards for deliverable fuel, as well as options for vendors that include discount off retail pricing. So by removing the word county from statute, we seek to align our state law with the regional pricing practice that was developed through the working group, approved by the legislature in our LIHEAP plan, and integrated into the program delivery model. This also provides necessary clarification to the statutory language regarding the manner in which the state determines daily pricing for fuel reimbursement under the margin over rack pricing option, which provides for transparency for participating vendors and administrative accuracy for the department. Therefore, we urge passage of this legislation. The next bill I'll speak to is an act concerning residential care homes. The department at this moment is in opposition to this bill for several reasons. First, we believe it will be in direct conflict with the current rate setting practices set for residential care homes, which I'll refer to as RCHs, and current department regulations. As just one example, the bill calls for an increase to the current limit for administrators' salaries from $63,407 to $75,000 for RCHs with beds of 60 beds for RCHs with beds of 60 beds or less. This is not a cap on the salary. This is the cap on what we would pay as a state for the salary, and the RCH itself, through other resources, can pay its CEOs or its leader anything beyond that. But the change to the base from 63,000 to 75,000 would increase the cost supplemental payment by about $1 million. This bill also calls for the removal of an important inflationary adjustment that is intended to support RCHs, actually removing the current inflation increases based on the gross domestic product deflator. And it removes our ability to actually recognize inflation using the national gross domestic product index and replaces it with an undefined index. The bill also calls for an inflationary adjustment of 3% in 2027, which will increase the cost by $2.9 million. We also have concerns about the proposed increase in the minimal allowable fair rent from $3.10, I should say, to $5 a day. We estimate that this will have a fiscal impact of about $1 million. And we know that fair rent is important. Obviously, it supports capital improvements and the purchase costs of a building. But we also welcome further discussion before committing to increasing the current limit. The department also has concerns about the hold harmless provision that requires any rebasing rates to include a stop loss so that no provider's rates is reduced as a result of the rebasing. This provision just eliminates rebasing entirely, which is concerning because rebasing really is the foundation upon which we provide adjustments not only for RCHs, but we do this for community living arrangements, for ICFs, and for nursing homes. So therefore, the rebasing is critical because it helps to account for correctly accounted reimbursement costs, and then, those costs are often removed when the cost expires, so it ensures that costs are correctly reflected in the rate and that the state is not overpaying or underpaying. Finally, and this is just a small correction in the bill itself, there is language in line 239 of the bill that is actually duplicative of language that's in 239. So we were just raising that as an issue that one of those lines probably should be stricken because they are duplicative. Moving on to House Bill 5358, an act concerning the rebasing of rates and reimbursement for certain residential facilities, we do urge the passage of this bill. This bill does a very important thing by codifying the process for the periodic review of community living arrangements, commonly known as CLAs, and intermediate care facilities, known as ICFs, for the costs and states reimbursements, commonly known as rebasing, which I just referred to in the RCH context. This will allow for a regular rebasing frequency that aligns with the application of inflation adjustments so that beginning on July 1, the cost for ICFs and CLAs will be rebased every 2 years as determined by the commissioner and when there are funds available. The last rebasing, as an example, for CLAs happened over 10 years ago. So having a regular cadence of rebasing every 2 years would make sure that that state funding stays in lines with costs and that the state is not overpaying or underpaying for costs that have been diminished or eliminated, such as mortgage costs. It also provides for providers' costs being accurately reflected to support important resident quality care, including food, room and board, resident supports, and other costs that ensure resident quality of care. So for this reason, we urge the passage of this legislation. The next is House Bill 5040, an act implementing the governor's budget, recommendations for health and human services, specifically several sections in this bill. The first would be for the state administered grant assistance, commonly known as SAGA. Rather than read all that I have here about SAGA, let me just explain it in a different way. And that would be that SAGA usually determines if an applicant for the benefit is unemployable by meeting certain medical, non-medical, or transitional criteria. While that eligibility is being determined, this individual usually receives a very small amount of money. It can be as low as $66. Almost every single time, that individual is then determined to be eligible. So then they're receiving the $66, which is really, it's unsustainable in terms of living, only to be able to get back to be determined eligible retrospectively or retroactively for the full amount, which is also quite small. It's $262. So what we are recommending here is that we just stick with the $262 from the time that the person applies for the benefit, because there are very, very few circumstances in which a person gets the 66 and it remains at the 66. We often have applicants. These are people who usually don't qualify for any other cash assistance. They're the most subsistence level of the people that we serve. Moving on to Section 2 of the bill, this eliminates the restriction of not managing antiretroviral drug classes in our Medicaid preferred drug list. So right now there are over 140 therapeutic drug classes on what we call our PDL. And it allows a provider to often prescribe medications on a step approach to being able to do this. And if that doesn't work, then the provider has flexibility in many different ways, but antiretrovirals are not on this list. So there's not a lot of flexibility that we would actually like our providers to be able to have. We actually are asking for this change because it helps us to better manage outcomes for our Husky members, and it has the potential and the practice of providing appropriate prescription coverage by assuring alignment with our clinical criteria and best practices. So we do this for many of our drugs. Antiretrovirals happen to not be in this category. So with the passage of this section, that would include them in our PDL and in those classes. Section 3 of the bill maintains the income and asset limits for MedConnect, which is also known as the Medicaid for Employees with Disabilities program, which became effective in April of 2025. Right now, those assets are set at 75,000 for an individual. But the bill would specifically call for the increase of that limit to go to 85,000 and would double the asset limit from 20,000 to 20,000 for individuals and 30,000 for couples. And it would phase in the elimination of income and asset limits over 4 years. So when it's fully annualized, this expansion of coverage is projected to cost the state $8.3 million or 16.6 after factoring in the federal share. And given these costs, the governor's budget supports the maintenance of the April 2025 levels going forward for a savings of $1 million in 2027, 2.1 after factoring the federal share. Moving on to Section 4 of this bill, it provides important rate increases, as I spoke earlier, to intermediate care facilities or ICFs for persons with intellectual disabilities. This increase to the Medicaid per diem will also provide our ICF and IDD providers with additional funding that is absolutely necessary to support resident care, worker wages, and a direct benefit to Medicaid members receiving services in our ICF IDD facilities. This language was included in Senate Bill 298, which has recently passed and is awaiting the governor's signature. It will allow our ICF providers to receive a per diem increase of 5.8% starting July 1, 2026, and a Medicaid per diem increase of 6.3% starting in July 1 of 2027. Moving on to Section 5 of the bill. This bill targets the increase for nursing home facilities to support wage increases for nurses. Licensed nurses, specifically who are engaged solely in direct patient care. In 2025, the governor did make a significant investment of over $110 million gross over the biennium, with additional commitments being made in FY 2028 to the nursing home industry. Direct care staff, such as nurses, we know are essential to the good quality care in nursing homes. So we are fully supportive of rate increases and wage increases for this population of healthcare professionals. Moving on to Section 6 of this bill, it allows the Commissioner of Social Services to review data on the effectiveness of certain high-cost medications. This actually will allow the department to better position itself in rebate negotiations with manufacturers to drive down costs. As many of you know, our Medicaid costs are driven in two specific areas, and one of those is absolutely costs and pharmacy. So having the ability to negotiate these costs, particularly as high dollar drug costs continue to enter the marketplace, it is important to understand if we have alternatives in order to manage those costs better. So we are in full support of the changes in this bill. Moving on to Senate Bill 327, an act extending emergency Medicaid coverage. This bill would establish a new definition for emergency medical condition. It would also require DSS to expand emergency Medicaid coverage for treatment of specified emergency medical conditions, and also establish an administrative system for persons to apply in advance for emergency Medicaid coverage. While we appreciate the intent of this bill, we do have several concerns. First is that federal regulations, particularly 42 CFR 442.255, provides that individuals who meet all of the Medicaid requirements, with the exception of immigration status, can be eligible only for limited medical services. And those are specifically limited to services that are required after the sudden onset of a medical condition manifesting itself with acute symptoms. And those symptoms would either place the patient's health in serious jeopardy, have serious impairment to bodily functions, or serious dysfunction of any bodily organ or part. So there are already a wide range of conditions that are covered under emergency Medicaid, but any services that fall outside of that federal definition would not be reimbursable, and the state would be required to cover all of those costs. What is actually also critical to understand here is that we have noticed, and we are also in conjunction with the Attorney General, we've noticed that there are several federal administrative policies related to the use of and sharing of Medicaid data, and those policies have recently changed, such as that all Medicaid services and corresponding detailed materials, information about individuals who are applying is being is subject to being shared with the federal government and with the Department of Homeland Security, and potentially other heretofore prohibited redisclosures with federal government agencies outside of the United States Department of Health and Human Services. So we do believe that the changes in this federal policy may discourage state residents from pursuing ongoing medical coverage, and therefore this proposed financial investment in the system may not result actually in increased access as previously envisioned. Moving on to Senate Bill 330, an act compensating spouses for state-funded care. This bill will require DSS to allow the spouses of participants on the state-funded Connecticut Home Care Program for Elders, often known as CHCPE, to be compensated as personal care assistants. So as we know, state-funded CHCPE provides personal care assistance services in several ways. It's either agency-directed, it's self-directed, in which the participant is actually the employer. This bill actually would result in significant increased costs to DSS associated with those members who would not otherwise access personal care but would do so by their spouse. While we acknowledge and we recognize that spouses do play a key role in ensuring that family members can live and participate in the community, this proposed expansion to reimburse spouses and other individuals can cost up to $31 million in state funding when fully annualized. In addition to that, this has been an issue we know has come up before, and some states have adopted it, but many states have not, because it does provide somewhat of a challenge around quality insurance. In Connecticut, a spouse is considered legally liable or legally responsible for their spouse. This means that they are responsible for decision making and regarding their care, and they're financially responsible. Allowing spouses to fill the decision-making role or the caretaking role may cause a conflict. And you just go back a little bit, that in overall, in all of our programs that have to do with care being provided to another person, there are some prohibitions in doing that with a person who is close to the person for whom the care is being provided. It's something that CMS calls conflict-free case management, and that's just an overall term that they use. And it really is to prevent a person who's close to someone from possibly engaging in behaviors that may feel the person who's getting the benefit or the services from feeling as if they're being coerced or exploited, because there is a possibility of that. We're not in any way suggesting, I really want to make this clear, that that is something that spouses would do or PCAs do. We're not suggesting that, but it is an overall rule that exists in CMS because there is a concern about that. And our position at DSS is consistent with the position at the Center for Medicare and Medicaid Services, and that persons in relationships such as spouses should not be paid as caregivers. And if they are, there should be significant safeguards put in place and only in extraordinary circumstances. Moving on to Senate Bill 331, and I'm almost finished, just to let you know. I apparently think this is my last bill that I'll be speaking to. It is an act concerning step therapy requirements for prescription drugs covered under the Medicaid program. So this will allow, in certain situations where the manufacturer and the FDA evidence-based guidelines exist, for us to use step therapy beyond the current 30-day limit. So here's, again, I will not read from this. I'll just try to explain this because it actually works for me. I wish I could just explain it. So a lot of drugs under our current statute have a 30-day window in which a provider or a prescriber can prescribe the drug to an individual, and they have 30 days to see whether or not the drug actually works for them statutorily. And if it doesn't, then statutorily, the provider then has to move the person to another drug. But it can take a lot longer for a person to adjust and to see how they may react to a drug or whether it's the right one for them. Sometimes you can know in a day, sometimes you might know on the 31st day. But statutorily now, the person is now required and that provider is now required to make that pivot. We would like more flexibility so that providers can actually practice medicine in a way that works for their patients. So what we're looking to do is to allow for the duration of therapy to be based on the manufacturer and the clinical guidelines rather than a static 30-day guideline that is statutory, so that people can have an opportunity to work with their own providers to determine what the right time period is for them to be on a particular medication before they just determine its efficacy. Finally, do believe that this will encourage the use of clinically appropriate treatment without the rigid timelines that actually may work against patient outcomes. It could improve client outcomes and ensure that patients get safe, effective, and evidence-based care rather than statutorily determined care. So we do urge passage of this legislation. So that does conclude my verbal testimony this morning. It does, Representative Case. We have submitted, I can go on, but I will not. Okay, we have written testimony on the remaining bills, and we welcome any questions you have. I do have many of the staff from DSS with me today to answer any questions you might have, and I do appreciate your time. So thank you.
Thank you, Commissioners. Good to see you and to see the entire Department of Social Services here. I'm worried that there could be a break-in over there and no one would notice. No, I actually do have one. I'll start with one perhaps unexpected critique, which is that your testimony wasn't long enough because there are two
Okay.
major, as I understand it, policy initiatives from the department slash the administration that ordinarily would have gone to Human Services, but instead went to another committee. And I'm specifically talking about Senate Bills 288 and 289, which
Okay.
govern the funding of Medicaid for nursing homes. And so, to the extent that this committee is going to be vetting a number of Medicaid proposals, it's very difficult to look at the administration's priorities and the governor's budget in full context with we don't have the full information in front of us. And so some of us also serve on the Appropriations Committee, and so we use this committee as the policy setting committee and that committee as the budgeting committee, but we don't have the policy justification for the budget information that we're going to be getting because for whatever reason this year it didn't come to us as it might otherwise ordinarily have. So I don't mean to call an audible and ask you to testify, but if you can give us this information, I think that would help us to do our jobs and to understand in full context, the budget that the governor has presented and the policies of the Department of Social Services.
So thank you for that, Senator. Are you referencing the bill that has to do with the changes in the way that nursing homes are paid? So moving to the PDPM, is that what you're referencing?
Yes, that and a number of
Okay.
other changes.
Okay. All right. Do you have specific questions about that? I do have Nicole Godburn here
Well,
with me.
well,
to
I was
review.
gonna start with that. I have a number of questions, but I don't have specific questions about that because I didn't want to ask you to testify
Understand.
without. Now, I also see on another area that there are a number of people who've signed up to testify regarding the governor's proposal to make changes to the Community First Choice Waiver Program.
Yeah.
And I also don't know if that's specifically in language in front of us or not. And I'm trying to be fair to you in the department. But we have, I think, quite a number of people who are testifying in opposition to that and concerned about what the governor's proposal could mean for them, for people with disabilities in the state, and the state's continuing commitment to to people with disabilities. And so I don't know. Again, I'm trying to. I'm trying not to. I don't like pulling surprises, but I do know that those folks are looking for an opportunity to testify and express their concerns, and would love to hear from you or from your entire team if any of them want to come up and explain what it is the governor is trying to do.
Sure. I will start. So what we're trying to do is to transition from the program that the waiver that the program is currently on, CHC, to a different waiver. And the reason that we're trying to do that is that we are deeply invested in individuals remaining in their homes and not moving to a nursing home level of care where that isn't necessary. And that's why this program is so essential. But the cost of the program and the enrollment has far exceeded any of the parameters that have been set when the program was established. And at its current rate, it will become fiscally unsustainable. And so the last thing that we want to see happen is for the program to go away completely. So we are looking for an opportunity to transition the program in a way that is thoughtful, that is planful, that takes in all of the input and feedback from those that are currently enrolled in the program, from advocates and other stakeholders, so that this can be done in a way that does not cause harm to people. So that, in a nutshell, is really where we are right now. We have heard that it's primarily cost driven, but the program has a significant number of challenges that we've tried to fix before. And some of those challenges include our work with our fiscal intermediary, making sure that our PCAs get paid in the ways that they should, making sure that our PCAs, I'm sorry, that our residents and our clients have an opportunity to self-direct in the manner that they see fit. But self-direction is somewhat challenging for some of those who are participating. So this transition allows us to really step back, take a closer and better look at the way that the program is run, to move it onto a waiver where we can better leverage federal dollars to manage the costs and still have an opportunity for people to participate in a way that is most beneficial to them. And I do have Christine Weston here that can give you more specifics about the waiver. I just didn't want to get into all of the.
Yes, I appreciate that,
Yeah.
and I would be happy to turn to her if you as you deem appropriate. I do have
Okay.
some sort of specific questions. So first of all, I understand that we've been having enormous challenges with the fiscal intermediary, and I know
Mhm.
that this committee has raised and will hear legislation sort of trying to give us some more tools to help ensure that that doesn't happen again. So that's going to be a conversation regardless of what happens about what we
Mhm.
can do to ensure that folks are paid and that the program is run appropriately. I totally agree with what you're saying about the challenges with self-directed care. My understanding is under the existing program, the department could, and we would have to fund it, provide case management to folks and or bring in um, other medical management services. And I was
Mhm.
wondering if that's something that the department or OPM, I guess we'll hear from OPM later, considered before proposing, ending the current program, because
Mhm.
that obviously has people concerned. I understand their concern. They're afraid that the state will walk back its commitment to people with disabilities. I hear that that's not what you're intending to do,
Yeah.
but that, when they see the program ending as opposed to bringing in case management, that to me seems, understandably concerning.
Right. Well, the thing is that the transition to the waiver, to the other waiver, will allow us to have more case management. Right now, case management can happen in the form of a support and planning coach. We have about 170 of those support and planning coaches that have been trained in a program in Tufts, and ideally, those individuals should be part of supporting people who have more challenges with self-direction. But having the people available and actually implementing those support and planning coaches has proven to be far more challenging than we had originally anticipated for a number of reasons. There are a number of people who are self-directed. Well, first of all, it comes out of the person's self-directed budget. I think that's the first thing that's important to know. So if a person wants someone to be their support and planning coach, that is part of that comes out of their budget, which means that they would have fewer dollars for actual direct care. So there are those that choose not to do that for those reasons. Second, that there has to be a very specific match between the person who is the support and planning coach and the person that's supporting them. In some instances, it seems like it would make sense that the PCA that's providing the most support would be that person, but that can't happen because of what I mentioned earlier about the conflict-free case management. That kind of relationship is it's strongly discouraged by the federal government. So that isn't something that we can necessarily do. So that now means, and this is something that has been raised by our friends at 1199, and so we would have to find a different way in order to make that program really work the way that it should. We are still committed to making sure that people have the support that they need in order to be able to self-direct in a way that works for them. But those are some of the challenges that we've faced before.
And are there obstacles? What we've gotten some testimony on today is that the DSS could bring in agency-based care under the existing waiver authority. That you don't have to change the program to do that. That you don't currently do that, but that you could do that. Do you agree with that assessment? Do you agree with that testimony? And again, I'm happy to ask you. You know your department in and out, but also if you want to pitch
Yeah.
anything to
I
Ms.
think,
Weston, you certainly can.
Christine, if you don't mind just joining me here, because Christine can speak. This is Christine Weston, who's the director of the program and all of our home and community-based services. I think she can speak more directly to that.
Hi, good morning, Senator Lesser, Rep. Gilchrist, and others. So agency-based would be an option under the model for community first choice. It actually had been proposed in previous legislations. However, we have systemic limitations in what's called our MMIS, our Medicaid Management Information System, that it would take 18 to 24 months to build that in. As well as we have some constraints on our MMIS limitations to absorb this new type of service. It's complicated and system driven. So we weren't able to kind of pursue agency-based under CFC. But again, that would inflate costs as well under CFC. And it doesn't really speak to the problem about the unsustainable growth of the program. It would actually exponentially grow the program potentially.
So I appreciate that. So if you were to limit the program, if that's the main purpose of moving it to a waiver is to limit the size of the program, doesn't that, I mean, the concern is folks got to go somewhere. So if they're not coming into the waiver, then are they going into nursing homes, and does that save us any money?
So I've heard this concern raised, Senator, and no, there is not an automatic path from CFC, sorry, to the nursing home. Everyone who is on the waiver in our current program are people who, for the most part, are avoiding nursing home level of care. And that would still be the way in which the program would work, is that people would avoid the nursing home level of care. If a person is in their home for a period of time, let's say over years, and then their health changes and they do have to then be directed to a nursing home, then that is exactly what would happen for that individual. But it's not an automatic path, and I've heard that before. So the waiver would give us an opportunity to, as we do now, but I think I don't know if I describe it, I think in a different manner, to assess the needs of all individuals who would come in. So it would, and I think this is what people are most concerned about, it would develop a somewhat of a wait list, which doesn't exist right now. And so our challenge here is to create a way in which that list will move so that people can be assessed quickly and not be on it for long periods of time, because I know that's one of the issues that was raised in appropriations. So no, it is not a direct path to a nursing home.
Well, again, we can have this conversation publicly, privately, et cetera. I think the
Sure.
concern is that if you create a wait list for people to receive needed services, folks are going to get the services they need one way or the other. So if someone who needs these services is not able to get the services through the wait list, then they're going to try to go through some other door, and that might be a nursing home door. I don't know that. Um, you know, I don't think anybody is on the Community First Choice program just for funsies. I think people go on because they need the service. And so if they're not, if they're in the wait list and they're not able to support themselves, then, and if they are able to support themselves, then they should probably not be they should not be in the queue. If they're not able to support themselves, then that's my concern, is that they may wind up, seeking, a nursing home level of care that is extremely expensive for the state, but also probably not their first choice about what they would prefer.
Well, and Senator, I think that's one of the reasons why when you first broached the subject, I said that these decisions are not unilateral to DSS, right? That there's a commitment on our part with OPM and with DDS to make sure that we do this in concert with all of the stakeholders and parties that would be affected, because we're hearing the concerns very clearly and we appreciate them. But as I said during my testimony in appropriations, I am also deeply concerned about the fiscal sustainability of the program, because if it ceases to exist in any form, then we are talking about alternative care that is really undesirable for people who really wish to stay in their homes. It's a difficult balance to strike. There is no question about that. But that's why I think that we'd have to do it thoughtfully and carefully. It's being proposed in the governor's budget. The work continues to make sure that it's done in the way that makes sure that people have what it is that they need. But if we continue on the path that we are on without making some sort of change or adjustment to its current enrollment, then we're facing a different circumstance.
Okay, well, I appreciate your testimony. I think we will continue to have some more conversations about it. I have, excuse me, Representative, I'm not done, sir. So I haven't even gotten to the commissioner's testimony today, so we will certainly get to you though. Moving, I appreciate your proposals on Saga and on the retroviral drug initiative. Just with respect to the antiretrovirals, I believe I know the answer to this, but that the change here will not in any way limit someone with HIV/AIDS getting access to the drugs that they are told that they need.
No, it will not.
Okay. Um, with respect to MedConnect and the proposed elimination of the expansion that was in statute, my understanding is that MedConnect premiums above a certain level are supposed to be under existing law set on a sliding scale based on well, they're supposed to cover the cost. So there should under the federal Ticket to Work program, there should not be a cost to the state because the premium is supposed to be set based on cost. So I'm confused as to why there is a projected cost to the state and how that was determined.
Yeah, I don't know if I'm the best person to answer that question. I'm not sure if anyone here can. Yes, there you go. Okay. DC Hadler's gonna try. Yeah,
Good morning, Peter Hadler, Deputy Commissioner at Department of Social Services. Thank you, Senator Lester, for that question. So there is a premium component to MedConnect. Over a certain income threshold, individuals are asked to pay a premium. It is somewhat of a sliding scale, but it's capped. It's based on a maximum of 10% of income is the highest possible premium that someone might need to pay into it.
Okay, thank you. And does that cover the cost?
I've got to go back and check what the projections are for the costs per month versus the income, because we have obviously changed the income limit. We've raised it. This first step in the previously passed bill did elevate the income thresholds, and so I think you need to go back and check and see what the premium comparison is for someone who has to pay the full 10% of their income versus this new higher limit, and whether that in fact will cover the costs or not.
And does the fiscal note that the commissioner cited, does that take into account the premiums that are paid?
Yes, it does.
Okay. My understanding is that other states that have done similar actions have not experienced costs. So that's why it's surprising. I understand the initial part, there was a point where people were below that threshold, but now that we've raised it past the income eligibility, the assets past that initial threshold, our expectation had been that the premiums would cover the cost. So that's why it's surprising to continue to see a fiscal note claim.
I will also just note that I believe that fiscal note includes the possibility and the likelihood that some people who hadn't previously been enrolled in the program would come on. So it does factor in some program growth. So to the extent that you have new enrollees in a program, that will add costs.
So in the governor's state of the state address, he did talk about emergency Medicaid as something that was a point of pride for the administration in ensuring that people are able to get needed medical care. So it's surprising to see that his budget proposes to roll back the funded expansion of emergency Medicaid, and just wanted to get some more clarity as to what the thoughts are there and what the specific concern is about proposed expansion.
our primary concern about the expansion is that it's in contravention to the federal definition of emergency Medicaid, and that in order to expand it, there would be a specific cost associated. We're not even particularly sure that, go ahead, right, that the federal government would even approve the expansion in the way that it's defined, because it is very specifically prescribed. That's the concern. So I think I can't speak for the governor, and obviously I was there for the state of the state, but I think we're talking really about the preservation of emergency Medicaid and not rolling back or stepping away from it, as opposed to its expansion that would, as I mentioned before, would actually be in contravention of federal law. DC Heller, was there anything you wanted to add to that?
Yeah, I would just, I think that you're correct, and to the extent, right, that any particular description of something that should be covered under the new proposed definition of emergency Medicaid was not accepted by the federal government, it would leave the state fully on the hook for the costs of all of those services, some of which could be very expensive. And I also just want to note that I believe that the funding was intended to help do some system work to help facilitate ongoing access for people to be able to enroll in emergency Medicaid. We have, based on the changes that have occurred at the federal level and through litigation that has gone on for the past year, we currently are not recommending that that activity take place and that emergency Medicaid continue to be limited to a retroactive payment for services delivered, often in the hospital setting, and under the parameters that we apply for emergency Medicaid broadly. We have an independent vendor who provides services and reviews those cases to ensure that any services that are being requested to be covered by emergency Medicaid do meet that federal definition. So it is flexible to the extent that we are still continuously interpreting that as and applying it to each individual situation to ensure that emergency Medicaid can be used to cover services in that structure.
So Senator Looney, who had brought the proposal before us, had documented a number of other states that had come up with this idea of, one, making sure that we were using a maximum definition of the services, the conditions that could be covered by emergency Medicaid, but also creating a more or less burdensome, more streamlined way of applying and perhaps finding out whether or not a service will be covered. And so my understanding is that those states are still receiving emergency Medicaid, but you think that there's some sort of federal approval that needs to happen in advance, or some sort of waiver authority or something? It's what I, or you're just saying you're just concerned that some federal action in the future will disallow that. I didn't know if you had specific clarity on what other states were doing and how Connecticut's program might be different.
So I'll start and I'll ask DC Heller to weigh in. I'm not sure when those states actually received that approvals, then that might be a factor that we'd have to consider. But in our current environment, we do not anticipate that anything outside of what's specifically defined in the federal regulations would be approved.
Okay. With respect to the residential care home funding, we've been concerned about rebasing for a number of years, and I understand your testimony in opposition to that proposal. Do you have advice for us or suggestions about how best to work with the RCHs on proposed rebasing?
We do. So we are opposed to the bill in its current form, but absolutely open to continuing to have conversations with the RCHs. There is a specific way in which we'd like to see the rebasing work. We'd like to have some communication with them, particularly around the rate moving from $3.10 to $5 to understand, to give us an opportunity to do some data analysis to understand what their needs are. So we're not opposed to actually having any kind of engagement and discussion, maybe coming back with a mutually agreeable proposal. It's just this particular one that is challenging at the moment. And none of the money for this one is actually in the governor's budget. But we could leave here today and start the conversation with our CHs about how we get to yes.
Hope that was someone heard that. So, okay. No, that sounds great. Then with respect to this is another perennial that we've had, but we've been sort of thinking about is for the state funded home care program for elders, the spousal caregiver. And I think I understand the department's concerns, but to me, I don't know that a spouse is categorically different from a son or a daughter or some other familial caregiver. Is there a clear difference between them in this case? If they're the concern about I don't know, conflicts of interest?
Yeah, so a spouse in, at least in our state, has that label of legal liability, of being legally liable for for the decisions that are made on behalf of the person that they're caring for their spouse. And that is why some states have really either not adopted this or adopted it under extraordinary circumstances, as we noted. We are leaning on the side of conservatism here. That is what we are doing, because we just want to make sure that those that are providing the care and those that are receiving the care are not in relationships that might compromise their relationship as caregiver and a person that is receiving care.
Okay. But I think other states have found a way to do this. Is that, you think that that's still a bad policy, even though they've done that, or it violates the federal
Well,
norms?
I can't speak to, to other states and really the, I guess, the relative good or bad of their policies. They are developing policies, I think, that are appropriate for their state and for their constituents. But in our instance, right now where we stand is that we don't believe this is a good policy. And so we're standing in opposition to this particular bill.
I've taken up an awful lot of the committee's time. I have lots of additional questions, including a whole bunch of heating oil questions, but I'm going to let my
Yes.
colleagues go, and we'll see
You
if those
safe
get
to
asked.
stay for those.
Okay, yeah. Oh, I suspect you were ready for that. So with that, I will turn it over to my good co-chair, Representative. Oh, no. Wow. I will turn it over to Representative Case, and then we'll go from there. I think we're.
Thank you. Good morning.
Good morning.
Lots of things talked about. A few questions. I'll go one by one real quickly. So ICF, we did something this past week. You mentioned that this is going to the providers. I asked on the House floor if this was going to the workers. Is this going to the workers? Is this going to the providers?
It's going to providers.
So it is going to administrative staff and also others. I was specifically told it was for the workers on the ground
By whom?
in session when I asked the question.
Okay, all right. The increases are for providers.
So it goes directly to the providers.
It goes to, it goes to
no-
providers. I'm sorry.
There's no concrete way that it's just going to go to the workers.
I will go back and check that for you. But my understanding is that the increase is going to the providers because they haven't had an increase. Maybe I'm confusing it with CLAs, but it hasn't, but those costs have not increased in 10 years. So that means that we sell providers that are trying to purchase food and make repairs and pay for utility and heating and on all of these costs that have gone up exponentially in the 10-year period. And you know, this representative Case, even when I was running an organization that had group homes, even then the cost of that we would receive in reimbursement wasn't enough to be able to maintain the homes without significant fundraising and other ways that you could find to make sure that people lived in homes that were kept in good repair and were heated and had everything that they need. So that's what these dollars are for, is to make sure that those organizations are using those resources to make sure that people are living well in the ICS and the CLAs. But no, it's supposed to cover costs like food, room and board, resident supports, again, haven't had rebasing in 10 years. I am not aware of those dollars going directly to workers, but I can double check on that for you.
Okay, so it can go for administrative salaries?
That's not necessarily what we're intending it for.
Okay, no, I was just questioning
Okay.
because the workers are the ones right now who need
Okay.
the boost, and that's what I asked on the House floor, and I was told it was going directly to the workers.
Okay, I will find out exactly where it's going. Okay.
Okay, real quick, any non-emergency medical transportation? We're back to
Yes.
the F endorsement.
Yes,
We have plenty of meetings in the back about the F endorsement.
yes.
What are you suggesting through this? I know, I understand it wholeheartedly. The
Yes.
non-emergency medical transportation company has the liability. They have to do the background checks.
We do.
Are we moving forward? Are you saying that we can go forward with the F endorsement because it does have a background check with DMV? This has been going on for years.
It has been, and I do appreciate that.
The F has a different word right now.
My concern about the F endorsement is that it will shrink the pool of available drivers. That is my concern about it. And I, at this point, having, they will tell you, I don't know if they're in the room or not, but I meet with our NEMT provider regularly, like every other week. Sometimes it's once a month because I'm traveling, but they are here very, very frequently and keeping track of the complaints and the safety concerns and everything else that they are doing. So what I'd like to be able to do is to continue to rely on the extensive background checks that they have been engaging in. And if we cannot find a way for the F endorsement to not shrink the pool of drivers, because accessibility really is our key goal here, obviously equal to safety. So that is where I'm standing right now.
And I agree with you. And I try to talk to people within this building about it. And the bottom line is the non-emergency medical transportation company has the liability for the people that they're taking.
They do.
Whether it's a different endorsement or something. they're the ones that have to answer
Right.
because they have to fund the cars that are on the road. I don't know how we get there, how we put more smaller groups out there to try to help with the transportation, but that's my understanding of it is they are the drop off for liability.
Correct.
And that's what we need to work on.
That's
Okay,
right.
two other things. The state funded spouse, I think this is parting off a little bit about DDS does with the IDD community. They allow for family members to take care of their loved ones within the home. I think that's what people are looking for in this.
Okay.
That was something that was done during COVID, and then DDS decided to move forward with it, and the federal government accepted it. Is that sort of the same scope that we're looking here because we want to keep people within the home and we want them, but when you're on a DDS side, there are checks and balances that have to be done with that home care provider of the family. They're checked on regularly. They're not just one that's given a check at the end of the week
Correct.
and they're not checked on. Is that,
That is part of the concerns that we don't have the infrastructure to manage it the way that DDS is managing it. We
and
don't.
DDS is a much smaller pool
Yes.
because they have a little bit of a more concentrated area. And I guess it was difficult for them to do in the beginning.
Correct.
But we didn't have the real programs for people to go during COVID of special needs, so we allowed it there, and we're
Right.
just carrying on from that. It's been working in that population. I don't know how we get it here, and that is because the IDD population are Title 19, so they are state funded. Here,
Right.
this is just state funded for the spouses to take care of their loved ones at home. It's just a different pot of money that's coming forward, and we don't have the oversight. Is that all what I'm hearing?
We don't have the money and we don't have the oversight. That is correct.
I don't think it is a savings, I believe, but then the oversight is a cost.
It is.
And that's what we have to work on.
That's right.
Because you can't just let this happen, have the funds go to the family or the spouse. You have to have oversight to make sure things are being done on a regulated
We
plan.
do.
Okay, I
Correct.
get that. LIHEAP.
Yes.
So we're talking about regional pricing, we're talking about same day pricing. Right now, we're in a real difficult spot, which will happen throughout when different things happen. One price on Friday is the same price on Monday, but over the weekend, it rose anywhere from 8 to 10 cents, and today it's up over 30 cents. On the oil side, on the propane side, it's up over 5 cents, but you're
Mhm.
still on Friday's pricing.
Mhm.
And we're delivering fuel at a increased price because of things that are happening in the market.
Right.
How do you expect somebody to pick up fuel today and pay for Friday's price when you haven't changed the price today?
DC.
Thank you, Representative Case.
Yes.
So as you know, we went through this process and this discussion fairly extensively during our work group where we landed on the two new options for oil vendor reimbursement approaches, which we're hoping to just memorialize here with this change to the statute. That is a very real challenge. It is, we look at this from sort of two lenses, both which is the fairest thing that we can do for everyone who's participating in the program, as well as what's administratively feasible. And so, over time, these things balance out because there are days when the price drops as well. And if you are coming in with a higher rate from the Friday and then you're picking up the lower rate on a Monday, these things tend to balance out over the course of the year. We looked at this very carefully, putting aside the administrative burdens and difficulties of trying to figure out how to calculate an amount for people to be able to deliver based on a price that we don't even know yet because the rack average data hasn't come into the agency. And we found that actually utilizing the day of pricing when we looked at a full year would have resulted in lower vendor reimbursement. So I do think that this process does work out over time, but there are exceptions where it's particularly challenging, like we're experiencing this weekend when something extraordinarily unforeseen by most of us, a major change to in the Middle East about that is driving a spike in oil prices. So we're looking very closely at what our options are within the program structure to be able to account for this sort of short-term extreme volatility, recognizing that right now it is all going up as opposed to going down. Though, again, these things have balanced out in the past, even when we go back to look at Russia's invasion of Ukraine, where we saw a similar extreme volatility. Things did average out over the course of the heating season. So we are looking at what we can do because we recognize that this is very challenging for those vendors that pick up day of and do delivery. We also recognize that there are other vendors who have long-term contracts or the ability to store their own fuel who are insulated for some of these changes. But we do want to make sure that we're not leaving people in a situation where you know the short-term losses are very significant, and they can be, right, if the price jumps 30 cents in a day. We get that. So we're looking to see what we can do. I don't think that the solution to that is to not implement the changes in the statute that memorialize the normal, typical approach that we want to be able to consistently apply, which we have for many, many years, and which for other states that do margin over rack currently utilize as well.
So in your testimony, the commissioner specifically mentioned rack. In your definition, what is rack pricing?
I do not have a definition of rack pricing because I do not have that clear of an understanding of margin over rack, which is why FTC has her here. So, yes.
Thank you,
Thank you.
Commissioner and Representative Case. So the current way that our margin over rack program is structured is that we utilize the pricing at racks or terminals in 4 locations around the state, which is the most detailed level of information that we're able to obtain on a consistent basis from an oil information provider. So we get that information daily about the average price for each of 4 terminals around the state. That allows us to have a better geographical spread and coverage to reflect regional wholesale prices compared to the prior program that we had, where it was solely based on New Haven terminal price. So rack and terminal, I'm using those 2 terms interchangeably, though I understand that there may be a nuance based on the size of a particular location for the wholesale pickup that you could use one or the other.
Okay, so rack is going off regional, which is different places throughout the state. Everybody, the company can have their own rack. I was just curious what your definition of the rack was, because everybody goes off of, New Haven Harbor or Mount Bellevue or Selkirk pricing. There's different racks throughout the region, the corridor over here. And how are we doing with paying vendors? A lot of questions have come to me on this, especially
Sure.
with the bounce check to Eversource from a
Yeah.
nonprofit and how
Yeah.
they're supposed to be paid in 3 days. The oil theirs are paid in 10 days, but they're
Yeah.
not getting their money in 10 days, from what I
Right.
understand.
Okay. That I have not had that report recently. So when there was, yeah, let me just say that. I've not heard that report recently. When we first ran into the challenges with one particular community action agency, there was definitely delay, but I was in very frequent communication with SEMA in particular, and not individual oil vendors, but definitely with SEMA to explain what the circumstances were and to explain what interventions we were taking, which included our own staff going to that particular CAA and overseeing the payment of those vendors directly, giving them the opportunity to either pick up their payments directly at the CAA location or having them mailed to them. And we have been constantly doing that to make sure that vendors are getting paid. We are sending our own team. There's a fiscal intermediary that is there. There is an interim CEO that's also in place. We also have a consultant that is in place that used to run a community action agency, so has direct experience in this space and also ran their own LIHEAP program when they were the leader of that agency, so that we have more than significant and sufficient oversight of the program. If they're not getting paid within 10 days, that is not something that I've heard of immediately, but we can certainly, if they're particular vendors, they should bring that to our attention.
Thank you. And the unfortunate circumstance of that one nonprofit is frustrating, but I think that's oversight that we have to look at on the state level, because we don't get 990s till a year after the year is up. So when a circumstance like this, if something bounces to a utility, we get notified right away. I thank you for your answers on that, because these providers for heating oil are mostly small businesses throughout our state, ones that try to want to help others, and they don't have the big checkbooks as large companies do. So it's very important that we don't put pressure on them to have to get lines of credit to make sure they can pay their employees, because they are the small businesses, the backbone of the state of Connecticut. I thank you for looking into it and watching over this, because we want to make it right. I think we've talked about
We
this
do.
for many years, and we're under some strange circumstances currently, but there's got to be a better way to get same day pricing. You all know I'm in the business. I get same day pricing 3 times a day right now because the market's changing 3 times a day. So it's just unfortunate that we don't have the abilities to do that with the amount of gallons that we deliver and the dollars that we spend. We'll talk about it at another time, but I'm curious to see where we are with LIHEAP because of the type of winter we had. Are we keeping people fueled? I haven't seen any reports on that, so I'm assuming we haven't gone short yet, but
No.
okay, so we're good with that because
Yes,
some
we
people
are.
say we're not, but I think we are because we did get some
Yeah.
increases this past year. And I think that, you know, a lot of oversight on the program has helped to make sure that we're getting the money to where it needs to go.
Yeah.
I think that's all I have for right now. I know, Commissioner, you're always accessible, so I thank you and thank your team because
Thank you.
these are the most vulnerable people. And there's a lot of nursing home things out there and other things that we can talk about. But thank you. Thank you, Mr. Chair.
Thank you, Representative. I believe I'm gonna go to Representative Gilchrist quickly, and then we'll go to you. Sorry. I know you've been waiting patiently. Sorry about that. Representative Gilchrist.
Thank you. So good to see you, Commissioner,
morning.
and the whole team. My question has to do with House Bill 5358. This is speaking to the rebasing of the CLAs and the ICF, all these initials.
Yes.
The concern or question has to do with, it seems as though the intent is to more regularly rebase, but in the past with rebasing, we haven't kept up with it. And so
That's right.
the language does say within available appropriations. So are we fixing this in the budget process as well so that we'll have the available appropriations? Just trying to understand if this is actually going to help or hurt going forward.
It will help because it will do two things. It will make sure that there's a regular cadence for the review of the rates, which is something that we do not have now, which is why a decade can go by before any review of rates and their sufficiency can be conducted. But and Nicole, I don't want to misspeak, but I think we did just give the CLAs a pretty significant bump. Yes, we just did. Yes, with resources that were made available. So that was within available appropriations. I think they were happy. I haven't heard otherwise, but again, this is the beginning part of making sure that our CLAs and our ICFs have a regular review and that there's an opportunity for them to be heard and where there are resources so we can make adjustments accordingly.
And so that's good news that it'll now happen every 2 years. Who will see that rebasing review? Because then will it come? I mean, there might be years where the governor's budget wouldn't include, right, the money. And so will the legislature see that rebasing review?
That's not specific in our statute, so I don't know if we've necessarily had a process for making sure that the review has different kinds of eyes on. Obviously, our partners at OPM would see the review. That would be one place where it would be seen. I'm not necessarily sure if there's any other place where it would be visible. I think that's what you're asking. But
Yeah.
I think in terms of accountability as to whether the review has actually occurred, that would be statutorily determined and if this bill were to pass, which is one of the reasons that we're in support of the legislation.
Okay.
Okay.
Okay. Thank you very much.
Thank you, Representative. And the most patient member of this committee, Representative Pizzuto, who has been anxiously waiting for his turn.
Yes.
Sorry for the many false starts, sir. The floor is yours.
Thank you, Mr. Chairman. A lot of the questions, it was worth the wait. I got a lot of great answers. I wanted to thank the commissioner and her staff for the comprehensive answers that you give and the hard work that you put in every day. My quick question that was not answered was HB 5358. It was simply, you had mentioned about direct care for staff nursing and an increase in pay. My question, commissioners, does that include only registered nurses or there's certified nursing assistants, patient care technicians, and so forth?
Oh, I'm sorry.
Sure.
It said
Yeah, take your time.
5358, but I think it's a different bill. That is the one that, section 5 of, just want to make sure I'm reading from the right one.
Sure.
Of 5040. So in what I have in
Oh.
front of me is section 5 of 5040 that gives increases to nursing home facility rates to include for wage increases. Am I not?
Yeah, and you had mentioned registered or nursing.
Yes. So
Does that apply across the board? Because most of the time, the registered nurses are in short supply. and not necessarily providing the bedside care.
Yes, this is specifically for increases for nurses that provide direct care.
Registered
For
nurses?
nurses.
It
yes,
is.
Yes.
Okay, so we may want to expand that to look at the rest of the staff, but thank you very much. Appreciate it. Thank you, Mr. Chairman.
That's it? Okay.
You guys covered everything else. It was great.
Okay.
Thank you.
Okay.
If I'd known you were gonna be so quick, I would have gone to you hours ago.
Okay.
Representative Comey, followed by Representative Kidd online.
Senator Lesser, if you don't mind.
Yeah, go ahead.
I just wanted to return to your question, Representative Pizzuto, because there are other positions that are listed in the statute that Deputy Commissioner Hadley brought to my attention. So it's registered nurses, certified nurse aides, support workers such as housekeeping, laundry, maintenance worker will directly benefit from those investments and increases in their wages and benefits. So I did overlook that. So thank you, DC Hadley, for pointing that out.
I appreciate the clarification, and I'm glad it does cover that.
Yeah.
And Mr. Chairman, just
Right.
running
Thank you
between
for that.
3 meetings with all of us, so
Okay.
I appreciate it. Thank you.
Thank you, Senator, for allowing me to address it again.
Thank you. Representative Comey, followed by Representative Kidd.
Thank you. Thank you very much, Mr. Chair. The Governor's Bill 5040, Section 1 of the bill. So it sounds like it's a good thing. It's a good move in a good direction. But how many, I would ask how many Connecticut residents would this be impacting?
Do we have
Or how
that?
much do we know the cost that it's currently costing to
Yeah.
expand it?
I believe that we anticipate there's about 60 people at any
It's
given
not
point in time and month that would be impacted by this, who currently receive the lower level of reimbursement. And most of them, as the commissioner referenced in her testimony, ultimately do qualify for the higher level and retroactively. The problem, of course, is when it's retroactive, they haven't received the funds when they most urgently need it. It's good. They do eventually get the funds, but we're proposing to sort of eliminate that waiting period for folks who are in pretty urgent circumstances to allow them to get the amount that they almost always qualify for. So the net total cost of this is fairly low.
Great. And is there any federal implication of this change or, okay,
It's a state program.
okay, completely, yeah. Okay, thank you so much. That's it.
Thank you, Representative Kidd.
Yes, thank you. I have 3 questions, comments. The first on Senate Bill 331, and step therapy. Step therapy's been a bugaboo of mine for a while there. Would Medicaid clients or someone who's newly accepted to Medicaid, if they were being maintained on one of these drugs, would they be required to go through the whole step therapy process? Meaning if they were on a more expensive, more intense form of a drug, would they be forced to go back and start over
You mean prior to?
prior to
having-
being on Medicaid?
Prior to being on Medicaid? I'm not sure of the answer to that, so let me find that out for you. We often would like people to have continuation in their cares, so I don't know if we necessarily make them start all over again. But Dr. Terranova, yeah, so our medical director will answer that question for you.
Good morning, Dr. Jody Terranova. Representative Kitt, we would follow the doctor's letter of medical necessity for patients that would want continuation. So if someone's new to Medicaid and has been shown to be stable on something, we would not ask them to step back and try something else. We want to make sure that patients have access to medications that have been shown to be working for them. So I don't think that should be a concern.
Okay, thank you. I know we did pass legislation regarding mental health drugs, multiple sclerosis, and I think there was one more. Just being very specific that they would not be made to switch. The second one was 330, Senate Bill 330. I know we've had a lot of comments on it. I would just say I think it would be beneficial to the state if we pursue ways to develop guardrails to make sure that spouses can continue to provide care in home. I understand the concerns, but I think there is room for us to move forward towards that goal of keeping folks in their home. And that was just a general comment. And then my last one was with the governor's bill concerning the Community First Choice program. Will people who are already in it be grandfathered, or is there a risk of them being moved to a wait list? I'm thinking of one family in particular, constituent who was trying to get onto the Katie Beckett waiver and it just sat there for years, and they're finally in the Community First Choice program, and they don't want to be seen put back in line to maybe get back into a waiver program. I have very big concerns about creating another intolerable wait list if we do this.
I
So
understand.
that's mine. I will hear any comments or
So our intent is that everyone who is enrolled in the program right now will stay in the program as enrolled.
okay, thank you. And that does it for me, Mr. Chair.
Thank you, Representative. Other questions or comments from members of the committee? If not, you're off easy, Commissioner. Only an hour and 12 minutes. Thank you so much. Good to see you again, and thank you to your team at DSS. What's that? Yeah, we're gonna have tumbleweeds flying through here momentarily. So our first hour has elapsed. So in the first hour, we reserve for public officials. After the first hour, we alternate between public officials and members of the public until we run out of public officials. So our first, now we have a group of folks who do need special accommodations. I don't think they are yet here. I'm sorry? Oh, okay. Okay, so we do have online, we've got Suzanne Garaffa. Suzanne, you are next. Following Suzanne, we will go to Kathleen Holt if she's available. Otherwise, we do have a couple of folks who do have tight timeframes that we are going to try to accommodate if they appear. So our current plan is to go to Suzanne and then Kathleen, but we may have to alternate that. Suzanne, you're up.
Hi, my name is Suzanne Graff, and I'm gonna have Ruth Globey read my testimony.
Good morning, Senator Lesser, Representative Gilchrist, and members of the Human Services Committee. My name is Suzanne Garaffa from West Hartford, and I want to thank you for the opportunity to provide testimony. I would like to speak today on two issues, Senate Bill 326 concerning Husky C asset limits and HB 5040 to implement the governor's budget recommendations. As the result of developments at the federal level, Connecticut's residents with disabilities are experiencing a great deal of stress and struggle. SB 326 makes the situation a little better, and HB 5040 makes it infinitely worse than I ever thought it could get. SB 326 is a start at ending the discriminatory rules for Husky C eligibility, but it doesn't address the impossibly low income levels. Non-disabled adults qualify for Medicaid under Husky A and D at a much higher income limit than the people with disabilities under Husky C. Please amend SB 326 to address this inequity. And now on to HB 5040. I have been fighting for the rights of people with disabilities like myself for many years, and I have never been as devastated as I am by the governor's proposal to end the Community First Choice program, especially since the suggested alternatives are vague and unfunded at best, with most of the current waiver programs having years-long waiting lists, which I believe is a major reason that Community First Choice was created in the first place. I am afraid that people like me will die before they get the services they need. The governor has made a vague and unfunded commitment that the state will take care of the people who are presently enrolled in Community First Choice. But what about the people who will need it in the future? One of my closest friends is currently in a nursing home because he had a number of complications from his disability that made him have to give up his apartment in the community. He is now better and ready to apply for Money Follows the Person in order to come back into the community. If the governor's proposal is enacted, he will be stuck in the nursing home. Nursing home care is not a good alternative to living with supports in the community. My friend's experience has clearly shown that nursing homes are presently understaffed and struggling to provide needed services. How much worse will it be when there is no longer CFC as an alternative? Since the passage of the ADA, our country has been working on helping people with disabilities to integrate into the community and to be seen and heard by their fellow Americans. Connecticut's official long-term care plan calls for increasing, not decreasing, the percentage of people receiving services outside of institutions. Eliminating community first choice flies in the face of that important goal and will
Can you
send
please-
us further
Can you
backward.
please summarize?
Yes, thank you very much.
Thank you very much. Thank you so much for being here and for your testimony. Any questions? Not seeing any. Thank you so much for your testimony.
Thank you.
Next, we will go to Kathleen Holt.
Hello, Senator Lesser, Representative Gilchrist, Senator Perillo, and Representative Case, and members of the Human Services Committee. For the record, I am Kathleen Holt, healthcare advocate for the state of Connecticut. I appreciate the opportunity. I will focus today on our support from the Office of the Healthcare Advocate for Senate Bill 326, which is an act concerning Husky-C asset limits. We are supportive of this bill and of other initiatives to raise and remove asset limits that impact eligibility for certain public benefits, especially health benefits for the aging and disabled. Asset limits create unnecessary barriers for individuals who may rely on their savings or other resources in order to meet their living expenses, particularly during high periods of inflation or other unusual circumstances. The inevitability that higher cost events and emergencies will occur and financially burden beneficiaries beyond the unfortunately low asset limit creates additional health harming physical and mental health stress on Husky-C beneficiaries. Such limits also unfairly discriminate against the aging and disabled relative to beneficiaries of other Medicaid programs like Husky A, B, and D, which have no asset limits to determine eligibility. This unequal treatment deprives potential Husky-C beneficiaries of the ability to accumulate savings or other resources that can enable them to withstand periods of financial hardship. Instead, program participants are put in the position of having to spend down assets that they may have spent years saving just to maintain a very modest standard of living. Expanding access to Husky-C need not automatically result in an increase to Medicaid program costs. In conjunction with removing the burden of asset tests from Husky-C eligibility, the Office of the Healthcare Advocate also urges the state to explore savings that would be achieved by encouraging more Husky-C beneficiaries to enroll in the traditional Medicare program, under which providers typically determine medically necessary care, not insurers, and denials of necessary health care are not aggressively pursued, as we see at the Office of the Healthcare Advocate. Private Medicare Advantage plans, particularly the dual special needs plans, are known to engage in tactics that result in significant cost shifting. And these cost shifts go to Medicaid, which should be the payer of last resort. Without this cost shifting by private Medicare plans, more services may be covered by Medicare, thus saving Medicaid money. And just as a context, approximately 20% of Connecticut hospital discharges are from Husky-C beneficiaries. And we know that hospitals may be paid as much as 8% more by traditional Medicare. So these are some of the cost savings and efficiencies to be gained. Thank you for your consideration of my testimony. And if you have any questions, I'm happy to take them.
Great. Thank you so much. Representative Hughes has a question. Go right ahead.
Thank you, Madam Chair, and thank you so much for Kathleen for your work in the Office of Healthcare Advocate. You touched on so many things, especially the complex payment of especially in the Medicare Advantage versus the Medicare plans. But in terms of eliminating the assets over time for Husky-C, I wonder if you can talk to us just a brief minute about the anxiety that Husky C members have continually trying not to lose their coverage and what that stress puts on an already compromised Husky C member with a disability.
Yeah, thank you for that question. What we see at the Office of the Healthcare Advocate are, we get about 30 calls a day from consumers, and many of those are Husky C beneficiaries who, share their stories with us, which could be anything from, I have my sidewalk needs to be repaired. I have to put a new roof on my house. I have to, the current level of assets at $1,600 is in inflationary time is so constraining to people that they really have to depend on their neighbors, their family, other participants in the community to help them to stay in the community and to not have that level of stress. But as it is right now, there's an enormous amount of stress that happens for individuals who are under these asset limits.
Thank you. And can you also speak to, I know when you came before the MAPOC committee, you talked about how many of these folks go into hospitalizations when they are not adequately supported in the community, and how maybe eliminating the Husky C asset and income limits could help support reducing hospitalizations, which are obviously very costly for the state, for everyone.
Right. So that is the result, as I was saying, of the healthcare and the stress that happens to individuals who are put under the pressures of these asset limits. They fear having to leave their homes or to go into the community, and at which point they experience cardiac issues. This is some of the things that we see at the Office of the Healthcare Advocate, and they leave their healthcare to the point where then they are of a need to go to the emergency room and to be admitted for extra care. So we don't have any pure statistics on what would happen if the asset limit is increased, but we could certainly follow that data to see, and particularly as this is a staged 5-year rollout of the increase in the asset limits, to see how that the impact actually works.
Thank you. And I'm sorry, just one final thing. The pushback we get from OFA is this would be so costly. What do you think about this phase, over several years, phase out of asset limits? What's your response to OFA's cost estimate?
So I think it's been proven that, and it was just mentioned actually, that oversight is a cost. So making sure that everybody needs, these asset limits are adhered to at the low level that they currently are at $1,600 and $2,400 for a couple. That's a lot of oversight. And if we can eliminate the cost of that oversight by increasing the asset limit and hopefully getting to the point where there's no need for oversight because it has reached the point where there is no asset limit. But in the meantime, each year as we increase, it allows us to see how many new people will come onto the program, who will qualify for the program, and what good that does to the community, and how that releases other valves in the community that are currently costing a great deal of money. So there's a lot to be said for this incremental change.
Thank you, Madam Chair. That's really helpful, the valve release concept. And I have no other questions. Thank you.
Thank you very much, Representative. I don't see any other hands. Thank you so much for your testimony and your time today.
Thank you.
Next is Sarah Hinman with us. Not yet. Sandra Roberts. Not yet. Oh, yes? Okay. But I do see Maureen A. Go right ahead. You just have to unmute, Maureen.
Sorry, thank you so much, Senator Lesser, Representative Gilchrist, Representative Case, and esteemed committee members. My name is Maureen Amiro. I am with Connecticut Adapt and Save CFC. I'm a wheelchair user with muscular dystrophy. I'm speaking in support of Senate Bill 326. I think it's a no-brainer. Disabled individuals are the only group of Medicaid recipients with asset limits. I do, however, believe that they should be removed immediately and not over a span of 4 years. Moreover, we need to remove the discrimination against the disabled community. I am not on Husky C because of the strict income limits, and I struggle to pay for my personal care attendant, my PCA, because my SSDI exceeds the asset limits, but I do not receive enough to cover for out-of-pocket costs for a caregiver. So I have to settle for a lower level of care than what I need, and it only gets worse as my disability progresses. And without adequate care, I risk going into a nursing home. Currently, Husky A and D limits are $400 more than Husky C, if I'm correct about that. It does make a big difference. I'm asking you to remove the incremental wait period for the removal of asset limits and amend the bill to raise the income limits to that of Huskies A and D. $439 is not just a disparity, it is discrimination. And speaking of discrimination, I'd like to turn your attention to our governor's proposal to cut funding for Community First Choice, which provides access to self-directed PCA care and other assistance, which allows members to live in the community as independently as possible without adequate care they face going into a nursing home too. And over 7,200 people are affected. Connecticut has worked so hard to bring these people out of the community into homes, and now they're facing being re-institutionalized. I've spoken to some people who are on the program and they are panicked, they're overwhelmed. I suspect a lot of people know that this is happening, and I'm alarmed at the response to our concerns. The details are so vague regarding how CFC members will be placed on current waiver programs. What happens to the people who are already on the very long waiting list, and what's being done to reduce the wait? What happens to the people who are deemed too expensive or too complicated for a waiver program? What happens to the new people? The math really isn't mathing, and it seems to me that there is direct route and indirect route to nursing homes, plucking these people out of their communities and placing them into nursing homes, which are likely to be overcrowded and understaffed. This would set the state of Connecticut back several decades and undo the many great strides we have achieved. And you're going to hear stories today, hopefully, and strong testimony strong data that supports our concerns and show that CFC actually saves the state money. So please listen very carefully to these stories, these testimonies, and please join us in opposing any cuts to or the removal of Community First Choice. Thank you.
Thank you, Maureen. Thank you for your testimony and for the work you do for the state. Any questions? Seeing none, thank you so much. Have a great afternoon.
Thank you, you too.
Next, we'll hear from Mairead Painter, Long-Term Care Ombudsman.
Good morning, Senator Lesser. It's still morning, I think. Representative Gilchrist, Senator Perillo, and Representative Case. I'm Mairead Painter, the State Long-Term Care Ombudsman. Thank you for all being here today. I put in written testimony, but I'm only going to speak to a few of the bills today. The first bill that I'd like to speak to is SB 328, an act requiring nursing homes to spend 80% of revenue on direct care. While I support the intent of this bill, I'm not able to support it as written because Connecticut has a very narrow definition of direct care. And if we only spend 80%, if we spend 80% on that narrow definition, it would not allow us to have the funds necessary to care for people in a holistic way for social services, dietary, maintenance, recreation, general upkeep of the building. I do think it's important related to transparency that we have a clear understanding of where all of the funds are going when we are giving funds to our long-term care settings. And this narrow definition really helps us to track that better because we're only looking at the funds that go to that, and then we can see how funds are dispersed in other areas of the building.
Yeah. So
I support. Oops, sorry. All right. So we must take into account this full range of services that are necessary to not only have a high quality of clinical care, but a high quality of life for the individuals living in these settings. The next bill I'd like to speak to is SB 330, an act about compensating spouses for the care that they give in homes. I understand the department's position on this. However, I do support having the ability to financially support individuals who are providing care for their loved ones at home. This often falls on spouses in cases of older adults. And these individuals either want to remain in the community or they want to transition back to the community from a long-term care setting. Many older adults receiving services at home rely heavily on these spouses. Oops, my thing here moved. The care that they provide is essential in keeping individuals in the greater community. This reflects what would be offset by the long-term care costs if the individuals had to go into a nursing home. I also think it's concerning that we're overly worried about how a spouse might care for someone when we have lots of other family members who provide care in the greater community. Many spouses, if they didn't want to care for their spouse, would leave them in a nursing home, or they would put them in a nursing home to not want to have to provide for that level of care. I recognize that these safeguards and training and oversight are important and ensure quality. However, then the structure needs to be thoughtfully put in place and have policies that promote this dignity and choice and allow the person to choose this if they want to, not that it's a requirement. I also think there's other ways to do this versus just paying a spouse. I think we could look at how a spouse's income or Social Security is counted towards the household income, and we could carve that out in a way where they're not being paid, but they're able to keep all of their funds coming into the house to support them in order for them not to have to go to work or not to have to impoverish themselves to keep their loved one at home. And I'd love to be able to talk more about that or to the departments about that. It would require multiple departments, not just DSS, but also Department of Housing. Next, I'd like to speak to both bills related to our residential care communities, House Bill 5357 and House Bill 5358. I support the spirit of both of these bills. Together, they work to strengthen the financial stability and predictability of reimbursement for residential care homes that serve a population of people that is growing in our state. We have many people who do not meet the level of care for a skilled nursing facility, but need some care and support. Residential care homes and other residential communities are more home-like settings where individuals remain connected to their communities, their families, as well as spiritual and social supports. Residential care homes are an essential component of our long-term care continuum in Connecticut. Without appropriate reimbursement and to accommodate for inflation and make those adjustments, we look at having low-quality residential care homes or not having them at all. This industry also supports individuals, take a quick sip, not at nursing home level of care. And if they're in the nursing home often can't discharge them, or they become homeless, or they're discharged to a shelter because they don't have the appropriate supports in their communities to meet those individual needs. And if a nursing home census is up, but 10 or 15 people in the home maybe aren't at level of care, the nursing home's also not getting paid for those individuals, which puts a burden on the nursing home. We need to make sure that every community has a really diverse spectrum of services and care options for individuals to choose from, and then we'll get the best outcomes, and I think it will be the least cost to the state overall. So thank you. That's my testimony today. If you have any questions.
Thank you so much, and I'll definitely be taking a look at your testimony. Representative Case, go right ahead.
Thank you. Thank you, Mairead, for coming. Not my concern, but expand a little bit more on 330, because it's something that we work with the IDD population, and we talked to the commissioner about earlier. The concerning part, especially with the bill, it's always says within available appropriations. but what actually do we need for oversight? I know that the reason why we have oversight in the IDD population is to make sure that all needs for the special person is taken care of. When you're taking care of somebody at home who's elderly, you're out there in the field, there's a few things you need to look at, but how do we get accountability?
I think in home care settings, accountability can look very different because it's individualized, right? It's what someone wants. It's how they see their dignity of risk. I will say we do receive a lot of calls about questions, right? Is this my right? Can I have this? Is this the appropriate care? Unfortunately, I have a very limited program related to community ombudsman. We have about 40 hours a week that we can put towards those questions and concerns, but that's it. With the number of people in the greater community, I think that is an oversight concern because we're unbiased, right? We look at how is the state appropriately supporting individuals? What are the supports given through community home care? And even with caregivers, some people will call us and say, for instance, my loved one doesn't want me to go on hospice, but I'd rather have hospice at home. Having that oversight, or even if it's about a spouse, making sure that all of those components are in place, really, I think, gets the best outcomes for the individuals being served.
Thank you. There can't be a huge number of people because there's a lot of qualifications you have to meet because it's state paid. A lot of people who are taken care of by their spouse at home might be private pay. They might have a nurse stop in every now and then. I just don't know how we get there. I'm trying to, there's always roadblocks when you want to take care of your own loved one at home that's on state aid.
When we transition someone from a nursing home, if they don't have a spouse, they're given up to 9 hours a day in a lot of cases, especially on the home care program for elders, if they had, depending on their needs, right? So they're assessed for their level of need. That care plan tells them how many hours a day they're able to receive in care. I really believe that if a spouse or a loved one is doing that, we would pay for a loved one to do that, but not a spouse. Spouses might otherwise have to work. We would allow a live-in to live in the house and receive all the benefits of living in the home, but not be counted towards the income coming into the home. So I definitely think there's ways to do that. I think we could be creative. We can look at all of the options and what supports individuals in the greater community, and then see how we can bring all of that together to ensure that the person's choices are honored.
Thank you. And I think we'll dig deeper into it and see where we can go with it because who better to take care of their own but their own. So thank you for coming forward and thank you for all you do. Appreciate it.
Thank you, Representative Case. I'm going to go to Representative Hughes.
Thank you, Madam Chair, and thank you, Mairead, and following my good colleagues' questioning. I really got interested in some of those other creative ways that you talked about having disallow for credits towards Social Security or that kind of thing for a spouse. I think it's time that we get creative about supporting people in their home and finding viable ways. One of the things that I thought about as you were testifying was really needing a case manager oversight in these specific cases. And I'm wondering, is there a way this bill can support sort of making exceptions to allow spouse rather than blanket, blanket allowable, like whether it's DSS or another agency that kind of opts in those exceptions? Can you talk to that?
I think I'd have to have an understanding of what those exceptions might be, how they might be applied to individuals, and making sure that it's consistent across the board. And just looking at, we want to make sure that spouses are taking care of themselves. And if they don't have the resources to do that, they often put off their own care because they can't financially support it. And then they become hospitalized or institutionalized, and we will see both people be institutionalized at once, which is also very costly. So anything that can be done to either through case management support them, look at the overall well-being for the couple together, I think works. And we've seen this work beautifully with loved ones bringing people home, children, cousins, other family members, and we do have really good outcomes.
Yeah, I think that's the model that we're trying to creatively support in spousal situations. And I love your approach to keep to case management for the couple. You know, what would work best for supporting self-determination and the individual's needs and allow the couple to keep that individual. So thank you. I think we need to just keep working with how to do this, right?
Thank you.
Thank you, Representative. Representative Butler, go right ahead.
Thank you, Madam Chair. And thank you, Maureen, for your testimony, especially on this Senate Bill 330. We're facing an aging population, and I think this is one of the things that we need to bring to bear to actually help us with the quality of care, the dignity, many times in our own homes versus in facilities. Your last answer to Representative Hughes actually highlighted some of the things that I wanted to hear about. But if you could just talk about how we could possibly put some of the things together to help this initiative versus the other initiatives if we don't have this, and just talk a little bit about the quality of care. Given this situation, if we could find a way to make it work with the necessary oversight. So if you could just elaborate on that a little bit more, appreciate it.
Sure. You hit lots of components there, so thank you. I think one of the biggest barriers to individuals transitioning out of nursing homes who are over the age of 65 is an emergency backup plan. And when you have a spouse, that person is able to be counted as your emergency backup plan and can help support that. So that right off the bat is cost savings. When you're talking about quality of care, I know there's a risk. I think there's a risk whenever anybody is at home, right? We have risks related to generalized home care, family, friends taking care of someone, but that's not the majority of what we see. That's the minority, right? There are some cases, we want to address those cases. But again, when you have a spouse taking care of someone at home, there are a lot easier options, which would be potentially to have them institutionalized. And if you're making that commitment, we see that love, that care go into the person's well-being. We also see a higher quality of life reported because people are connected to their communities of origin. We forget about food. We forget about spirituality. We forget about just having that person stop by the house because it's a little bit easier, staying and having a cup of coffee in a way and having a private conversation. Those little bits of dignity and quality of life go a long way. And when we first started with Money Follows the Person years ago, there was actually a concern that when people transitioned to the community and had that dignity of risk, we might see that they passed away. They might take that choice, but they actually live longer. They report higher quality of life, more connectedness and less loneliness, even though they have fewer instances a day of seeing people or connecting with them because those instances are more meaningful to them. So it's really about how the individual, how they weigh that impact to those things in their life, not how we're weighing them for them.
Well, thank you for your testimony. Thank you, Madam Chair.
Thank you, Representative. Don't see any other questions. Thank you so much for your testimony and your work.
Thank you very much.
Just want to remind folks on Zoom to accept the promotion to panelist when it is sent to you. Now we will turn to Sandra Roberts. Oh, I'm sorry. Oh, I'm sorry. Let me tell Sandra, we'll be right to you, but I'm going to go to Sarah Hinman. You're welcome. I just need you to push the button. So straight ahead of you, there's going to be, there you go.
Okay.
I'm Sarah Hinman. I'm the mother and caretaker of Chris, an adult son who's a C3 quadriplegic. Chris left the rehab hospital after 14 months without Medicaid status and supports. His father and I are his 24-hour caretakers. I am here to implore everyone on the Appropriations Committee to maintain community first choice funding. I did just chase down the commissioner. So my testimony has changed a little bit after I just chased her down and got some answers. But I did have a meeting with Michael Pecorelli and Paul Chase from the Department of Social Services regarding the need for community supports. That they told me the community first choice was the best option for Chris because the waivers, it offered more choice than the waivers. And they also said more choice. And I think that he could get services at different shifts that way, 24-hour shifts. Let's see. I want to tell you about my son because I think that you need to, he needs to be personalized. I think people with disabilities, I'm going to cry, need to be personalized. He is smart, determined, positive, has never asked why he's injured. He's self-aware, motivated, and a problem solver. He's engaged in his treatment and his self-care. Also, while maintaining his skills that he does have, he attends PT, OT, is planning an adapted vegetable garden, and has designed adaptive items for use in the house that are not available for purchase. He's been asked to volunteer as a patient in a physical therapy clinical experience for students, in part because of his attitude, self-awareness, and determination. Despite his chronic pain, fatigue, and lack of abilities, he is trying to consider possible ways that he can return to the workforce with the PCA. The ticket to this is community first choice. There's only 3 of you. Is everybody else listening? Is the rest of the committee listening?
Yep.
The ticket to this is community first choice. I don't believe it's waiver. That is the way that he's going to be able to stay independent. We are getting older. I am going to be 69. My husband's going to be 72. My son is 6 feet, 6'4", 200 pounds. I am tall. I'm an OT. I can transfer. This isn't forever. We can't do this forever. He needs to stay in the community. He can be independent if he has community first choice and whatever other supports are necessary. It's very concerning to me that this might be cut. I can't even tell you. And I don't believe that going to the waiver program is going to cut it. So I don't know that much about all the specifics of the waiver program, but what I've heard is that it doesn't provide the same thing the community first choice provides. And the commissioner said it was a short waiting list. That's not accurate. I've been told, okay, thank you. I was over here. I wanted to say, excuse me. I have heard that it can be up to 5 years. I've heard there's people that have been waiting 10 years. I can't prove that because I don't have the documentation. Is that my time? Am I done?
That is the,
Oh, I'm so sorry.
no, you
Okay.
did great.
Okay. But there's more. I do have my testimony.
Okay, wonderful.
Testimony, and I just would really urge you to keep funding for that program.
And thank you for personalizing it. Thank you for being here today. Next, we will go to Michael Werner.
Good morning, Senator Lesser, Representative Gilchrist, Senator Perillo, Representative Case, Senator Marr, Representative Comey, and other distinguished members of the Human Services Committee. My name is Michael Werner. I'm the lead aging policy analyst for the Commission on Women, Children, Seniors, Equity, and Opportunity, and I'm joined by my colleague, Megan Baker, who will introduce herself in a moment. We've submitted written testimony as well. However, we're here to testify in favor of Senate Bill 330, an act compensating spouses for state-funded care. And we really applaud the committee for raising this bill, which helps to serve vulnerable populations where they are. And it honors our commitment to allow people to age in place at home in the community. And as we know, Connecticut's older adult population is booming. According to the Healthy Aging Data Report, Connecticut has increased its population of the 60 and above cohort from about 18% to almost 25% just since 2021. A recent AARP report found that about 27% of Connecticut's adults, or about 773,000 people, are caregivers, and about 35% of those populations engage in high-intensity caregiving and high complexity of care. By valuing the extraordinary care provided by spouses in the activities of daily living, Connecticut can help keep families together, and it can address the needs of hard-to-serve rural and empty nester populations, among others, while avoiding unnecessary and expensive institutionalization. This bill also addresses workforce shortages, which are a lingering legacy of the pandemic.
Thank you, Michael. And my name is Megan Baker. I am the lead Asian American Pacific Islander policy analyst for the CWC SEO. And I just want to briefly bolster my colleagues' comments with a cultural apparatus because Connecticut's population is rapidly diversifying. We've had our state diversity index increase 10% from 46% in 2010 to 56% in 2020. And we have the highest diversity index amongst the New England states. And amongst this influx, the AAPI demographic is one of the fastest growing populations in the state. We have a 30% growth of population over the past decade with the two census. And then we have counties here that have experienced anywhere between a 57 to an 111% growth. And for AAPI families in particular, there's strong cultural norms of what's called filial piety. And this is not only respect for elders, but it emphasizes family duty and avoiding institutionalization whenever possible. And this makes in-home support not only a preference, but a cultural priority. The financial support that families will receive from spousal compensation will reduce caregiver stress for a mantle that they're already uplifting, which will allow these individuals to stay in the home that they're comfortable in, eat culturally connected foods that they have always eaten, and speak in their primary preferred language. With the establishment of this compensation, there's also an opportunity to collect data on this program utilization, which will help us better understand community need, community preference, such as language spoken in the home, and other metrics. So we really appreciate and thank the Human Services Committee for the opportunity to testify and for raising this bill, and we are open to any questions you may have. Thank you.
Thank you very much. Very helpful information. I don't see any questions. Thank you for your testimony and your time today.
Thank you.
Next, we will hear from Sandra Roberts, joining us on Zoom.
Can you hear me?
Yes, we can. Go right ahead.
Okay, thank you very much. I appreciate you giving me a chance to speak before you today. Mike, I'm having a lot of concerns regarding House Bill 5040 in reference to the Community First Choice program. I was on Community First Choice from approximately 2017 to 2024 when I had to go into the nursing home due to many health issues I was having. Even though I had diabetes for a number of years, I was suddenly insulin dependent. And I also was having numerous back issues, which I was not sure would lead to lower back surgery, which required my sugar to go down in order to have the back surgery. First, I do want to give a little bit of background about the Community First Choice. I want to make sure that it's clear that Community First Choice is an entitlement program, not a waiver. Because it is an entitlement program, there's not a waiting list like there can be with waivers. So there is no cap in that regards. Also, the cost typical plan under Community First Choice is approximately $63,000. Well, Medicaid would pay $92,000 if a person is in a nursing home. So right there, from where I sit, it looks like there's a cost savings. The other thing is that community first choice, you must meet institutional level of care. So when you are assessed, if it's determined that without the community first choice, you would be in a nursing home, that is one of the ways you qualify for it. Back in 2017, I was on the personal care assistance waiver, but I had recently had knee surgery. And due to my disability, which I was born with, arthrogryposis, my right leg, once the knee was replaced, could no longer bear my weight, which basically meant the leg collapsed. So up to that point, while I could stand to transfer, shower, dress in a standing position requiring only one aid, after the knee surgery, my care needs worsened. So essentially, I was getting dressed in bed because I could no longer stand up and I'm not able to bend at the waist. So it required two aides because they would literally have to roll me back and forth, putting on my clothes. Then I would have to be transferred with a Hoyer lift, where previously I could just stand up and be put into a wheelchair. I could even put myself into a wheelchair. So my care needs definitely changed. And because of that, while I had two aides there at the same time, one aide I had to pay out of pocket because the personal care assistance waiver would not allow for two aides at the same time.
Can you please summarize?
Sure. So basically what I'm saying is that community first choice is so critical. And I also want to speak that I'm in support of Senate Bill 326, which increases the asset limit for Husky C.
Wonderful. Thank you so much. Thank you for your testimony and for
Thank
being
you.
here today.
Thank you.
Great afternoon.
You too.
Next, we will hear from Claudio. Come right up. Will Zani be joining you? All right.
That's 2 up.
Thank you for being here today.
Thank you. Good morning still. Chairwoman Gilchrist, Ranking Member Case, members of the Human Services Committee. My name is Claudio Gualtieri. I'm Senior Policy Advisor for the Office of Policy and Management, joined here today by our HHS Division Director, Zania Matovsky. Together, we want to voice our strong support for Senate Bill 87, the governor's proposed bill to strengthen our nonprofits. I first want to commend the work of this committee over the past several years to do the investment in our nonprofits, including in the enacted budget that has $156 million for COLA increases. We see this governor's bill as being a necessary complement to some of the funding that we've put in place for our nonprofits. The goal is really threefold. First, we want to provide some level of navigation with all the changes at the federal level, with SNAP, Medicaid, and the federal landscape changing. We would propose establishing an advisory board where state agencies can work collaboratively with our nonprofit partners, try to find efficiencies, find best practices, and share innovations, including trying to streamline some of the reporting requirements and conflicts across different state contracts. The second thing we seek to do is to promote volunteerism. I've worked for a number of years in the aging space. Many of you probably have known that. And I think one of the most difficult conversations we had to have in caring for older loved ones was about when it was time to hang up the keys. And fortunately, in Connecticut, we're lucky to have nonprofits that have volunteer drivers. And those volunteer drivers are absolutely crucial in making sure when someone is in that position where they may not be able to drive anymore, they're not giving up their independence just because they're giving up the keys, that they have an ability to stay connected to the community. And we have fantastic number of people who are willing to be neighborly and step up to drive their seniors to medical appointments, the local senior center, church, and stay vibrant and actively involved in their community. The third piece that this seeks to do, this bill, is create some financial sustainability and predictability when it comes to commercial billing. In particular, in Connecticut currently, insurance companies can retroactively deny and downcode different claims up to 18 months. That's a significant burden on our nonprofits and other health systems when they're trying to close the books, decide where they have opportunities to make investment in their workforce or invest in their clinics. And we just see this as being an unfair and burdensome shift onto our nonprofits and other healthcare providers. So collectively, we've put forward this package. We look forward to working with you. We're excited that there's a couple other clawback bills and other committees. We think our bill is the broadest, and we want to work with you to make it the strongest. And then as for just some of the testimony on the record regarding the driver provisions and making sure that a volunteer driver doesn't have risk of cancellation of their auto insurance policy or being in a position where they're penalized with a surcharge just because they do volunteer drives. This bill would put us in alignment with a majority of New England states. So Vermont, New Hampshire, Maine, Rhode Island all have this. In addition, there are large states like Maryland, Illinois, and Florida that also make this protection available. And a few years ago, AARP actually recognized these volunteer protections for volunteer drivers as being a best practice in their long-term care scorecard. So with that, I'll pause if you have any questions or if Sonny wants to add any comments.
Great. Thank you so much. Thank you for the opportunity prior to today to discuss these. These all seem like strong proposals, and so look forward to working with you all throughout the session. I do see Representative Case. Go right ahead.
Thank you. Thank you for coming forward. What do you see with in the governor's budget with the community first care?
So I'm glad you're asking that question and we get a chance to provide a little bit more clarity and detail. Obviously, this program means a lot to individuals and families, and it's been around for a significant period of time. So allowing us to unpack the details and the thoughtfulness by which we want to move to a different waiver authority, a different Medicaid authority, while maintaining our commitment to the services. So first I'll say, anyone who's listening, who's on the program, our absolute commitment is to make sure everyone on the program and enrolled in the program before we make the transition will be transitioned over to a waiver service. There'll be no cut in benefits. There'll be no cut in services. We understand that there needs to be changes in the current waivers that would absorb those individuals to account for things like 24/7. But we're absolutely committed that no one will lose services and will have comparable, if not more, levels of care. The motivation behind this is not purely physical. It's not a budgetary savings. It's also about making sure that we have a system that more fairly distributes the limited resources we have. So when people talk about wait lists, I know, Rep. Case, autism is 10 years. ABI, probably 4 to 6, we're averaging. And we have a small portion of our home and community-based services, self-directed PCAs, that's uncapped. What that's doing is crowding out any other ability for us to take people off the wait list. So I see this as a three-pronged approach. First, we need to make sure that everyone on the Community First Choice program knows they will continue to get services. We will support them in the community as long as they wish to be there. Two, we need a thoughtful reinvestment plan to make sure that we're indexing and having a meaningful move to remove all the people, regardless of whether you can self-direct or not. Some people can't choose to self-direct. They may not have family members to support and coach them through that process. We have very limited ability to provide case management in our CFC program. So we need to make sure that the new waivers have more consumer options. People can choose self-directed PCAs. They can go to an agency-based PCAs. They can put together a host of a much broader array of services under those waivers. And I think that commitment is necessary. And over the next week, I know next week in particular, we have 5 stakeholder meetings, one each day with the impacted parties. We have a responsibility to make sure that our plan is clear. DSS is hiring an expert consultant, and CMS is committed to working with us to make sure we get this right. But it's really about fairness and equity, putting some movement on our waivers that have long been capped so that people who can't self-direct aren't stuck languishing on a waiver for 10 plus years. We need to look at distributing those resources and reinvesting in our HCBS system.
Thank you. I thank you for that clarification because a lot of things that happen in this building, as you guys know, titles or one sentence sparks up a lot of controversy. But we want to make sure, because we are all people, we're people in the state of Connecticut, we want to make sure that everybody has the right ability to be taken care of and have housing to where it needs to be. And if they don't, we need to be accountable to them. So, you know, obviously we're gonna have a lot of people coming and testifying. That opens up a lot. That there's more to it, and you guys are working through it over in the governor's office. So thank you.
Thank you, Representative. I'm going to go to Senator Lesser, followed by Representative Comey.
Thank you, Madam Chair, and good to see you. Sir, just a question I asked earlier of Commissioner Barton Reeves with respect to the major changes Community First Choice. We are hearing from an enormous number of stakeholders who are concerned that if this were to come to pass, it would dramatically reduce the options available for people with disabilities in the state. And I've heard the concerns about the third-party intermediary, and I've heard what you're saying about case management and the challenges with self-directed care. But we had a colloquy this morning with Director Weston and with the commissioner about what we can do under the existing program without applying for the waiver, which is that if the issue really is about case management and using that to control care or to bring an agency model, we can do that today. There's no barrier to that other than some technical questions. And I just wanted to see if that was something that you agreed with.
Senator, so I appreciate that because it gives us an opportunity to address a concern that's come up, which is why not fix it? Why just move to sort of transition the authority? And I will remind the committee, because you guys were there with us over the past several years where we've tried to fix it. We had 2 other fiscal intermediaries were not performing well. We went out to a competitive bid. We plussed up the contract significantly to try to get an enhanced service level commitment from the FIs. The problem remains that too many people are forced into self-directing that don't want to self-direct, and they don't have the interest or the capacity always to self-direct, hire, manage their own timesheets and backup plans for care workers. So that remains a pain point in the design flaw of CFC. I respect the agency base being an option. We had tried to explore that too a couple years ago. I think there you'll hear from a lot of the providers that the capacity is just not there on the provider side. So we can make it available as a paper offering, but unless we have the provider capacity on the agency side, I just don't think we're going to have a meaningful option to move people into agency base. So the waivers allow us 2 options. It will maybe allow us to reinvest in the agencies to build up that capacity so that the workers paid by agencies are more comparable to the self-directed. That would allow them to take on more people. I also think it would allow us to do wraparound services much further than the support and coaching function that's currently available under CFC. We have 170 people that have been trained to be coaching and support broker functions. That's being very hard to match make that function of supportive case management with the people who need it. So waivers just have that more intentional, focused wraparound support and allows us a lot more flexibility in what we cover to make sure that people have the support they need when they're managing their care.
And we can't do that outside of the waiver, because what we've heard is that you could, that the department is just not currently doing that, but that there is no prohibition right now. You talked about agencies, talked about case management, that we could do that under the existing model. Would just happen not to. My concern is that the cost containment is hoping that people will get on a wait list and stay on the wait list. And so we're going to be depriving folks who need services of the services they need. And I'm skeptical that that'll work with this population. The skepticism that I articulated earlier with the commissioner is that you put folks on a wait list who need a certain level of care, they're just going to go into a nursing home. And if you do that, that's going to, balloon state costs, and it's also not what they want. And so I don't know, other states have considered this, and I understand that there's actually pushback from the federal government. They don't think that this is a appropriate response to the ballooning costs. And I'm curious how much you've looked into this.
I think your point, Senator, actually speaks to what will be most likely to keep the state accountable to making sure that we open up slots, because we all acknowledge that it's in the best interest of the state to serve people in the home and community-based setting as much as possible. So why would we want to cap people who can be effectively served in community when that's a it's a preferable choice of delivery, and it saves the state money. So that's what's going to keep us honest, just as it is with another waiver. The elder waiver is uncapped. We could choose to cap that. We functionally choose not to, because it's not in the state's interest. It's not in consumers' interest. So we make a determination of what's needed to increase the slots, and then we put resources behind that to make sure that those slots are available to every senior who wants to be served in the community. This is what we need to redesign. The savings from the transition to a waiver authority as opposed to CFC will allow us that reinvestment opportunity to actually move people off of these very, very, very long wait lists and get them the support they need, because not everyone can be served effectively with just self-directed PCA services. People need a full array, sometimes residential support, especially in the DDS community. ABI and autism need very specialized services in some cases. So this would just allow us to actually make meaningful progress across the full continuum of need, not just one subset that can choose to self-direct their own care.
So I guess I hear that, but what we heard from Director Weston this morning, and I hope I got her title correct, was that the barrier, right, the easiest way for us to get case management services to the current folks on Community First Choice would be to bring in agencies, and that the barrier to that is a time and money issue, that there's an issue with the MMIS, I forget, the Medicaid Management Information System or something like that. And that there's a barrier there, and it would take a little while, but we could do that, and then that would solve the issue. But it sounded like that was, I mean, that was what I heard her say. Maybe I misheard, but that was what I took from her, testimony in response to my questions this morning. So when you're seeing the stakeholders express enormous concerns that you're saying you're trying to pull people off wait lists, like my look is that we're creating a new wait list. And I hear a lot of folks with disabilities expressing, real serious concern that this is just going to walk back this the state's commitment to people with disabilities. If we're taking those concerns seriously, and we are saying, the current program isn't serving the population, it isn't, there's money being wasted because folks who need case management aren't getting it, why not put an investment into the MMIS system and try to figure out how to bring in agencies within the existing model?
So I think Director Christine Weston articulated that there's a very long lead time, and it's not a simple process to correct the MMIS deficiencies. I think, as I mentioned previously, there's a practical reality of we don't have the capacity at the agency base to swing the door wide open. So we need to be more thoughtful on the people who really need that agency-based support as opposed to self-directed. We could probably help those that are most in need of having an agency as opposed to self-directing if we could manage it through a waiver. The final thing I'll say is there are technical rules that we need to be mindful of where we can't duplicate services. So about half the people on CFC are part of a waiver, but they receive their self-directed, their PCA service hours through the CFC program. And we don't have duplication between those two programs. So if we add certain things like case management or other components here, it may limit us for the people who are on waivers that don't want to be part of CFC. So we need to be mindful of any unintended consequences of duplication of services between the waivers and CFC that needs to be worked out.
So we are going to be back next week, I suspect, with another hearing looking at the PCA third-party intermediary. And full disclosure, I did meet with the third-party intermediary recently, and they are very concerned about what we might be up to. And they did push back, and they said one of the challenges, and we'll get them hopefully on the record next week, but what they told me privately was that one of the challenges they've had is a number of frustrations because they're getting inadequate information through the MMIS system. And I understand, you and Director Reston saying it's a lot of work to upgrade that system, but it sounds like from, sort of hearing this question from a number of different angles, like that might be something we just have to do, because if the program isn't working, then we got to upgrade it. And so unless I'm missing, maybe their concerns are misplaced, but it sounds like there may be a number of reasons why we might want to do some technical upgrades to the MMIS system.
Totally in agreement with you, Senator, that regardless, I think there's going to be a period of time, even if we do move forward with this transition in Medicaid authority away from the CFC to a different waiver authority, there's going to be a period of time where we need to make sure CFC works better. And so if that means making sure we're procuring additional FI capacity, MMIS upgrades, whatever it takes, we're even exploring some potential opportunities to tap into the work of the access agencies to, as an administrative expense, wrap around and provide some informal case management. We're looking to do some more training of the coaches and support brokers and trying to find a matchmaking service, because we have a period of time where we have a commitment to individuals who are on the program to try to make it work as effectively as possible. And if that period is a year or multiple years, we're fine with working with you on making sure that we're doing the best we can. And that's multi-pronged. I don't think one is exclusive of the other.
So one last, I will just echo what I said earlier to the commissioner. Parts of, we have the governor's budget implementer in front of us, and parts of the governor's budget proposals for human services are in that implementer, and some of them are in other bills and other committees, and it's just difficult for us. There's one person who submitted testimony saying that we need an exorcist for the governor's budget proposal. I'm not sure I totally align myself with that concern, but we are trying to figure out how to, we've got things flying around, and I just would ask that OPM and the agency, as I mentioned before, just make sure that we're getting all of the information about what the governor wants to do to this committee, so we can, we know what to do, because it's harder to track all of these proposals that are in other committees.
Yep, and if I could briefly respond, at least one of those bills I will take some responsibility for, because it was the quality reimbursement system. So this has long been an issue that Senator Hockedal has championed. I've worked with her for the past 3 years on trying to institute it, and they did have a bill last year that sort of set up the shadow rate structure and formalized the process that DSS had. This year, when she raised the title, we came to our attention after our implementer was out that we would in fact like to have language establishing the transition of the PDMP, which on the 3rd year funds the $10 million quality pool. So I asked if she would be open to using our language, which aligns with where the funding already lies, to do a quality pool. So it was a mutual agreement after our HHS implementer was out. We didn't know we would have needed the language until then. So I'm committed to making sure that you are fully brought into that bill moving forward.
Thank you. That's all I got, I think. Andrew?
You, Representative Comey, followed by Representative Hughes.
Thank you very much. Thanks for coming, both of you. The SB 87 enacts strengthening the nonprofits. You have a volunteer nonprofit advisory board, and you provided testimony. It's sort of, it's not very specific, right? There's not a lot of details to it, except for maybe who's on it or who gets appointed. Is this a term, is there a certain amount of time that this is in place for? We have had nonprofit agencies in the last administration, the governor's administration. And I'm wondering how it is similar or different in that respect.
A very good question. So, Inzani, I'll tip to you to fill in some of the gaps here. So this proposal before you is looking to refresh some of the successful models that worked before. So Governor Malloy had some successful work, and at that time they targeted it around some very particular interventions. One of the successes was about trying to create better standardization of med administration, because many of our agency providers work with nonprofits on managing and administering medication and simplifying the certifications that are necessary across different agencies. And another was a liens analysis process. What streamlining on the back end and shared services could our nonprofits do? And so that when that board met and it had a very focused intention, it concluded its work, it had a successful run, and there was sort of a decision to sort of move past that. I think what we're proposing here is more of a long-standing one, and that's why one of the critical components of our bill that's built off of both what was successful under the Malloy administration, but also what's currently in place in New York, is operationalizing that group with a dedicated policy person. So it's not a place to just convene and surface ideas, but to formulate the action steps that are necessary. And this can be flexible by design so that we can tackle the emerging needs. Up until a few years ago, we didn't realize, for example, that liability insurance was such a pain point for our nonprofits, but we're seeing a lot of them face huge increases and potentially people not wanting to underwrite that risk anymore and have significant trade-offs there. So we wanted to leave it flexible so that if an issue like that emerges, we have the capacity and the framework and the forum to problem solve. I think in the short term, I expect a lot of the work of this board to be focused on the fallout from HR 1, Medicaid changes, reimbursement changes, uninsurance, because the ACA subsidies may be more limited moving forward. So how do we navigate that together? I also think there's an incredible opportunity to lean into our nonprofits for certifying that someone has done volunteer hours, which would be a way of meeting the Husky D work requirement, community engagement. So we have very unique and pressing points, I think, that are going to be the focus point in the short term, but we wanted to leave it broad enough so that as emerging issues come in to play, we still have the capacity to tackle those. Do you want to?
And then I would just add on OPM and the agencies deal with, there's 9 HHS agencies, and we deal with a lot of operational concerns. So contracting, all of this, and ways we can streamline and better help them operate and make sure they're able to serve the residents we serve. It's a benefit to the residents of the state. So the flexibility given to that board to tackle these emergent issues, I think, is a benefit for us. So the vagueness is kind of deliberate.
Thank you. And just a follow up on that, you mentioned the insurance. We're having the same issue in regards to childcare, whether nonprofit or for profit, right? But so this is specifically targeting toward HHS, you mentioned, I think, Sonny. Or is this across agencies? I'm sorry, I didn't have
It is targeting for us HHS because so far the intention is for it to be with Claudio and I in our division.
Okay, thank you. Well, it certainly can't hurt. So there is a budget that will be, they'll have the resources they need to do their work. I'm hopeful.
Yes. It is in the proposed governor's budget, and we're hopeful that it remains in the final negotiated package. Yes, Representative Comey. I think the other point I would say by way of anecdote is that having a formal structure has already yielded some benefits. Since we put the bill out, we've had agencies not named raise their hand and say, this is really cool. We have this data set on workforce development that we'd like to share, DOL. It's very rare that agencies come to us and say, hey, we have something to share and we want to be at the table, and they're volunteering to do more work. But I think they really see having a formal structure for problem solving and being more proactive with the nonprofit community that we rely on for so much of our human services is in everyone's best interest. And I am excited by this opportunity if we're able to get it.
Absolutely. I think it could be very beneficial for a lot of the agencies and the people in the state. So Section 3 of that same bill, which I hear a lot about from our mental health care providers, things like that. I mean, that has been a real issue for the insurance companies coming back after 16, 18 months. And I notice this isn't in insurance. It's here as part of the strengthening, I guess, part of 87. Will this benefit? It's 12 months. They can't go back. Can we just talk about that a little bit more as far as
of course,
what that will do?
So right now in Connecticut, insurers can go back and look at a claim that they've approved after it's been a clean claim, and they can downcode it, recode it, deny it, and past the date, and then claw back the payment made to that provider up to 18 months in the past. Obviously, that's a huge challenge for people. And as you've heard from some of your providers. I'm particularly concerned because we've done work, for example, standing up the UCCs. It's a brand new nonprofit mental health service type that we've initiated in the state. And it was very hard to get the Medicaid rates in order and all that. And one of the things that they've told us is they're feeling a lot of uncompensated care, and they've struggled mightily to get a good commercial rate. So when they have a good commercial rate, that's going to be an essential complement to their Medicaid book of business. But we need to make sure that if they're getting a rate and they get billed that amount, that there's not this clawback way after the fact that could be taken away from them. You know, a lot of these nonprofits that deliver mental health services are not operating on huge margins. And so we're very hopeful that by putting some protections in so that when you close the books, 12 months, we think is a fair amount of time, you close the books and you can have some assurances the money's going to be in the bank and you can use it to invest in your nonprofit or your health service provider, or give raises to the workforce that's in dire need and shortage right now. So the bill is actually one that other states have had. Again, we're looking to model best practices in other states. About 1, 2, 3, 4. We have about 12 states that we've identified. Many in our region, like Massachusetts and Maine, also big states like California, have set the 12-month limit. There's additional 4 states that actually have gone even further than that and limit the clawbacks to just 6 months. So you have Texas, Nebraska, and Maryland going with a 6-month. So we think 18-month is an outlier, but we want to recognize that maybe it takes a little bit of time to process appropriately and see where the additional, by reducing it by 6 months, we think that's a prudent step, but it's a meaningful step. And we do think it's one of the stronger bills out there. To your point of why it's in this bill, I think that's always the nature of our nonprofits, right? They cut across so much of what we do that they're going to, by necessity, take into account insurance, workforce development, delivery of human services and social services. But what holds it all together in my book is what we're trying to accomplish. And that's making sure that our nonprofit providers that are on the front line of delivering services, delivering those human services, have the supports they need from multiple different levers that we have to pull in state government, whether that be through regulation, through funding, through our nonprofit advisory council support. So to me, the connective tissue is we're standing up our nonprofits and we're delivering human services, and that's fundamentally the jurisdiction of the Human Services Committee.
Thank you. I'm sorry, can I have a clarification on that, though? So this would only be the carve out, I would say, is there any carve outs? This would only apply to nonprofits? I mean, would
No,
it apply to the person providing mental health care for, just a therapist and not in a program?
It's in the bill because it includes nonprofits, but it applies to all of them.
It's just a recognition that
It
our
just fit
health
the entire, it fit the entire theme of the bill, which was, it's an added benefit that includes all of them.
Again, I think it would be a benefit to certainly our small business owners as well.
Agreed.
Agree as well. Thank you. Representative Hughes, go right away.
Thank you, Madam Chair, and I just want to echo Rep. Comey's concerns that, this has been a burden that our nonprofits and small providers have been subjected to, as these clawbacks. So this is absolutely essential to having some kind of stability towards providers being able to operate effectively without this hanging over them. I just wanted to ask you about, again, going back to community first choice. We were one of the first states to implement an MFP, money follows the person, community first choice program, correct? And I'm just wondering, as you look at other states going to a waiver-based consolidation, what are some of the unintended consequences that we've seen in other states, and have other states done?
So Representative Hughes, I have to confess, I, in my old job, helped write, along with Don Lambert, the very first community first waiver that was approved in Connecticut, and we were one of the first states to do it. So,
Yes, indeed.
yeah. Certainly, there's only a handful of states that have elected this option. It was made available in the ACA, and there was an incentive, an additional 6% FMAP for those services provided under a CFC. And there has been, a handful of states that have continued to do it. I think Maryland has moved to try to reform some of the ways it delivers services. I think they recognize, similar to us, that they need to be more than just self-directed. There really needs to be some sort of a case management or agency component. So they have leaned more into bringing agency-based perspectives in. I think for us, we're trying to look at ways across all of the different wait lists that we have for where we make these investments, not just in one part of our continuum of services. So it's an equity factor here in Connecticut. Not every state has the same wait lists for some of the autism waivers or the ABI waivers, for example. So when we're looking at it holistically, we're trying to balance in a way where we can actually define true need, unmet need, and then prioritize across all the complexity of care, including those that can't hire a PCA and self-direct. So it's really about maximizing choice and trying to make an intentional year-over-year commitment to move these wait lists that have become very slow to move in actuality, despite some of the greatest efforts of Speaker's Bill 5001 a couple of years ago. I think we've just chipped away, and with the population growth, haven't been able to keep up on that side of our home and community-based delivery system.
I guess, thank you for that. And I just wonder, I keep hearing echoes of this need for case management really to be provided for folks on this continuum. And I was just wondering, do you think that there's a hybrid option of providing that kind of case management first before we go into moving into the
Well, I certainly agree. I think that's an identified pain point. And I think that the people who have the benefit of having case management and self-directed PCAs are doing a lot better. It helps them create additional backup plans. It helps them manage their budgets so that if they have ebbs and flows in their care needs or different family members coming in at certain months but not available or as frequently available at different points in the year, managing and being proactive about that through the case management function is extremely helpful. I think doing timesheets and reporting and making sure that with the new benefits that we've provided, like paid time off, that adds even more complexity. Because if you were anticipating someone to work and you have to double up and make sure that there's backup coverage when someone needs to take a day off or would like to take a day off, that's going to be an area where case management really helps. So as the program has evolved and gotten more complex, I think the need for case management and the gap that we have in providing that support to the consumer employers is really starting to manifest itself. So anything we can do, whether that be also part of a hybrid approach, I think is absolutely on the table and something we should be considering.
Thank you so much. Thank you for collaborating with us on this as we try to provide services to everyone.
Thank you, Representative Hughes. I don't see any other questions. Thank you both so much.
Thank you. Have a good day.
You too. Next, we will go to Joy Minervini with us on Zoom.
Hello.
Hello, go right ahead.
To the Human Service Committee, I am testifying to the opposition to the governor's proposal to end the community choice program. My name is Joy Minervini, and I would be personally and severely harmed if the elimination was to go through. It would cause involuntary institutionalization. I testified before the Appropriations Committee on February 18th, but I realize many of you are not on the committee or cannot be there. Thank you for letting me tell my story to you. I have a severe form of cerebral palsy, which involves uncontrolled movements. As I age, these movements have worsened and involved my face, neck, arms, and legs, and then my entire body. I require total care for my ADL 24 hours a day, 7 days a week. I cannot speak. Therefore, I use a communication board with words and letters of the alphabet to communicate. I have a suprapubic catheter, but I also experience urinary incontinence several times during a 24-hour period. In addition, I also have many bowel movement accidents. Both incontinence require me to be clean and changed timely to prevent skin irritation, open wounds, and infections. I receive nutrients and fluids through a J tube because my facial tongue and teeth grinding movements made it impossible to eat and drink using my mouth. Each day, it takes anywhere from 12 to 14 hours for the completion of the feeding and fluids. When the tube gets blocked, the machine starts beeping and my PCAs need to address the issue, prime it, and restart the feeding. My left hip is dislocated and requires me to sleep on my right side. A pillow needs to be placed between my knees and another pillow behind my back so I can stay on my right side. Throughout the night, the PCAs must reposition the pillow behind my back so when I cough or aspirate, I will not choke. I wake up several times throughout the night, mostly in the early morning hours, and I cannot go back to sleep. My panic attacks are triggered, and I end up biting my tongue. My PCA gets me up and places me in my wheelchair to help me calm down and clean me up. All the above reasons why I need the CFC program to continue my 24-hour, 7 days a week care. Only the CFC covers a 24-hour care in the community. If CFC goes away, I will not have any choice but to go into a nursing home. And truthfully, I will not receive the one-on-one care that I receive now. The nursing home staff have way too many patients to care for, and quite frankly, I will not survive very long in a nursing home before I pass. My life is in your hands. Please do not lock me up and rob me of my independence. Joy Minervini.
Thank you so much, Joy. Thank you for your testimony and for sharing your experience. Next, is Marianne Langton here or Patty Ellis? Not yet? Okay. We will move to Jennifer Tadukiewicz. So sorry. I know I butchered that. Okay.
Good afternoon, I think. Yes, good afternoon, Representative Gilchrist, Representative Case, and Representative Comey. I'm glad to be here. My name is Jennifer Chidukowicz. I live in Cromwell, but serve as Chief Strategy Officer at the Southeastern Council on Alcoholism and Drug Dependence, better known as SCAD. SCAD provides a full continuum of care for substance use disorder, regardless of financial means, from our front door, withdrawal management, which people used to call detox in New London, to residential treatment for men and women with locations in Lebanon, Norwich, and New London. We provide outpatient and inpatient services, primary care, hepatitis C treatment, medication-assisted treatment at every level of care, and recovery housing. We serve approximately 5,000 individuals annually and employ 213 staff members. We contract with and are regulated or funded by multiple state and federal entities, including DEMIS, DSS, Medicaid, the Medicaid waiver, CSSD, Eastern Region Service Center, ABH, DOC, and we are licensed by the Department of Public Health. We also comply with federal and state reporting requirements such as DDEP and GIPRA and oversight from agencies including DEA, DOC, SODA, and CSAT. But most importantly, I am always wearing my hat as a woman in long-term recovery first. And I'm grateful to testify in support of Senate Bill 87 today, which would establish a nonprofit advisory board within OPM to advise the governor. This is an important step toward addressing longstanding inefficiencies in how nonprofits contract with and report to the state. Let me offer a few examples. The duplication and lack of standardization in reporting requirements across agencies creates significant administrative burden. The judicial branch requires client data entry into its CDCS portal. DEMIS requires reporting into DDAP, the same exact information. Some contracts require federal GIPRA reporting. Each system collects overlapping information, but in different formats with different definitions. Even something as straightforward as a critical incident report varies by agency and sometimes even within departments of the same agency. This inefficiency extends beyond clinical data to financial reporting, census tracking, and monitoring visits, often multiple site visits from different agencies reviewing the same materials and documentation. At the same time, we are facing a severe clinical workforce shortage. Part of this challenge stems from inconsistencies between DPH licensure standards, DSS Medicaid waiver reimbursement and credentialing requirements, and DMIS contract expectations. These structural misalignments restrict workforce flexibility at a time when clinicians are leaving for telehealth providers. School systems, hospitals, private practice, and state agencies can offer higher salaries. In summary, it's important to codify this advisory board in the state statute, ensure that this effort is not temporary or dependent on one administration. It institutionalizes nonprofit partnership within the state government and creates a durable, accountable framework for improving how we deliver essential human services in Connecticut. It's not about asking for funding, it's about smart, efficient systems into law. Thank you so much.
Thank you so much. Thank you for all the work you do and for testifying today.
Thank you.
Wonderful. Next, we will go to Laura Jordan.
Thank you, honorable members of the committee. I'm Laura Jordan, the mother and caretaker of my 23-year-old Alexi. Here, I'll say hello briefly. And he's really beautiful and sweet, but he struggles with disabilities, including autism, IDD, speech, and dyspraxia. He can run off, he can't tie his shoes, bathe, dress, and eat safely or prepare a meal without help. But he's more than that. He's an award-winning artist and loving young man. He really needs community first choice to stay at home and in the community. I'm here to add to the very eloquent people who've spoken before me and will speak after to voice my concerns and ask that you save CFC and amend HB 5040 to preclude any cuts to CFC, which my son greatly relies on. It's a successful and cost-saving program for so many, and it's been a lifesaver for Alexi. Self-direction with CFC, choosing one's own caregivers, gives people flexibility, choice, and dignity to live at home and in the community. Moving people from this entitlement, which they need and can access right away, to a capped waiver and wait lists means many will lose this vital care. Family would have to take over, leave their jobs. Individuals would be forced to go into institutions, nursing homes, or CLAs, which don't have enough beds and staff as it is. People would be cherry-picked based on cost, which is awful and discriminatory. It's cruel. There are many fundamental problems with Governor Lamont's and Commissioner Barton Reeves' proposal. There's also no rationale to cut CFC because it's difficult to case manage. I manage it, and I'm no expert. I'm no business person. Instead, fix the GT issues, and for those who need it, there's the option to hire support and planning coach. I spoke to one, she was very capable. Or add an agency option, which it may cost more, and coming out of our loved one's budget and thus care orders, but it is an option. It could be an option. Not only is CFC better, it's less expensive. It saves the state approximately $210 million per year. That's $29,000 per individual over individual care. There will be high costs to create and manage this proposed waiver. The state would lose the 6% federal match, and the wait list will grow. It's already set 5 to 10 years, and individuals on CFC, like my son, may not get the same level of CFC services because it's all vague and discriminatory, and it will kick people off of services that they need. Therefore, the rationale behind axing CFC and putting our loved ones at risk in institutions with abuse and neglect possibilities is morally wrong, and it doesn't add up financially either. Please add an amendment to HB 5040 to stop this proposal in its tracks and save CFC. Briefly, I also support SB 326 to increase the asset limits for those like my son on Husky C. Also consider increasing the income limits for Husky C as well, because $1,397 a month limit is very low. It's dire poverty, not even 90 hours or so of work a month at minimum wage. That's not a lot of hours to work. Those on Husky C who can work
Can you
should be
please
able to
summarize?
table it. Thank you to other Husky programs. Thank you very much.
Thank you very much. Thank you for your testimony and for being here today. I don't see any questions. Have a great afternoon.
Thank you. You too.
Thank you. Because of the weather, we are going to start calling on folks who are in the room, and then we'll go back to remote. So I'm looking at my list. I think I'm going to get this right. Next would be Chris Herb.
Good afternoon. My name is Chris Herb. I'm the president of the Connecticut Energy Marketers Association. We represent 600 family-owned fuel retailers in the state, many who participate in the Energy Assistance Program. We're here today in opposition to House Bill 5355. First, I want to thank you and your colleagues for, in a bipartisan way, for many years passing several laws that would, in response to vendors' concerns about the Energy Assistance Program. The legislature's recognition of the weaknesses in the program and their willingness to change the law in response to that is immensely appreciated. I can tell all of you that the vendors that are in your districts, it means a lot that you have responded to their needs. Unfortunately, the Department of Social Services has not implemented many of those laws over the last several years. And I'll remind you that last year you passed a bill, or 2 years ago, you passed a bill that required us to have a working group because we couldn't figure out how to get them to enforce the law. That working group did meet, and I appreciate DSS's efforts in it, but it's convenient that they only point to information that came out of that working group when it suits them and ignores the vast majority of the information that was dealt with. This bill, 5355, does two things. It repeals the laws that you passed in response to our concerns. They don't want those laws to exist, even though we've met with them not only through the working group, but independently many times where they said that that we had our interpretation of the law was incorrect. And I will say that why do they need to repeal a law that they're saying that we didn't interpret correctly? It's because the black letter of the law requires them to do some things that they're not doing. The price volatility that was discussed earlier today in testimony comes front and center. After the Russian invasion of Ukraine, vendors came to you and said that they could not withstand the type of price volatility that occurred at that time. So we moved to a day of pricing system that was never implemented. And I'm just going to give you an idea. On Friday, DSS published a price for vendors that was based on Thursday's price. So Thursday's price was published on Friday. It was held on Saturday, Sunday, and Monday and didn't change until today. During that time, there was a 25-cent increase on Saturday. There was a 15-cent increase on Sunday. And then there was a 40-cent increase on Monday. The restricted margin over rack program is 50 cents. They're already upside down. Today, yesterday and today, vendors have parked their trucks. They are not making deliveries. Dozens and dozens of them have contacted me. They've contacted the community action agencies saying there is no way it's economically possible for them to do this. If the law was being followed, deliveries would be made today. It's unfortunate that people who are entitled to these benefits are not being served because the department is not following the law. The second thing the bill does is it repeals a law that requires them to have county pricing. The deputy commissioner pointed out that it is not consistent with the region, and he is correct. There is no other state that has county pricing. But there are states that pay full margin in the region. We don't do that. There are states in the region that have 13-cent and 11-cent discounts off of retail. The DSS came up with a program that had a 35-cent discount. They're not following the region. So they like to point to the region as a convenient way to say that county pricing should be repealed, yet they ignore all of the other regional practices that they weren't willing to implement. We have come here in partnership with the legislature, with the community action agencies, and the department because we all have the end goal in mind of making sure that every household that is eligible for this program is served properly and has many options of vendors that they can do business with. Yet we continue to see an erosion of participation in the program. And today I participated in a press conference with Representative Gilchrist with Generation Power Next, formerly Operation Fuel, who's seeing an increase in enrollment of vendors because they run a program that is fair and equitable and makes sure that consumers are served properly. The problem with the program is that it's been broken since day one when they fixed this margin. Other states haven't gone in that direction, and we continue to try to tweak it so that it does work to maximize participation. So I urge you, and you'll hear from vendors later in today's hearing. We are respectful, only asking a few to testify, but we urge you to reject House Bill 5355. Thank you.
Thank you. Thank you for your testimony and for working with us. Yes, Representative Case.
Thank you. Thanks, Chris. Is there a way DSS can get same day pricing so they can put that? Because this is happening all over the country is, you know, fuel has just gone up and we're watching it going up 2 to 3 times a day.
Well, in the immediate situation, the LIHEAP plan and the vendor agreement has language in it that allows DSS to respond to unanticipated price volatility. We have requested that the department make an adjustment in pricing so that vendors can not lose money and get back on the road to make these deliveries. I just received an email in the last 10 minutes saying that they're still considering it. If they're not willing to make the change, then no, nothing's going to happen. They'll continue to keep those trucks parked until such time as that the economics work themselves out. The deputy commissioner testified saying that these price increases are typically set off by price decreases. I've worked here for 25 years. I have never seen prices ever decrease and is extremely as they've gone up in this case and in previous cases. Earlier during the season, we had a Friday price that was carried over into the Monday Martin Luther King holiday and then a state snow day. So the price didn't change. In the meantime, we had about 20-cent price volatility from that Thursday price to when the program reopened and was adjusted. And they still didn't deliver until another day because the pricing didn't catch up. So we have to find a way to do this. And right now, the department should take immediate action to address the margin issue and so that we can make deliveries.
Thank you. And I think you heard the commissioner say that, you know, the fund is still flush and still good, and there'd probably be a decent carryover. My concern is a lot of these companies that do these deliveries to our most vulnerable families are small businesses themselves. Do you see the small businesses not being able to pay their own bills because they're not getting, they can't roll the trucks unless they're getting paid to do it?
Credit lines are getting stretched. Absolutely. The price of fuel has gone up so much, yet your banks that provide working lines of capital aren't responsive to price increases. So they are being pushed to the limit. I will tell you, and I will compliment the community action agencies and DSS. One of the changes in the law that you made was to ensure that vendors are paid in 10 days. That has generally been happening. Sometimes it stretches out a little bit more and vendors get a little tweaked, but for the most part, I would say that everyone's done a really good job with that. The problem is that that when you're getting paid at a 50-cent fixed margin, you eliminated the county differential that added up to 11.5 cents. That directly came out of their pockets. So when you see dramatic price increases, not having that county differential also it makes them more sensitive to steep price increases.
So, and real quickly, so some of the things we're going to start to see is, you know, price of diesel and gasoline is going up. So outside of the petroleum business, you're going to see delivery charges going. But in the petroleum business, correct me if I'm wrong, Connecticut is one of the only states right now that doesn't allow fees being added on to petroleum products being delivered. That's heating oil, propane, and kerosene. Is that correct?
You are correct. In 1979, the legislature prohibited heating oil dealers, propane dealers, et cetera, fuel dealers from charging surcharges. So there is no way to recover if diesel theoretically could be $5 by the end of the week. We cannot charge an additional surcharge to recover those costs, which will put additional pressure on vendors. Now, the majority of dealers don't participate in the program anymore, so their flexibility in pricing is a little bit different than what the vendors are.
And I just think that's one extra thing that we have to look at, because all companies are looking at the delivery costs to get the fuel to the home or the business. But if those prices become so exorbitant because of what's going on, unfortunately, the most vulnerable are the ones who aren't going to get the fuel. And we need to be reactive to that, to the state. Because not only is heating oil going up, it's the cost to run those trucks is going to be going up. So, and we can't recover that, or the dealers can't recover that. So we have to be very careful. And I find that if the fund is flush because it's federal dollars that are coming in, we need to be a little more flexible and see what we can move to make, because once again, those heating dealers are small businesses and they're the backbone of our state. But I thank you for working with us and trying to figure out how to get to the bottom line.
We continue to want to work with you. We just think that this bill would set the efforts that the legislature is engaged in back several years.
Great. Thank you very much. Don't see any other questions. Thanks for being here.
Thank you.
Next, we're going to go to Thomas Burr. Is Thomas in the room? Okay. Carl Mancini. Okay. Mancini.
Okay.
Oh, it was on. You just have to push it again. Yeah. There you go.
Good afternoon, Senator Lesser, Representative Gilchrist, Representative Comey, and Representative Case. My name is Carl Mancini, and I serve as the business manager for Advocacy Unlimited Incorporated, a statewide peer-run nonprofit here in Connecticut. We provide holistic peer-led education, advocacy, and support services in the areas of mental health, addiction, and trauma recovery. Our programs include our recovery support specialist training, our Bridgers program, and our Join Rise Be young adult program in Warmline. We also facilitate support groups such as the Connecticut Hearing Voices Network and Alternatives to Suicide. Every one of these spaces is led by people with lived experience. Before this chapter of my life, I was a pharmacist for nearly 25 years. I built a career around medications and clinical protocols. But when I faced my own mental health and substance use challenges, I learned something important. Recovery requires more than treatment. It requires connection, dignity, and hope. I found that hope through peer support and ultimately through Advocacy Unlimited. Peer support fills a gap that clinical services alone cannot. When I was struggling, what changed my life was not another prescription or treatment. It was someone saying, I've been there too, and I'm still here. This is why I strongly support Senate Bill 87. First, this bill creates a formal advisory structure for nonprofit providers. Too often, nonprofits function as contractors, responding to directives without meaningful input at the beginning of policy development. Senate Bill 87 establishes a consistent channel for communications, ensuring that the expertise of peer-run and community-based organizations inform on policy from the start. That leads to more responsive and effective human services. Second, the bill strengthens the partnership between the state and nonprofits. Organizations like ours deliver essential mental health and recovery services. Yet, we often face administrative burdens and regulatory complexities that strain limited resources. This legislation promotes collaboration and problem solving, allowing us to spend less time navigating bureaucracy and more time serving people. Third, Senate Bill 87 enhances financial stability and predictability. For peer-run nonprofits, uncertainty directly affects staffing and programming. Greater fiscal clarity will help ensure sustainability. Stable nonprofits mean stable services for Connecticut residents in recovery. Finally, and most importantly, this bill gives nonprofits a voice. Peer organizations exist to elevate lived experience. Senate Bill 87 reflects that same value at the systems level. It recognizes that community-based providers are not peripheral to the human services system. We are central to it. At Advocacy Unlimited, we believe recovery is possible and strong partnerships make it sustainable. Senate Bill 87 ensures nonprofit providers have a meaningful seat at the table in shaping policies that affect our staff, our participants, and our communities. On behalf of Advocacy Unlimited and those we serve, I respectfully urge you to support Senate Bill 87. Thanks for your time and consideration.
Thank you. Thank you for your testimony today. I don't see any questions. Thanks so much. Next, we'll hear from Barry Simon.
So good afternoon, and thank you for remaining here during the oncoming weather.
I just want to take this opportunity to testify on Senate Bill 87, an act strengthening nonprofits. I am proud to lead Oak Hill, which is specialty healthcare and special education agency and Connecticut's largest purchase of service provider. When fully staffed, we employ nearly 1,700 employees. We have 150 programs, serve 3,500 individuals, families throughout Connecticut. We contract with almost all of the state human service agencies and are especially recognized as a DDS provider. I want to thank the governor for introducing this important bill, which would create the Nonprofit Advisory Board housed in OPM to advise the governor. Having an advisory board like this would help to identify and address the issues nonprofits face as we contract with the state to deliver essential services. As a provider that contracts with almost all of the health and human service agencies in Connecticut, I can say with great certainty, it's hard to do business with the state. All of the different regulations or reporting requirements for similar services run by the different state agencies create challenges and opportunities lost for us and for the state. So much time, effort, and energy is spent deciphering and creating different reporting for the same type of information and or services. If the state had a board and it could focus on how to collect budget and health data, the state and providers would be in a much better place to grapple with how to manage and allocate resources. Governor Malloy, as you had heard, had created a gubernatorial appointed cabinet for the nonprofit state agencies to grapple with issues and to modernize and strengthen the state's healthcare system. I served on that board. And it was amazing work that was being accomplished to align processes and contracting and debate and create policies and processes that reflected best and promising practices. Unfortunately, because it was never codified into statute, it did not continue to pass this term. Because of my experience in what could be accomplished and the frustration that has been part of this experience, I highly support Senate Bill 87. As proposed, it would make that structure permanent and create opportunity and alignment on many disparate issues. However, I would also like to say nothing about us without us. Please consider adding specific appointments to the board to ensure that it includes representation from across the nonprofit sector. Thank you for this opportunity to testify and appreciate your considering this.
Thank you very much, and we'll take a look at your testimony and your recommendations. Thank you.
Thank you.
All right, next up is Bruce Stovall.
Good afternoon, Representative Gilchrist, Senator Lesser, and Representative Comey. I work for Barry, so you're going to hear a little bit of the same. A little bit about Oak Hill. We were established in 1893 as a school for the blind. We've grown over the decades, and we are currently the largest provider of disability services in Connecticut. We do 65 group homes. We do about 150 student special ed school, various camps, assistive technology center, you name it, we do it. Oak Hill has approximately 1,700 employees, and we are very much in support of this bill. We heartily endorse the concept of bringing back Governor Malloy's nonprofit cabinet structure. As many of you are aware, nonprofits are currently in the midst of a number of critical challenges. These include a massive workforce shortage, Medicaid rates that have simply not kept pace for true costs over many years, skyrocketing liability costs, insurance costs, as well as a number of other issues. I see a number of you have been kind enough to come out to our programs and see our staff. As Barry referenced, this is a great kind of working tool to kind of get the issues out and expedite solutions moving forward. So again, we heartily support backing this bill. Thank you very much.
Thank you very much.
Okay.
Good to see you. Thanks so much.
Good to see you.
Glad we got you guys in and out. Next up is Mary Caruso. Is she with us? Okay. If not, we'll go down to Michaela Fisel.
Hi, good afternoon. Hi.
Afternoon, hello.
Hello. My name is Michaela Fissel, and good afternoon, respective members of the Human Services Committee. I'm really grateful to be here, and I appreciate you being open even in the storm that is upon us. So safe travels home. I am Michaela, and I serve in the role of Executive Director at Advocacy Unlimited. Advocacy Unlimited is the leading nonprofit provider of holistic, peer-led recovery resources in the state of Connecticut. Over the past year, we served over 13,000 community members, and we do this through a grant made available through the Department of Mental Health and Addiction Services. We actually recently received an expansion grant through the Department of Children and Families, and we are now bringing peer support to youth ages 14 to 17 in partnership with our sister organization, CCAR. And we're really excited to be doing this work. So I've been in nonprofit work for human service work for just about 20 years. I started off in direct care for my first decade and then moved into executive administration for the last 8. During my tenure, I've had the really the privilege of working in the margins and organizing resources for our most vulnerable populations of people, who often are underserved in many other sectors of our society. And I say this as a privilege because I've gained valuable insight and awareness of what it takes to really meet people where they're at when they so often have been conditioned to reject services due to a number of factors along their lifespan. So what I'm asking today is that you do support Senate Bill 87. I think this is a necessary next step for our state to advance.
You're fine. Should we keep going? Okay, you can keep going. There's someone else came up on the screen behind you in a different, oh, you can see it. Keep going.
I'm not that person.
Oh, yeah.
And I hope that they can also be heard today. Okay. uh, yeah, I do believe that this is a meaningful next step. The only ask that I'm going to make is that there is, to echo the last speaker, there is seats available for nonprofit representation. And specifically folks who are working in the peer-run organization space between CCAR, Advocacy Unlimited. We do represent a unique service population, and the design and delivery of our services continue to be underfunded, but we're not really looking for more money. We're looking for equal representation. So we can also participate actively and meaningfully in the overall design and coordination of services at the state level. So that is my ask today, and I really appreciate the opportunity to speak in front of the committee today, and thank you so much for holding this opportunity.
Thank you so much. And we'll take a look at your testimony and your recommendations. Appreciate it.
Thanks.
Drive safe.
Yeah, you too.
In a windowless room, I have no idea what's happening in the world, but I believe everything you all are saying. All right, next up is Natalie Shirtliff.
Hello. Thank you for switching up for the in-person folks here because it's a snow day. So I have a companion, my son. My name is Natalie Shirtliff. I am an Associate State Director of Advocacy and Outreach with AARP Connecticut. You have a packed agenda today, and we submitted extensive written testimony covering many of the bills on the agenda. But today, I really wanted to focus on Senate Bill 330 to provide more support to family caregivers. We at AARP do a whole lot to support family caregivers because we know that they're really the backbone of a broken long-term care system. In Connecticut, we have 773,000 unpaid family caregivers that are providing support for their loved ones. And oftentimes, they're folks that are providing care for their older loved ones, but often also providing care for their spouses. So we think that providing compensation for for spouses that are caring for a loved one and providing a significant level of care makes sense. It allows people to stay at home in their communities where they want to be and not need to go to a nursing home because they're getting that level of support at home, while also supporting the caregiver, the spouse, by providing them a little bit of compensation. We often hear from caregivers that have to step down and take less hours at work, do, give up their job, and that can provide, cause a real financial harm to the family. And so we think that this proposal, along with other proposals like a caregiver tax credit, really have an ability to support family caregivers, and we strongly support it. I would also just take a moment to thank this committee for what you all did last year to lower the cost of prescription drugs, and add that we're thankful to see one of the sections in House Bill 5040 would continue that work in lowering the cost of prescription drugs. So thank you.
Thank you. Thank you for the work you do, and welcome to your guest. Enjoy the snow day. Thank you.
Thank you.
Next up is Christopher Blake.
Hello. I wanted to speak for Medicaid state, and other states that passed it successfully, and I don't know why they're saying it's going to take 5 or 7 years to transition when I should be doing this decades ago, when they didn't have a cost of living to automatically transition, is not be in limbo on the cap for how much you can save. And it's not your responsibility of federal benefits, only the same problem there too. So it's hard when they have like a cap and you're working and it's going to, you go past that point. So it's kind of, a lot of people with disabilities don't want to work because of how complicated it is to stay at that point, or the state agencies don't have proper communication skills to contact you directly in a proper plain language for even your staff to help you to fix the problem. So you have to go act on it very quickly when you're trying to figure out what the problem is and how to approach it correctly. If they had a higher cap or no assets, people could actually attribute and get a job and actually go be a taxpayer. Is not worried about if they're going to get some assistance and get a penalty in the back end. So I recommend it should be transitioned in 2 years, not in possibly 7. Could say 5, it's going to be 7.
Very good point.
So, echo into community choice. If you guys don't make a plan, it will end up being a giant waiting list on a different service mechanism, or they to go directly in nursing homes. So it's be one of the two or both. Oh. Thank you for your time.
Thank you. Thank you for being here and thank you for your testimony. Representative Case, go right ahead.
No, thank you. And I think you've been here all morning into the afternoon, and Governor's office actually said that they're working on a plan, because you're absolutely correct. If we do away with certain services, the waiting lists are just going to grow. And we have so many waiting lists in this state. We're trying to eradicate the waiting lists. We've actually put people in the governor's office to oversee the autism and the IDD waiting list, because the more things we do to programs, those waiting lists do grow. And we don't want that. We want to get rid of them so people can get services, because that's what we do. We're here to take care of people. But I appreciate you coming forward and sticking around and putting it on the record for us. But thank you.
And like, honestly, I think the governor only think of a ticket item, how much it's costing, not what it actually does and what what the purpose it
You're
is.
exactly right. And that's what our job is, to make sure that that office knows that it's about people. And that's why we're here on Human Services, because things do cost money, but we have to justify and tell them that it's people's lives that we're here to work on. So money doesn't do anything when it's somebody's life that we have to worry about. So thank you. I
Yeah,
really
highly
that.
appreciate it.
Thank you so much. I appreciate you being here. Next, we will hear from Jean Carl Casa. I know, I can never say it.
Thank you, Madam Chairman, members of the committee. My name is John Carl Casa. I am President and CEO of the Connecticut Community Nonprofit Alliance. I'm here to testify in support of Bill 87 that would create a nonprofit advisory board at OPM to advise the governor on matters concerning health and human services providers in particular and nonprofits in general. There are hundreds of nonprofits that contract with the state to provide services, and they do it so the state and local governments don't have to. They're high quality, they're cost effective, but with so many contracts affecting so many organizations and different state agencies, problems and confusion arise. It is inevitable. And we can come here, and the state agencies can come here, and we can complain to you about each and every one of them. But this would create a forum that might avoid some of that. It was the experience that happened when Governor Malloy had the nonprofit cabinet on health and human services. That was never codified in statute. This proposal, and we thank Governor Lamont for it, would codify that organization or something similar to it in statute. It can make the nonprofit state relationship work better. We do ask that, because there are so many sectors that affect that within the nonprofit health and human services sector generally, there's so many different ones. We ask for slots named for various providers. So for instance, a behavioral health provider representative would be there, someone representing health and human services organizations, someone representing IDD groups. We also support the remaining sections of the bill, also part of the governor's proposal. We thank you, and we urge you to amend it as we suggest and favorably report it.
Wonderful, thank you. And I assume your recommendations are outlined in the testimony, and so we can
Yes.
just go right there. Wonderful. Let me make sure. All right, no questions. Thanks so much. Next up, Sal Murata. Is Sal with us? Maybe transitioning to the, okay. Chris McNabo.
Good afternoon, Representative Gilchrist and members of the Human Services Committee. My name is Chris McNabo, CEO and founder of Horizons, one of the private nonprofit agencies providing essential services to our citizens with developmental disabilities through contracts with DDS. We are in our 47th year and serve over 1,600 people with developmental disabilities statewide. We employ about 270 year-round staff and an additional 140 seasonal staff. Nonprofit agencies are businesses. They need to operate as businesses and be able to project costs and expenses into budgets they develop every year. Some of the challenges to that are the changes that come with new administrations. My hope is that an advisory board, as outlined in Senate Bill 87, will bring to the governor and OPM some of these issues to mitigate, for them to mitigate where possible. Having served on the Youth Camp Advisory Board to DPH and now to OEC for over 25 years, I have seen firsthand how valuable an advisory board can be. Community members serving are usually those in the trenches with firsthand experiences on the issue. The previous administration created a gubernatorial appointed cabinet that worked through some of these issues and made some real progress to modernize and streamline the system. One example of their work that we now use is the 8-month budgeting process done by all who get funds from state agencies. Unfortunately, because it was never codified into statute, the cabinet did not continue. So we support SB 87 because it will make the structure permanent. Thank you very much for your time.
Thank you so much, and thank you for the work you do. Good to see you.
Yeah, it's good to see you too.
Drive safe. Okay. Is Sal with us? All right. Going to Christine Cohen. Megan Gorman.
Not just on you, I was on other hearings as well. Good afternoon, Representative Gilchrist, Representative Comey, and all representatives and senators tuned in on Zoom. Good afternoon at this point. My name is Megan Gorman, and I am the Government Relations Coordinator for CMHA, Community Mental Health Affiliates. We are a large behavioral health provider that serves the entire state, truly. We're focused in central Connecticut, but we serve over 7,500 individuals annually. That's a little over 65,000 therapy sessions a year. We have in our employ about 300 individuals, and the need for the services that we provide don't stop, essentially. Now, I'm here today to testify specifically in support of SB 87 and Act Strengthening Nonprofits. Similar to other individuals who've come before me, we thank Governor Lamont for introducing this important bill, which will primarily create a nonprofit advisory board within the offices of OPM. We have and will continue to acknowledge the longstanding reality for nonprofits, which is that despite modest adjustments and efforts to increase funding, recent changes do not compensate for the chronic and persistent underfunding of critical nonprofit behavioral health services. There are further issues with duplicative reporting requirements, multiple audits for numerous agencies, and even additional or even random requests for information or data outside of our contractual obligations for which we are expected to meet, despite the lack of staff, time, or means to comply. While I and every other nonprofit leader will continue to urge you to increase funding for vital nonprofits in the amount of $155 million in fiscal year 27, I also want to encourage you to establish means for nonprofits to have a greater impact and ability to inform legislative decisions about our funding and services. This nonprofit advisory board would help to identify and address the issues that we face as we contract with the state to deliver these essential services. As it was stated before, former Governor Malloy created a gubernatorially appointed cabinet with nonprofit and state agency representation that worked to address collectively issues that nonprofits face while addressing the funding concerns. Unfortunately, because it was never codified or put into statute, it did not continue past his term. We support SB 87 because it would make this structure permanent. As I said, stagnant, inadequate funding combined with the ever-increasing demand continues to erode our ability to fulfill our mission. People's lives and livelihoods are at stake, so that while we have the skill, experience, and compassion to do this work, what we need from you is supportive action on SB 87 and other legislative matters geared towards appropriately funding nonprofits and allowing us to engage meaningfully in the budgetary and regulatory decision-making process. On behalf of the clients that we serve and my colleagues at CMHA, I thank you again for your time and the ability to testify and encourage your positive support of SB 87.
Thank you so much. Thank you for your testimony and the work you do.
Thank you very much.
Next, we are going to go to Maria Content Skinner. Not in the room. How about Mike Van Vlaanderen?
Good afternoon, hardy souls. Thanks for staying. My name is Mike Van Vlaanderen. I am employed with Reliance Health, where I've been for the last 35 years. We have 250 staff. We serve over 1,000 folks. Our primary funding is through DMS and DDS. I'm here to speak in favor of Bill 87, and you've heard many of my colleagues talk in favor of it. I've not heard much pushback from anybody that's been up here, so hopefully it's a smooth ride from here on out. But just to share with you some of the challenges we face, and I'll wrap up with a caveat on what the group should look like at the end. You both know this because you sit on other panels, but chronic underfunding over the last 35 years for nonprofits, failure to address rising costs associated with running a business in Connecticut, which nonprofits are businesses, rising costs of transportation, new costs that did not exist when I started, technology, EHRs, cybersecurity, software licenses, increase in healthcare costs, insurance for our staff, workers' compensation costs, legal fees. I could go on, but you've heard it from others before I spoke. But just to sort of piggyback on what John Carl said, on what Barry said, and what others have said, the makeup of the board does seem a little skewed, heavy towards state agencies and OPM staff. I count, if I'm correct, 12 heads of state agencies, 2 OPM staff, and only 1 dedicated person representing nonprofits. So clearly that creates a bit of a power dynamic. So if that could be balanced out a little better, and I have some recommendations in my testimony, which I'll submit later today, and I'm sure John Carl has some recommendations as well as Barry. So that would be my only ask, is that the structure of the group should be a little more balanced.
Wonderful. Thank you.
Yeah, thank you.
Appreciate it. We
Yep.
will take a look.
Thanks.
All right. Next up is Alyssa Go-To. I'm sorry, I'm messing up names today. Go-To-T. Okay, nope. How about Heather Latora? Okay. Connor Reck.
Hi. Good afternoon to the chair, Representative Gilchrist, Vice Chair Comey, members of the committee. My name is Connor Reck. I'm here today on behalf of the Insurance Association of Connecticut. The IAC is a state-based trade organization representing Connecticut's property and casualty insurance and life insurance industries. The IAC is opposed to Section 2 of SB 87, which concerns auto liability insurance and volunteer drivers for nonprofit organizations. We would first like to thank the committee for including the word solely in the language of Section 2. The inclusion of solely acknowledges that underwriting decisions are multifactorial and actuarially driven, and that insurers must retain the ability to assess actual exposure to losses. Still, Section 2 creates significant operational concerns that warrant reconsideration. Auto insurance operates on actuarial principles. Insurers rely on objective factors such as mileage, vehicle use, frequency of passenger transport, driving patterns, claims history, and other exposure indicators to determine appropriate premiums. When a driver's exposure changes, insurers must have the ability to evaluate and price that risk accurately. If insurers are constrained in adjusting premiums to reflect increased exposure, particularly when volunteer drivers become regular or substantial, costs do not disappear. These costs are redistributed across the broader pool of policyholders. At a time when auto insurance premiums are under pressure due to inflation, increased repair costs, litigation trends, additional statutory restrictions on underwriting flexibility may exacerbate these concerns. The IAC is also concerned about market stability. The nonprofit insurance market is already not as competitive as other insurance markets in Connecticut because of the heightened risks associated with nonprofit operations. If prohibitions on non-renewal are enacted, or if insurers are not permitted to accurately price for risk, the results may lead to further contraction of the market. Legislative policies that restrict underwriting discretion may discourage participation, reduce competition, and ultimately make coverage harder to obtain. it is important for this committee to be aware that the IAC served on the Nonprofit Liability Insurance Working Group, which was convened to study market conditions and develop recommendations concerning coverage issues among nonprofit organizations in the state. At no point during the working group's meetings was a proposal such as Section 2 raised or analyzed. Because this proposal was not vetted nor recommended through that collaborative process, we respectfully suggest that further stakeholder review would be appropriate in lieu of this policy proposal. So in closing, we reiterate our appreciation of the inclusion of SOLI and this committee's thoughtful consideration on this issue. However, even with that language, Section 2 risks interfering with actuarially sound underwriting, increasing cross-subsidization among policyholders, and further shrinking an already limited nonprofit-related insurance marketplace. That being said, the IAC is more than willing to meet with members of this committee, along with OPM and interested stakeholders, so that we may find common ground. Thank you.
Thank you so much. I do have a question. OPM mentioned that this has been done in other states. Do you have any information about how it's worked or not worked in those states?
I do not have that information available, but I'd be happy to get that to you.
Yeah, it'd be helpful to know from your lens.
Absolutely.
Okay.
Yep.
Thank you. Yep, Representative Comey.
Yes.
Hi, thank you.
Hi.
Thanks for coming.
Yep.
So you were just specifically talking about which bill?
87.
87.
Active nonprofits, yes.
Okay.
Section 2.
Okay. What about section 3?
We're not taking a position on Section 3 or 4. We don't do health insurance. The IAC is not. We're just property casualty and then life
Okay.
insurance. Yep.
All right. Thank you.
You're
Thanks for
welcome.
clarifying.
Yep.
Wonderful. Thank you so much.
Thank you. Have a wonderful day.
You
Be
too.
safe.
You too. Next is Catherine Valeda. I don't see. Matthew Barrett.
He's on his way.
Okay. Okay. We did fly through the in-persons. Okay. And then Carrie Dyer. Great.
Hi, good afternoon, everyone from the Human Services Committee. Those online, thank you for allowing me to testify early. I drew the last number, so this is a nice surprise. My name is Carrie Dyer. I am the Chief Executive Officer for Reliance Health in Norwich. We are a nonprofit mental health provider. We contract with both DEMIS and DDS. We also lease from the Department of Administrative Services. So we are one of the organizations that would benefit from SB 87 with the nonprofit advisory. As you've heard from all of us from each time we testify, there's value to hearing direct stories and creating relationships. Everything we do as a nonprofit provider and working with individuals is built on relationships and getting to know the nuances of each person we serve. This is what this committee would serve to do for us. We have a tremendous amount of institutional knowledge that we could share. I myself have spent almost 32 years in this business alone and can share insights that others possibly could not. I'm just very in favor of having an opportunity to have open and clear communication, to share the different experiences that we have. In the grand scheme of things, Reliance Health is relatively small. We serve 1,000 people. We have 250 employees. We serve all of Eastern Connecticut. But compared to Oak Hill, we're tiny. But our experiences are just as valuable and just as important for the state to understand as we are a contractor. So I'm speaking in support of that. I think anytime you can build relationships and share stories, there is tremendous value. Thank you for your time.
Wonderful. Thank you so much. Thank you for your testimony. Just for those to know, the building has not officially closed. There are committees closing early and turning to virtual. We have not made a decision yet. So we did get through most of the in-person. I will say if someone arrives who is testifying in person, please just let the clerk know and we'll have you go. But at this point, I'm going to go back to our remote folks. And so thank you to all those who came out in person. Please drive safely. Moving to number 22, thank you for the folks online for your patience. Stephen Gorelli.
Thank you. Good afternoon, Senator Lesser, Representative Gilchrist, and members of the Human Services Committee. My name is Stephen Girelli, and I am the proud president and CEO of Klingberg Family Centers, having worked here for over 35 years. Klingberg is based in New Britain and provides Central Connecticut with over 20 programs and services, including child welfare, special education, and children's behavioral health. Our staff of nearly 300 employees serves roughly 5,000 people annually. Thank you for the opportunity to testify in support of Senate Bill 87, an act strengthening nonprofits. And thank you to the governor for introducing this important bill, which would create a nonprofit advisory board housed at OPM to advise the governor. Having an advisory board like this would help to identify and address the issues nonprofits face as we contract with the state to deliver essential health and human services. Governor Malloy created a gubernatorially appointed cabinet with nonprofit and state agency representation that worked through these issues and made real progress to modernize and streamline the state's health and human services system. Unfortunately, because it was never codified into statute, it did not continue past his term. We support Senate Bill 87 because it will make the structure permanent. I had the honor of serving on Governor Malloy's cabinet on nonprofit health and human services and saw tremendous value in that initiative in a number of ways. For one, the relationships and collaborations forged by the cabinet between the provider community and state personnel was invaluable. In part, the communication between the public and private sector allowed challenges and issues experienced by either to be brought to the awareness of the other. On a more practical level, the cabinet was able to identify concrete obstacles to the effective delivery of human services to our communities and was able to generate practical solutions. These covered a range of issues, including funding, licensure, and financial and programmatic reporting requirements. And they were always effectively addressed through the public-private partnership that grew to characterize the cabinet's culture and processes. In the years since the dissolution of the cabinet, it has been more difficult to surface and resolve issues that negatively impact nonprofit service delivery in the state. To be clear, that is not a comment on the investment of either party in eliminating those barriers, but the absence of a forum of multiple stakeholders designed to efficiently and effectively solve these problems is a limitation. I urge you to support Senate Bill 87 and request that you consider adding specific appointments to the board, as John Carl and others have suggested, to ensure that it includes representation from across the nonprofit sector. Thank you for the opportunity to testify, and please support Senate Bill 87.
Thank you very much. Thank you for your testimony and for being here today.
Thank you.
Have a good afternoon.
You as well.
Next, we'll have Ed Schreiner.
Good afternoon, Representative Gilchrist and members of the Human Services Committee. My name is Ed Schreiner. I'm a registered pharmacist, pharmacy owner in Waterbury, Connecticut, and currently I'm Vice President of Network Development for Northeast Pharmacy Service Corp. We provide business support services to 115 Connecticut pharmacies. I'm here today to speak in support of HB 5354 and Act concerning Medicaid pharmacy audits. In 2010, Section 17B-99 of state statutes were revised Medicaid state audit guidelines to make clear that clerical errors are not willful violations without proof of fraud, and that extrapolation should only occur when errors exceed a 1.75% threshold. In practice, that threshold is now outdated and is producing disproportionate penalties for pharmacy providers. I personally worked with pharmacies facing extrapolated audit findings ranging from $37,000 to over $700,000, often driven not by fraud or improper dispensing, but by technical, clerical, or documentation issues. And I'd like to give you a couple of examples. In one audit, just 9 out of 150 claims were cited because the prescriptions were written on non-tamper-proof prescription blanks, which is a federal requirement placed on prescribers, not on pharmacies. Those claims totaled about $7,000, but that pushed the pharmacy over the 1.75% threshold and triggered a much larger extrapolation penalty. High-cost medications further distort audits. Connecticut Medicaid reimburses using National Average Drug Acquisition Costs, or NADAC, plus a dispensing fee. So the ingredient cost, often thousands of dollars, is largely a pass-through amount, not pharmacy profit, yet extrapolation is calculated on the full reimbursed amount, not just the dispensing fee. A small number of high-cost drugs can easily push an audit over the threshold, even when the pharmacy's actual profit is only reflected in the dispensing fee. In another audit, nearly the entire sample was cited because the pharmacy had not properly configured its software to retain proof of counsel and signature data. These were computer setup issues, precisely the type of clerical errors the statute was meant to address, yet they triggered extrapolation for that pharmacy. No other pharmacy payer in Connecticut applies extrapolation in the manner that we see with Connecticut Medicaid provider audits. Medicaid provider audits should ensure compliance with and program integrity. Audits are not meant to generate revenue to fund a line item in the state budget. I respectfully suggest that applying a fiscal note to this legislation is inconsistent with the purpose of a provider audit, as it incentivizes the department to maximize findings. Recoupment of specific non-compliant claims may be appropriate, but compounding repayment through extrapolation for isolated clerical errors or technical errors is excessive and inconsistent with legislative intent. Extrapolation should be reserved for sustained patterns of significant errors or evidence of credible fraud. Also, Section C of this bill seeks to establish a grievance process for pharmacies to challenge drug cost reimbursement, but because DSS follows NADAC pricing, which is established at the federal level where Connecticut doesn't have oversight, I don't think this section is appropriate for this bill. This grievance process would only impact a small number of drugs where a NADAC price has not been established, and would be more appropriate in a bill concerning PBM oversight for non-pharmacy claims. In conclusion, Connecticut Medicaid pharmacy audits require distinct consideration when compared to other providers. Under NADAC, drug costs are largely pass-throughs, not pharmacy profit, yet they drive inflated, extrapolated penalties. HB 5354 helps restore the law's intent by ensuring clerical and technical errors do not result in disproportionate financial consequences. And I respectfully urge you to support passage of HB 5354 and request reconsideration of the outdated 1.75% threshold as it applies to pharmacies, so it better reflects the economic realities of pharmacy and reimbursement that I've outlined today. Thank you for your time and consideration and allowing me to testify.
Thank you so much. Thank you for being here and for your testimony today. Next, we'll hear from State Representative Tracy Mara.
Thank you so much. It's fitting that I'm following Mr. Schreiner there. I thank you to Rep. Gilchrist and Rep. Case for being there, and for the committee for hearing this. Again, I am here in support of HB 5354, an act concerning the Medicaid audit process. This proposal was raised last year. And I am happy that you brought it forward again. The current process has been allowing disproportionate outcomes that really harm our providers who are acting in good faith. The issue before us is not whether fraud should be addressed. It absolutely should. However, the findings identified in these audits are generally not intentionally fraud, but errors. And in those cases, I really believe that education should be the first step before we jump to fines. And then if we do have to jump for fines, those fines need to be based on not on the medication cost, but the services that are provided by the pharmacist. As was mentioned, my local pharmacy, Greaves Pharmacy, was put with a $700,000 fine that would have completely shut down this pharmacy. They were able to work it back to somewhere around $100,000, but none of these issues were consequential in the care of patients. Nobody got wrong medication. Everybody, and if you go to Greaves, you'll know everyone has the option to talk to the pharmacist. They're right there. They are extremely active in our community. So to see something like this affect this pharmacy is really frustrating. So I'm asking first that we look at education first as the first step. And then second, when we look at fines, we understand that pharmacy audits are very different from other audits because there is the medication that already has a price that the pharmacy is incurring on there. And you really just need to look at that pharmacy fee that's above it. Greaves Pharmacy, you will notice, is actually not on the list. They did submit testimony, and I will tell you why they are not on the list. The head pharmacist there is working up to 60 hours a week because he has lost 2 pharmacists because he has to pay $25,000 a year. He was unable to give his pharmacists raises. He's got new people that he is trying to train. And this is what happens when you don't support our local businesses. So I am begging and pleading that we all come to the table and we look at fixes for this, because now we are seeing the consequences of decreased healthcare, the consequences of not being able to support providers in our community because of the overreach and overstep of our government. Thank you again. I look forward to working with you on this bill, and I really appreciate you hearing it again.
Thank you so much, and I look forward to working with you as well. And hope you enjoy your snow day at home.
Thank you. Thanks for letting me be remote.
Yeah, thanks so much. Next, we will hear, is Thomas Burr on Zoom or in the room? Okay. Mag Morelli, go right ahead.
Thank you. Good afternoon. My name is Mag Morelli. I am the president of Leading Age Connecticut and Rhode Island, a membership association representing not-for-profit and mission-driven provider organizations serving older adults across the continuum of aging services. On behalf of Leading Age Connecticut and Rhode Island, we submitted testimony in several bills, and I just want to start by clarifying we did submit testimony in support of Senate Bill 87, even though we are not the nonprofit sector that this is geared towards, and also House Bill 5357 concerning the residential care home rates. And we appreciated the commissioner's comments saying that she was willing to work on stabilizing those rates. We also are not opposing House Bill 5040. In Section 5 of this bill, DSS is proposing to correct a drafting error in the statute passed last session, which provided increases to nursing home rates. The intent of the original bill was not to include administrative nurses' wages and salaries, but that's not how it was drafted. And so this bill attempts to reverse that. We are not opposed because we know that the original intent was not to provide funding for these administrative positions. We do, however, believe that these reimbursement policies are short-sighted. Strong leadership and management are foundational to the quality, stability, and integrity of every nursing home. While frontline caregivers provide invaluable hands-on care, it is the leadership team that sets the tone, establishes the culture, ensures regulatory compliance, manages financial stability, and creates the environment in which high-quality care can flourish. If we expect nursing homes to deliver safe, high-quality care, we must recognize that strong leadership is essential. We are opposing another bill. We are opposing Senate Bill 328. This bill would require that 80% of all revenue received by a nursing home be used to pay for nursing personnel who provide hands-on care. Respectfully, we cannot support this bill. The proposal will lead to unintended operational challenges which do not acknowledge the realities of nursing home care and services. Nursing home care is highly dependent upon nurse and nurse aid services, but also upon social work, therapy, recreation, dining, and housekeeping services. In addition, meals, laundry, linens, heat, and hot water all must be paid for through these payer sources. Regarding the Medicaid revenue received, Connecticut has a cost-based nursing home rate system that has transitioned to include an acuity-based component. By its very nature, the acuity-based component prioritizes the cost of direct care staff, and the new system was designed with staffing concerns in mind. The system was fully phased in, and nursing homes that invested in high levels of direct care staffing saw their rates increase. Nursing homes that did not make this investment may have seen their rates fall. Also, you may be aware the governor's proposed further revisions to this acuity rate system, and this process will involve another phased-in period. We ask the state allow the acuity-based system to work as intended without any additional mandate being placed on it, especially now that further refinements will be made. Thank you for the opportunity to testify. I'd be happy to answer any questions.
Thank you so much, Mag. So good to see you. And thank you for your testimony. I don't see any questions. Have a great day. Next is Cal Patel.
Good afternoon, Senator Lesser, Ranking Member Case, and Representative Gilchrist, and members of the Human Services Committee. My name is Cal Patel. I am the board member of CARCH, Connecticut Association of Residential Care Homes, and an administrator of Essex Village Manor, a 33-bed residential care facility in Connecticut, Essex, Connecticut. Residential care facilities serve Connecticut's most vulnerable citizens, the frail elderly and individuals navigating mental and substance abuse challenges. We provide their housing, their food, their medication oversight, and their safety. The state asks us to do this all on an average about $100 a day less. In 2026, that's simply not enough to maintain a dignified standard of living. Our residents are almost entirely state funded. We have, as an industry, very little to no private pay residents, and we have no residents to help, no other sources of revenue to help us balance cost or shift cost. I did submit a written testimony, but I wanted to specifically highlight a few things. I wanted to specifically highlight the need for the fair rent adjustment. Our current rate is $3.10 cap, and that rate was established in the 90s. That desperately needs to be looked at. We cannot maintain a commercial facility at $3.10, a cap that was issued set in the 90s. Essex Village Manor is an older facility specifically. Like many older homes, our physical bones need help. We have urgent need to update resident quarters to ensure comfort and privacy, our kitchen facilities to maintain modern safety standards, and general infrastructure to pass rigorous state inspections that we undergo. Currently, we virtually have no margin to make these repairs. We are often forced as an industry to choose between rising food costs and fixing leaky roof or aging HVAC system. Beyond the building, we also need to support our staff. HB 5357 provides an inflationary increase and updates to the administrator's salary. Without these, we cannot pay the competitive wages needed to keep the staff who built a deep and life-enhancing relationship with a lot of our residents. High turnover is expensive and destabilizing for a vulnerable population. We must address this. It's been a problem for a while. Residential care homes are the most cost-effective solution for the state, but we are being squeezed to a breaking point. We are the safety net, but that net is frying. Rates haven't kept pace with the reality of running an older building in 2026. I urge you to, again, please support HB 5357 so we can keep our doors open and staff paid fairly and keep our residents safe and in a well-maintained home. I appreciate the opportunity.
Thank you so much for being here and for your testimony.
Thank you.
Next, we'll hear from Paula Ryan.
Hi, good afternoon. Can you hear me?
Yes, we can. Go right ahead.
All right. I am Paula Ryan from Ryan Oil Company in Hamden, Connecticut, and I'm here today to oppose HB 5355, the bill concerning the fuel assistant pricing. I can tell you right now, everything that Mr. Chris Herb said before, I agree 100% with. He mentioned the price increasing over the weekend. He did not mention the price increasing that we saw already today, which was 3 times. I just received the update for us to deliver if we get any authorizations for Lehigh program, and the more price, which we chose to go off of, is 20 cents. Yes, 20 cents less than the 50-cent margin that they give us for the more price. For what I can buy the oil for, it's 20 cents less than that. So there's a big problem here. As Chris said earlier, we are going off of several days prior in order to get the price that we need so we can figure out how many gallons of oil we deliver our customers. This bill is very concerning if it passes. It was a very difficult decision this year to stay in the program. The owner of the company and myself, the owner is my son. Previously, the ownership of the company was my husband. this is a big question whether or not we're going to participate and continue to participate for the remainder of the year. We cannot go out at a loss. It reminds me of a poster my mother used to have by her desk when she was still working in here with us. And it said that this is a nonprofit organization. We didn't plan it that way, but that's what happened. I have bills to pay, I have employees to pay, I have insurance to pay. And to get penalized because we're a family-owned business, and for DSS to say that we're trying to take money out of our clients' pockets is utterly ridiculous. We do everything that we can, as well as all the other family-owned businesses, such as myself, do to help our customers, to keep them warm, to keep the hot water running. And DSS, as far as I know, any other utility company that's out there, they get their full price. They pay the utility companies what you pay personally, what I pay personally, but yet the heating, I just want to say that this will hurt. If this passes, this will hurt not just the industry, it will hurt the consumers that are getting the oil.
Thank you, Paula. Thank you very much. And
Thank
we
you.
will consider your testimony. Have a great afternoon.
Thank you, you too.
Is Amanda Pasquielko with us? All right, Andrew Bate.
Members of the Human Services Committee, I respectfully request that 2 amendments be made to House Bill 5040. First, language that prohibits the governor or the Department of Social Services from terminating in any way the Community First Choice program. Today, we have heard about the difference in cost between an average CFC plan, $64,000 versus $92,000 per year per resident in a nursing facility. I have read in the governor's budget that he hopes to save about $100 million by state fiscal year 2030 by eliminating CFC. However, what I have not heard is an analysis of the cost to the state if every one of the 7,250 members on CFC were forced back into a nursing facility. Despite assertions to the contrary, as a person with a disability and a former social worker, I can tell this body that this can happen. It is not hyperbole. I've also heard, I've also not heard about what will happen to people, new people that need services, people like Sandra Roberts, who we heard from earlier today. My best guess is that she'll be trapped in a nursing home. Second, I would respectfully request that the bill be amended to require the Commissioner of the Department of Social Services to file an amendment to the Community First Choice State Plan Service. Today, we heard the Commissioner of DSS saying that it is indeed possible to amend CFC to include agency-based services. The Commissioner also said that it was not possible to implement this option because it would require a modification of the department's medical management information system. This may be the case. However, I follow the medical assistance oversight committee meetings, and my understanding is that a pool of money has been allocated and additional monies could be drawn upon to upgrade the Department of Social Services line, information line, phone system, and hire more personnel. I would respectfully suggest that updating the medical management information system be added to the upgrades. Additionally, the Commissioner suggested that we need to move to another waiver program because hiring a PCA is difficult for some As a person with a disability and someone that hires personal care attendants, I know this is true. But that is why people that is why people should have a choice to hire agency-based service. This rationale should not be used to eliminate CFC, in my opinion. CFC is a cheaper alternative to nursing homes on average, and Connecticut residents overwhelmingly want to remain in the community. Why on earth are we considering eliminating CFC? Thank you.
Thank you, Andrew. Thank you for being here and for your testimony today. Next, we're going to go to Marianne Langton, who's in the room. Oh, in a minute. We'll come back. You take your time. Okay, then we are going to go. Got everything. To Christian Damiana. Are they with us? How about Phil Stahlboger? Marcy Russo? Who did? Okay. Christian Damiana.
Thank you for your patience. I was waiting to be promoted. Good afternoon, Representative Gilchrist, Senator Lesser, members of the committee. My name is Christian Damiana, and I lead the Connecticut Parity Coalition, a group of 20 statewide organizations representing clinicians, patients, and advocates, united around making sure that when Connecticut law says mental health care must be covered the same as physical health care, that promise is actually kept. I'm here to talk about clawbacks. There are 3 bills currently pending through the legislature. I know you're considering SB 87 and Human Services today. We've submitted detailed written testimony that includes a provision-by-provision comparison of all 3 bills, along with a proposed amendment for reconciling those 3. I'd strongly encourage the committee to review it, but I'll start by telling you what's happening on the ground. Clawback happens when a therapist sees a patient, the insurer authorizes the visit, the insurer pays the claim, weeks go by, months go by, sometimes more than a year goes by, and then that same insurer sends a letter demanding the money back, often with a vague explanation, and often because of the insurer's own administrative error, not the providers, the insurers. Under current Connecticut law, insurers can do this for up to 18 months after paying a clean claim. That's one of the longest windows in the country. And the process that follows is just as bad. Providers are forced to navigate time-consuming, paper-based appeals, all while facing the threat of automatic payroll deductions if they don't respond fast enough. In this case, the insurer is the judge, the jury, and the debt collector all at once. It's not a niche issue. Connecticut Psychological Association survey found 68% of psychologists in our state had experienced a clawback, and more than half of those demands arrived over a year after a service was provided. And clinicians across our coalition are experiencing the same thing. Clawbacks are a routine fact of life, and they shouldn't be. The damage goes beyond individual providers. Every clawback that destabilizes a small practice makes it much harder for that clinician to justify staying on insurance panels. And we know when providers leave networks, it's patients who pay the price. All 3 bills before you would improve current law. They all shorten the recoupment window, add procedural protections, and require that repayment demands be paused while appeal is pending. We support all 3. But I want to be direct about this. No single bill checks every box. Each one has strengths the others lack. SB 341 and 87 bring the clawback window down to 12 months. 87 also extends protections beyond contracting health organizations to cover all insurer types. That's critical because current law has a gap that leaves many providers unprotected. But SB 87 also weakens notice requirements by dropping certified mail. It sets no deadline for insurers to respond to appeals and includes no consequence if they simply ignore you. HB 5377, on the other hand, has the strongest procedural framework of the 3 within electronic appeals process. because in 2026, providers should not have to fax an appeal. It also gives insurers 12 business days to respond, and if they miss that deadline, the appeal is resolved in the provider's favor. That's real accountability. In our written testimony, we lay all of this out with a detailed table and propose amendments that combine the best elements of each bill: the 12-month window, the broad entity coverage, and the strong procedural protections. I'd encourage the committee to look closely at these proposed amendments and at this comparison as you work to reconcile the three proposals, because the details really do matter here. I'll close with this. Clawbacks are one of the clearest examples of an insurance practice where the rules are written entirely in the insurer's failure. They get to make the error, demand the money back, set the timeline, and control the appeals process. These bills give providers a fighting chance. So the Connecticut Parity Coalition urges the committee to advance strong, comprehensive clawback reform. Thank you.
Thank you so much. And we will take a look at your testimony. Really appreciate you being here and for your advocacy.
Thank you, Representative.
Great afternoon. All right. Now we will go to Marianne and Patty. Come right up. Good afternoon. Oh, you just have to push the button. Sorry. Thank you.
Hello, Senator Lesser, Representative Gilchrist, and distinguished members. My name is Marianne Langton from West Hartford, and I ask Patty Ellis from Windsor to read my statement that I have prepared. My life has been upside down ever since the governor gave his State of the State address to the Connecticut General Assembly on February 4th. One of his proposals is to eliminate Community First Choice, which is a Medicaid-funded state option made possible by the Affordable Care Act. This allows eligible individuals needing institutional level care to receive help from personal care assistants, PCAs, and support services at home instead of living in a nursing facility. As of today, there are 7,250 people who rely on this, myself included. As a woman with a physical disability requiring assistance for all basic activities of daily living, I have been on CFC since the beginning of this entitlement. I am also proud to say I was one of the principal contributors to the original writing of the state entitlement, and now I participate on its advisory committee. This program has enabled me to live in the community with 76.25 hours of personal assistance per week, and as a result, to be a very productive disability advocate fighting for civil liberties throughout the state. We can talk about my quality of life with the freedom I have with PCA assistance versus being stuck in a bed in a wet diaper waiting for assistance behind 3 other residents in a nursing home. How would you like to live like this? Without this vital program, I will not be able to live in the community, and I will be stuck living in a nursing home at an approximate cost of $12,000 per month versus the $7,600 per month it presently costs for me to live in the community. I know I would not. Marianne says, and I would get kicked out of that nursing home within 24 hours. I know I would not get the support I will need in a nursing home because I require many more hours than the allotted time for nursing home patients. Nursing home residents get limited one-on-one time, a maximum of 3 hours if you're lucky. I require a minimum of 8 hours a day of one-on-one care. I do not belong in a nursing home wasting away. I belong in the community, period. This issue also affects personal care assistants. For them, this is income and job stability. For us, it is independence and trust. We spend so many hours together that they truly learn to care about our lives and what we do. Disrupting these services impacts both sides of that relationship, the individual receiving care and the worker providing it. To demonstrate the relationship between the employer and employee, my PCAs even came to my brother's calling hours. I was blown away with how much they cared about me at this challenging time. Help me stay in my own home in the community where I belong. Don't lock me away.
Thank you so much, and I certainly enjoy you two as a duo, so.
Thank you.
Thank you. All right, have a great afternoon. Safe travels. Thank you so much for your testimony. All right. Next, I tried.
I was wondering
Oh.
who was next. That's why I'm.
Yes, go right ahead. I didn't realize.
That's fine. Thank you. Good afternoon. My name is Patty Ellis, and I am a personal care assistant working under Community First Choice, also known as CFC. This program is under threat of being completely cut as per HB number 5040. My job is on the line, as well as the jobs of thousands of others like me. Working as a PCA for the past 6 years has had a profoundly positive impact on my life. I take pride in helping create accessibility and stability for someone who deserves the same freedom and quality of life as anyone else. I work one-on-one with Marianne Langton, who currently relies on CFC to live in her home and remain a truly active part of her community. Marianne was closely involved in the establishment of CFC in Connecticut and continues to strongly advocate for the civil liberties of all people day in and day out. In many ways, I have learned so much from her, and it is extremely difficult to picture such an active individual residing in a nursing home, to say the least. People with disabilities have been taking on this fight for their own civil rights for so many years, and with this cut, Connecticut will be undoing this progress, which was hard fought for. I'm here to strongly urge you to reject cutting CFC. The plan for those losing this entitlement is to move people onto waivers, which differ significantly from CFC. CFC is not a waiver program, it is an entitlement, which means no caps or waiting lists which force people into institutions when funding runs out. This design is intentional, as CFC was created to resolve the multitude of problems which come with these waivers. It is because of this program that 7,250 individuals in Connecticut are living in their communities instead of nursing homes. I ask you to imagine having the life you've known suddenly ripped away from you, only to be dropped into an institution needlessly. Nursing homes are overall more costly to the state and often lead to isolation, declining mental health, and preventable medical complications, and at worst, premature deaths. Cutting CFC would not save the state money in the long term. It would only shift costs while drastically reducing quality of life, as well as unnecessarily cutting many lives short in the way of vitality and lifespans. CFC protects independence, dignity, physical and mental health, and community integration. All people deserve access to these basic human rights, and I ask you to protect CFC in this budget. Thank you for your time.
Thank you. Fantastic job. Thank you for your advocacy.
Thank you.
Thank you both. Okay, Phil again. No Phil. Marcy Russo? Yes.
Good afternoon, Representative Gilchrist and members of the Human Services Committee. Those are two very difficult testimonies to follow, but I'll give it my best. My name is Dr. Marcy Russo. I'm a licensed psychologist living and practicing in Connecticut, and I'm currently the co-chair of the Connecticut Psychological Association Legislative Committee. And not only do I speak to you today as a practicing psychologist in Connecticut, but I also confidently am representing the voices of our Connecticut Psychological Association. And you heard from a colleague of ours, Christian, just a few moments ago. So I'll shorten my testimony as well in respect to you all. I know you have a long agenda, and a lot of what I have to say would replicate what he was advocating for. We've worked in partnership with the Mental Health Parity Coalition to look at some of the bills that you have proposed this legislative session on clawbacks and to support those earnestly. So I believe you have a bill in front of you today that's Senate Bill 87. And you may even know of all the problematic areas that are related and to clawbacks here in Connecticut. But I urge the committee to support meaningful reform to Connecticut's insurance clawback laws. Insurers are currently allowed to demand repayment for previously reimbursed services, which often arrive with unclear expectations or explanations, inadequate information, and at times many months, adding up to years in some instances after a service has been delivered by a licensed qualified mental health provider to a patient who is in desperate need of clinical intervention. So a mental health provider offers an intervention in good faith, and then months, sometimes years later, an insurance company requests that provider to claw back and to pay back information that that provider had already been billed, had already been paid. The administrative burdens that clawbacks place on providers who have to chase insurers down to understand why monetary compensation is being taken back well after a service has been delivered to the patient and the claim paid by the insurer causes really detrimental effects. Many of our colleagues in practices as psychologists, as well as other mental health providers in Connecticut, have unfortunately chosen to leave insurance networks and begun to practice as out-of-network providers to avoid horrible clawback instances. And this really, quite frankly, results in decreased access and difficulty for patients who are in desperate need of clinical intervention to be able to get an in-network insurance provider to deliver care. Just alone in Connecticut, psychologists have experienced, over 68% of psychologists have experienced a clawback. So I urge you to support Senate Bill 87. It has the broadest scope of the 3 bills that are being proposed this session in relation to clawbacks, and it extends protection to all different types of insurers, and most importantly, it reduces the clawback window to 12 months. I thank you for your time. I'm open for any types of questions that you might have, and I appreciate you taking the time to allow us to advocate.
Thank you so much. Thank you for being here and for your testimony today. Have a great afternoon.
Thank you.
Next is Mark Donald with us. All right. Todd Johnston.
Wonderful. Hello, Human Services Committee. Thank you for what you do and for allowing me to testify today. My name is Todd Johnston, and I currently participate with the MedConnect program along with Community First Choice. First item I'd like to speak against is the proposed change in Section 3 of HB 5040, an act implementing the governor's budget recommendations for health and human services. It is my understanding where the current $20,000 asset limit and $85,000 income limit is going to be held at those limits going further, where the current state law states on or after July 1st of 2029, there shall be no income or asset limits. I also wish you to remember that consumers on MedConnect do pay a portion of a premium for their Husky C benefit when they make over 200% of the federal poverty level. When I started, the asset limits for CFC were $10,000 and $75,000 annual income. When I had to have a deck replaced, I got quotes. The high was $25,000, the low was $8,500. I went with the $8,500 repair. I was concerned that I was going to go over the $10,000 asset limit for MedConnect, and I would be kicked off the MedConnect program. As you'll see, as I provide further testimony, how that would have impacted me even more. The MedConnect program allowed me to have more comprehensive insurance coverage through Husky C without a spend down. Prior to that, I only had original Medicare, Part A, hospital, Part B, medical coverage, or my doctor coverage. Husky C provides me with the much needed vision and dental coverage. Also, Husky C has assisted covering some durable medical equipment that I need that original Medicare will not cover. When leaving the hospital stay once, my discharge nurse applied for me to have the PCA waiver and community first choice. I was contacted by the PCA waiver program about a week later, and I was told there was a 4-year wait list. I was contacted by Community First Choice about a month after leaving the hospital. It took 6 months to coordinate to get on CFC and then have my current PCA set up to work with me. I've been on Community First Choice now for about 3 years. CFC has provided me with what I need to be able to work part-time for the North Central Area Agency on Aging as a Choices counselor. I request you to vote to keep CFC so I can continue to contribute to our community and live at home. Thank you very much.
Thank you very much. Thank you for your testimony and for being here today. Next, Kathy Flaherty. Kathy with us? Nope. Kate Childs.
Good afternoon. Thank you so much for allowing me the opportunity to speak today on HB 5355. I'm strongly opposed to the language in this bill that DSS is looking to modify the way that oil dealers get paid for delivering heating oil under the LIHEAP program. I've personally partaken in many meetings with the DSS representatives. I've spent a lot of time explaining how the pricing is calculated, how it's not remotely possible to provide a same-day delivery price just based on how the indexes are published. There's no way to get to a same-day price for delivery of heating oil. I think they finally understand that because now they're asking you to change the law to say they don't have to do a same-day price. They're looking to say it'll all come out in the wash. And the last 2 days we've had 80 cents in increase of prices to our cost. Woke up this morning and before we'd even delivered a drop of oil, we had our suppliers increasing our cost 40 cents at 6 a.m. So if a customer were to receive a delivery today based on yesterday's price or even potentially the day before's price, you could easily experience an oil company losing between 40 and 80 cents a gallon. There's just no justification for why other energy providers get paid their full margins, why we've offered a number of solutions to DSS on other options, whether that be some sort of discount over our posted price. I mean, we've done everything to try to come to some sort of common ground. And even though we've had some laws put into place to try to create an environment where a business can survive this way, the DSS office has chosen to modify what they're paying us, and we don't really have any recourse in that sense. I personally know also of an oil company that went out of business that was delivering a lot of LIHEAP funds for heating oil. This was back in the another spike time in the spike price of oil. It's just the loss of money every day is real when the prices are volatile. And we just think that, all companies should be treated the same way. We're not looking to be exorbitant in anything we're trying to do. If anyone wants to help the community and keep people warm, it's the mission of our companies. I just fear that this program is ultimately going to have fewer and fewer vendors that are going to partake, and people are going to end up cold. The things I hear are we partake because our current customers rely on us, but we're not taking new customers. Things like that, because there's just, it doesn't make business sense to partake in this program. So I don't think that's the goal of the legislature. I don't think it's necessarily the goal of DSS, but that's what is ultimately going to happen. We have not participated in the program for a number of years.
Thank you so much. I appreciate your testimony and sharing the concerns. I don't see any questions. Thank you for being here today. Next, Matt Barrett, would you like to go? We're doing folks who are here in person.
Thank you very much, Representative Gilchrist. On behalf of the Connecticut Association of Healthcare Facilities, a trade association of skilled nursing facilities and assisted living communities, my name is Matthew Barrett, the association's president and CEO, and I thank you for this opportunity to present testimony in opposition to Section 5 of House Bill 5040. We're asking the Human Services Committee to make no changes to the nursing staff wage enhancement provisions adopted last session in Section 322 of Public Act number 25168, emphasizing that the adopted law makes no distinction in the nurses that the state legislature directed receive a wage increase. By way of background, last session's law provides for wage increases for nursing facility rates to support wage increases for nursing, nurses' aides, dietary, housekeeping, laundry, and maintenance, and plant operations personnel in the amount of 3% effective July 1st, 2025, and an additional 4% effective January 1st, 2027. In addition to the adopted statute, my testimony cites several other sources if the committee is looking for support to continue these raises, and I hope that you will consider that. First, the published Connecticut state budget for FY26 and 27 does not make any distinction in the wage enhancement between nurses performing only direct care functions. And I cite to page 201 of the adopted Connecticut state budget. A letter that was sent to both nursing home associations on June 18th, 2025 indicates the intent of the adopted wage enhancement was to strengthen the industry, deliver high wages and economic security to the nursing home employees, and improve the quality of care for residents. It provides no distinction between eligible nurses and no mention of a distinguishing provision in a settled agreement between the executive branch and SEIU. Later in July 2025, an agency webinar presentation to all Connecticut nursing homes announced that only direct care nursing would be eligible for pay increases adopted by the full Connecticut General Assembly. And I cite to that slide that indicates that. And it's quite accurate that nursing home operators from across the state, as is their right, appealed the rates shortly thereafter from the nursing exclusion in the rate setting formula. And while the initial rates issued by the agency over the summer didn't include all nurses, earlier in February 2026, the rates were reissued in alignment with the adopted statute to include all excluded nurses with a rate increase for that purpose, while appealing nursing homes were requested to settle their appeals with the agency. I want to be clear, there's no windfall for Connecticut nursing homes in this wage enhancement for these excluded nurses. These wage enhancement dollars pass directly to the staff. And so in conclusion, we felt that it was fair and equitable that all nurses were mentioned in the statute that adopted last session, and we hope that the Human Services will continue that public policy. I also submitted testimony in opposition to Senate Bill 328 for the record concerning the unfunded state mandate concerning direct care staffing for nursing homes. And I thank you so much. It was very courteous of you to allow people that were here in person to testify, Representative.
You are so welcome, and please get home safely. Thank you so much for your testimony. We have been joined by number 37, Mark Donald.
Good afternoon, everybody. Thank you very much for taking the time to listen, and hopefully everybody gets home safe. It's a lot more clear down here in Southwest Connecticut. My name is Mark Donald, and I am the president and CEO of Catalyst CT, a nonprofit in Southwest Connecticut focused on prevention and intervention and so many of those things that plague our communities, like gun violence, suicide, mental health, substance misuse, etc. One of the advantages, I think, of going late and speaking in support of SB 87 is hearing many of my nonprofit colleagues speak in favor of it for so many different reasons. And the ones that I've had the opportunity to speak, listen to, have been very different in terms of service populations, missions, et cetera. But we're all essentially saying the same thing, that it's critical that nonprofit leadership has a voice at the table with many of these decisions. It's no secret that our various areas of expertise allow us to do things better at a cheaper rate than the government, and the needs for many of our services are only growing more. So as an agency that has contracts from DEMIS, DCF, and Judicial, we certainly experience some pain points across those different contracts and expectations that can lead to a little bit of inefficiency. So the creation of this act to strengthen nonprofits is certainly warranted. It's overdue. We've heard some historical references to the situation during Governor Malloy, and I certainly hope that we can get this passed, and look forward to participating in any way that I can to support it. Thanks very much, and I appreciate all of you.
Thank you so much. Thank you for your testimony and your work. Have a great afternoon.
Thank you.
Next is Mary Caruso.
Here we go. Oh, we're all in here. Just making sure we all get in.
Wonderful.
Good afternoon, chairs, ranking members, and members of the Human Services Committee. My name is Mary Caruso. I'm here as a mom, but I'm here as a person with a strong passion for strong communities. I'm here with my 2 adult children, Sam and Alex Bodie. And we'd like to tell you what CFC means to us. They both have Friedreich's ataxia, which is a genetic and progressive disorder. It's not preventable. It has shaped every step of their lives, but it has not defined them. Sam works at our local high school, helping shape young minds and teaching by example that people with different abilities can be part of our communities. Alex runs her own nonprofit dedicated to improving accessibility across Connecticut. They do not want to be cared for. They want to participate, to work, and to serve. But participation requires support. Neither of them, sorry guys, can get out of bed, dress themselves, or transfer without the assistance of another person. Community First Choice is what allows them to live in their own home and structure support around their work and civic engagement. It makes integration possible. If this program is cut, the impact is not just logistical, it's also social. When people with disabilities lose the support that allows them to be visible in workplaces and communities, they become isolated. And when they become isolated, communities lose something too. We lose coworkers, volunteers, mentors, and we lose leaders. Segregation does not always look dramatic. Sometimes it looks like quietly removing supports that make participation possible. 70% of rare diseases are progressive. Needs will increase, they do not decrease. In past years, as Sam and Alex have lost abilities, trying to explain their changing needs became very difficult. We struggle to help agencies understand a rare disease that doesn't fit neatly into standard assessments. What should have been supportive sometimes felt adversarial as we fought for necessary hours. It was during that time that we were guided to the Community First Choice program because it allowed the flexibility and the responsiveness as needs evolved. Having lived through that process is what gives me pause about a future without CFC. Community First Choice allows a person who needs significant assistance to still achieve meaningful independence. It bridges the gap between disability and possibility. Please do not take away the structure that allows my children and so many others to live not as patients on the sidelines, but as engaged members of the communities that we all share. When you make this decision, you're not deciding just on a program. You are deciding whether people like Sam and Alex remain visible, valued members of our shared community, or whether they'll be pushed aside into any type of isolation. We thank you so much for your time and your efforts here in making serious considerations about what's going to happen in the future. Thanks so much.
Thank you so much. Thank you all for being here and for your testimony.
Thank you.
Have a great afternoon.
You too.
Thanks so much.
Thank you. Next is Richard Famaglietti. One day I'll get it completely right, I promise.
Good afternoon. Can you hear me?
Yes, we can.
Okay. Good afternoon, Human Services Committee. My name is Richard Famiglietti. I'm here today to oppose the governor's continued attack on people with disabilities outlined in his budget bill, House Bill 540, and answer any questions you might have. I'm also here to support, in part, and thank you if it passes, Senate Bill 326, an act concerning Husky C asset limits. Senate Bill 326, I'm in great support of removing the asset limits for Husky C and finally to be treated equally in terms of asset limits as in Husky A and D, where all three Husky plans will have no asset tests. However, why the phase in? Why do we gotta wait? It doesn't make any sense. We're afraid that if it goes, it's a phase in, the governor's gonna wanna stop it, just like he's doing with, or slowing it down like he's doing it with the phase in with MedConnect asset limits. Also, more or just as important is the income limit for Husky C. How do you expect anyone to save any kind of assets or money or emergencies when their income is adjusted after the spend down to be under $1,400 a month, which leave you short $300 to $400 to pay rent? People are forced to spend down income like a deductible until their income is below $1,400 a month before Medicaid pays for anything. Also, those like me on MedConnect who are soon to retire or by decline have to again stop work after many years of paying taxes. Once we stop working, now we're subject the very next day to that ridiculously low income and asset limit of Husky C. What is the incentive for us to work? If I'm only going to go back to be in poverty, or if I can't afford to live in the community, I will make a conscious choice to go to a nursing home. That's just the plain facts. Now, community first choice. I hear talk about how difficult it is to manage the PCAs, how GTI and allied services can't do the payroll. Well, you know what? Don't punish the people with disabilities. Whoever's in charge of hiring or subcontracting these companies to do these payrolls, maybe they need to be fired. Don't throw out the program. There's too many people on this program. Self-directed services are way better. You can't get an agency-based PCA to meet me at the movies to help me go to the bathroom when I want to go out. Your self-directed PCA can. You are taking away freedom, choice of care, if you don't allow me to at least have a choice between the two. There is a place for agency-based. Another issue with agency-based, which I used to use then, if the assigned PCA calls out sick, you're not guaranteed to get a backup. On self-directed, I got 3 or 4 people ready to come in if somebody calls out sick at the time I want, not having to wait to 3 hours or the next day. Also, I'm opposing in the governor's budget, why the heck is he proposing to give people, single people who earn up to $200,000 a year, or multiple family people earning up to $400,000 a year, he wants to give them a $200 tax refund and a $400 tax refund respectively. Those income people that high do not need it. use that money to fund community first choice. Thank you. Any questions?
Thank you so much.
Oh, by the
Appreciate-
way, that proposal for the tax break is on the very same page as eliminating community first choice. What a freaking insult. Because the people who are not paying income tax are the people on Husky C with disabilities, and they got the same inflation rates, and their income doesn't get adjusted except for getting lower. Thank you.
Thank you. Thank you for your testimony. All right. Have a great afternoon.
You too. Thank you.
Next is Eleni Kaloidis. Is she with us? Nope. Jean Mills Aranha. Nope. Sheldon Tubman.
Good afternoon, Representative Gilchrist, other members of the committee. Can't tell who's there in person, but thank you for sticking it out. My name is Sheldon Tubman. I'm an attorney with Disability Rights Connecticut. We serve people with a broad range of disabilities throughout the state. You have my written testimony. I just want to touch on a few things and respond to what I heard. First of all, to be clear, CFC is not a waiver. The commissioner referred to it as a waiver program. That is not correct. It is a state plan option that Connecticut chose that is an entitlement, unlike waivers, which are discretionary, where the state can and does cap the number of people participating and can and does cap the amount of dollars you can get. And if we were to go to waivers, it's not entitlement, so the next administration could just cut back. Next is costs. We are told that this is being done because the costs are unsustainable. And yet, neither the governor, nor the commissioner, nor OPM ever mentioned the savings from CFC or the increased savings from CFC as we've gotten more and more people on it. They scare you with the statement that its costs have gone from 88 million to 371 million in 7 years, but they don't tell you how much was saved. In fact, they don't even mention how much was saved. Well, we know because the commissioner says that each CFC plan on average costs $64,000. By the department's own figures, the average nursing home cost is $92,676. So we save $29,000 per year per person on CFC versus being in a nursing home. In addition, the argument was made by the commissioner, well, some of these people on CFC don't yet meet nursing home level of care. That's not correct. You can't be on CFC unless DSS has itself gone through a rigorous assessment and found that without CFC services, you will be in a nursing home. They are already at that level of care. So just doing the math here, $29,000 saved per person, 7,200 people on it now. At $29,000 saved per person on average, we're saving $210 million a year. That figure is not mentioned, nor is any figure about savings mentioned. In addition, the arguments being thrown out, such as we can't do agency-based under CFC, we can't do case management. Senator Lesser asked the question, the answer we got was clearly, yes, they can do both of those things under CFC. It's just a little administratively complicated, and they haven't started the 18-month process they were asked to start 2 years ago to make it possible. And the argument made by OPM that if we go to agency-based through that, there won't be enough agencies to meet the need, then that completely undercuts their whole argument about putting people on waivers so they can go to agencies. So the most important thing I want to emphasize is that they seem to think it's okay to talk about taking care of the needs of the people right now. And that is frankly disturbing. It's not the role of the state to only take care of people who have a need as of a certain date. What about Sarah Hinman, who you heard from, whose son is quadriplegic due to an accident, not yet applying for the program, but going to need it soon? Or Sandy in a nursing home right now, but not able to get out yet. What happens when intake is closed per the proposal? So I urge you to think seriously about that kind of cutting it off. And also, I do have to mention that at the Appropriations Committee, the commissioner said expressly that the intention is to put all the new people on a waiting list. And after that, there will be direct rationing based on, I quote, level of care. She said that people with a lower level of care will be prioritized over people with a higher level of need, a completely backwards concept of rationing that should be disturbing to all of us. On Husky C 326, we do appreciate it, but I have to say, what Rick Famiglio just pointed out about income discrimination has to also be addressed. People cannot shed income the way they can assets, so they don't have a chance of getting on Medicaid. I would urge you to look at that as well, and to at least start addressing the income inequality as well as the asset inequality. And lastly, on drugs, there's two bills on step therapy and prior auth. What keeps being missed in all this is that these systems, although not designed to result in people getting no treatment, have exactly that result. Step therapy means people get nothing when they show up at the pharmacy and they try to get a drug, but they didn't prove step therapy. Representative Comey, I think, asked the question, well, what about if the person had the drug and failed on it through another payer? Will they be protected? The answer is theoretically yes, but proving it is the problem. The doctor has to go through all the paperwork, and if they don't, they're going to be denied it. Prior authorization, as proposed to now be imposed on HIV drugs, is the same thing. So these systems result in people going to the drugstore and getting nothing. I've attached to my testimony proposed language that's been looked at by many other advocates as well. And it's a suggestion for language that at least if you're going to allow them to do more prior auth and more step therapy, to at least have written notification go to folks telling them what's happened, why it's happened, and steps they can take to try to prevent these things from happening, or at least limit the amount of time of the gap that is created by these systems that are solely designed to save money, but don't recognize the actual resulting harm that comes when you do these kinds of things. Thank you very much. Happy to answer any questions. And again, thanks for staying so late to be here with us, given the snow.
Thank you, Sheldon. Representative Dathan, go right ahead.
Thank you very much, Madam Chair, and thank you, Sheldon, for your testimony today. I know you have been involved in this discussion for a while, but I did want to ask you, can you think of any other instances where we have had services under the state plan that have moved to a waiver program, and how that has affected the population who were previously eligible for services under the entitlement, but then no longer eligible or had to be waitlisted as a result of the move?
I can't think of any cases of that. I mean, maybe there are, I don't remember that. I've been around a long time, but I don't remember that. But the thing is to understand is that we are, by definition, that's the point, putting people into a system that's going to be capped. That's the idea. It's not going to be an entitlement anymore. So you are taking away, and that was acknowledged today when Senator Lesser asked, so you're going to basically taking stuff away from people, they're going to have to get less? And the answer is, yes, we are. And so that's what people should understand. If we go to a waiver, we are necessarily going to be doing that, apart from what happens with the next administration, et cetera. But I'm sorry, I don't happen to have any answer of that having been done. And maybe there's a reason why that's never been done, precisely because it would be taking services away.
Well, that's why I asked the question, because I haven't seen anything like that. I am going to ask OLR if there have been any situations like this. But we already see long waiting lists for folks in the that need services under the autism waiver and then other programs within the state. And I do fear that this is going to cause unnecessary harm to many individuals, including folks who maybe don't need the services quite yet today, but will have to rush and get these services and then put a lot of strain on the whole area. My second question is regarding Husky C. I know we've had this discussion before, but in terms of the assets, you had produced an analysis of what California has done to eliminate the asset requirements, or the limits, I should say. I wanted to ask you if that assessment is still valid, and if we have any updates to the work that you did in that in the past.
Yes, I've been analyzed this in past years since I've been working on this for a while. The estimate of how much it would cost is absurd. What the department, or OPM more accurately, puts out as a supposed claim of the cost of this is ridiculous, based upon what actually happened in California, where a much larger state, 11 times the size, they got rid of their asset limits entirely. And by the way, New York has extremely high asset limits for their Husky-C-like program. So even though they technically have an asset limit, almost nobody gets anywhere near it. And there's other states that have high asset limits. But same thing with the income limit. It's raising it to end the discrimination, to end the odious discrimination against people with disabilities. So they have a $439 lower income limit than any other adult. How do you explain that? You can't justify that. And the cost of doing that, to answer your question, was way less than what OPM had claimed, which unfortunately the fiscal office had adopted as well. But I'm happy to provide another analysis of that, showing that it's well under 100,000 to fix this for everybody, both income and assets. And it's about time we ended the discrimination. Thank you.
I do hope that is part of your testimony. I will have a look online. I had to leave the building with the weather, but I appreciate you testifying today, and thank you, Madam Chair.
Thank you, Representative. Representative Hughes, go right ahead.
Thank you, Madam Chair, and thank you, Sheldon, for your detailed testimony on all of these. I wanted to follow up a little bit on what my colleague said about the discrimination for people with disabilities, and would the proposed elimination of staged asset limits still be in violation of the discrimination?
So yes. And just for full disclosure, we have a lawsuit pending right now against the state DSS over the income limit discrimination. Those plaintiffs, it's about the fact that of income being in between the Husky A and the AD versus Husky C income limits. What that does is it violates the Equal Protection Clause of the state constitution, which says expressly prohibits states from discriminating on the basis of, quote, physical or mental disability. Just like race discrimination, it's one of the many discriminations that are expressly prohibited. So that discrimination prohibition is violated equally by imposing assets only on people with disabilities and 65 and older, as it is with having a much lower income limit for people with disabilities versus not people who are not disabled. It violates that constitutional protection either way. We appreciate whatever you're doing, and we recognize you've been fighting this, and we honor that. We're hoping that this year, and maybe in light of the recognition there's a lawsuit that's been filed, maybe it's time for the legislature to step up and for the governor to step up and do the right thing. Don't wait for the courts to rule. It's going to take a while. That's unfortunately the way this is. In the meantime, we have an active discrimination going on, and that's when Rick Famiglietti before me said, why are they discriminating against people with disabilities? Well, that's what it is. It's express discrimination, and people have known about it for years now. This is not like it's new. You've known about it. The legislature has known about it. The governor's known about it. So at this point, it's become intentional discrimination. And the question is whether it's worth finally addressing it. And yes, that could potentially mean addressing the fiscal guardrails so as to end this kind of odious discrimination once and for all.
Thank you for putting that on the record. The other question I was going to follow up on with my colleague was about the prior auth and the prescription drug step therapy. Do you feel like what you suggested in your testimony, at least giving written notice, addresses the at least spirit of the law about notification for the patient before?
The language that we've given, and some national experts also help put that together, the language that we provided does address the ongoing due process violations in violation of federal law and state law that are going on right now, as well as providing additional notification not required. The three basic components are that when drugs are denied at the pharmacy from now on, there will be written notice that explains why the drug was denied. For example, you didn't go through step therapy, you didn't get prior auth, whatever. The states the reason, the regulatory basis, the right to a hearing, and how you get a hearing. That's one thing that's required by law right now and not being done. The second thing is that when you're going to terminate coverage for a drug somebody's already on, is that there's advance written notice, just like ending Medicaid eligibility or ending any other services, advance written notice that tells people it's about to end, says all those same things in the written notice, but also says you have a right to keep that drug going pending a hearing if you think it's a mistake. And last, that's also required by law. And the last thing is we propose a notice, an informational notice that goes out when they're changing the rules. They do this to the doctors, but the doctors don't read those bulletins. So you need to make sure the patient who actually is affected gets the written notice, and the bill would also address that, provide some informational notice to say, talk to your doctor about fixing this issue.
And who would be responsible for those written notices?
That would be for DSS to do.
Okay, and do we have any idea what that capacity, what that cost, you know, anything around administering that is?
I can't do that. I mean, you'll have to bring
Yeah.
them in. I will say this is a very positive result, which
Yep.
is that advocates, 5 organizations sent a letter, I think on February 3rd to the department about this issue in light of 220 drugs newly being subject to prior auth, thousands and thousands of people. We don't know exactly how many, but many, many people. They're threatened with losing their access on April 1st because their doctors didn't read the bulletin and didn't request prior auth. So we asked the department to change its policies and start doing these notices, and they did respond positively on some of it, and we will be responding to them and engaging with them. But up until now, there hasn't been any protection, and it seems to me if you put that in law, we can make this happen. Yes, there'll be a cost. Stamps are not free, but it's worth it since what we're talking about is people going without treatment. For example, for seizure disorder, you know, anticonvulsant medications that prevent brain damaging seizures. So I think it's worth it.
Oh, I know it's worth it, and I know it's worth it for keeping emergency room visits reduced as a result of this, but I just wanted to hear you say it for the record. Thank you.
Thank you.
Madam Chair.
Thank you, Sheldon. And thanks, Rep. Hughes. I don't see any other hands or questions. Thank you so much for being here today. Okay. Next is Danielle Middlebrooks.
Good afternoon, Senator Gilchrist, Senator Lesser, Representative Case, and Human Service Committee members. My name is Danielle Middlebrooks, and I serve as the Director of Advocacy and Public Policy for the ARC Connecticut, the state's leading advocacy organization for people with IDD and their families. From birth through aging, in partnership with our 14 chapters across the state, we work to advance policies and systems that promote dignity, inclusion, and opportunity. It's impossible to sum up all the needs of an entire community in a compelling, relationship-building, data-backed, solutions-forward 3-minute speech, especially when it is critical that I advocate in favor of CFC, SDM, the General Administrative Payment or GAP, DDS, DSS, the challenges with GTI, the MEWAs, and remember which committee is hearing which bill on which day and which number they were on, and follow Rick F. and Sheldon Tubman. You can also find our full recommendations and a more detailed explanation of our position in written testimony. But in brief, the ARC Connecticut is in support of bills that improve the physical, mental, social, and emotional conditions of those we serve, their caregivers, and community. We believe supporting SB 326 and 327 can help pave the way for improved health outcomes across the IDD community. Our support of HB 5357 and 5358 recognize that our providers need regular rate increases to ensure funding keeps pace with the cost of goods and services for the care of those with disabilities. Our support of SB 87 recognizes what our 14 chapters show, that we are stronger together. And we remain outspoken in our opposition to moving Community First Choice into a waiver program. These bills don't just represent acronyms. They represent the daily realities of the IDD community. They represent whether someone can access care, whether a provider can keep the doors open, and whether individuals have access to inclusion over isolation. The ARC Connecticut, as always, stands ready to work alongside you to build and protect systems that are sustainable, equitable, and centered on the dignity and potential of every person. Thank you for the opportunity to testify, for your leadership, and for your commitment, especially on a day like today.
Thank you so much. Sorry for my distraction. Thank you for your testimony and thank you for being here today. Next up is Tom Fiorentino. Is Tom with us? Nope. Okay. Jonathan Sigworth.
Hello. Senator Lesser, Representative Gilchrist, and other distinguished members of the Human Services Committee. Glad to see you guys again. My name is Jonathan Sigworth. I'm president and CEO of the nonprofit More Than Walking and a wheelchair user since a bicycle accident and spinal cord injury 20 years ago. I'm here to support SB 326 and SB 330 and to encourage all of you to do what you can to amend HB 5040 so as to prevent the elimination of the Community First Choice program. The CFC program is so fundamental to the health, independence, and quality of life for the disabled community that I'm going to focus my comments on this issue. I cannot emphasize enough how delusional it is for us to talk about any bill or policy that impacts the disabled community if we do not recognize that it therefore applies to each and every one of us. CFC program does not only serve 7,250 of Connecticut's most disabled residents, it serves you and me and every person in the state, including those who are not disabled and who are not currently on Medicaid. A large part of my work every day is meeting virtually with individuals and families from across the country dealing with the aftermath of traumatic spinal cord injury following car accidents, work accidents, shootings, everyone caught off guard, no one expecting to become severely disabled. And that is why we need to continue to invest in social safety net programs like CFC. Most of the people I talk to, they're not enrolled in separate long-term care insurance plans. And so they are surprised that all of a sudden they must enroll in Medicaid to access long-term caregiving services. And that is what CFC, the CFC entitlement and these other waivers provide. So if CFC is eliminated and people are shifted to waivers with significant months and years of waiting lists, this is what happens. If you're not currently on Medicaid and you become disabled, you will need to get on Medicaid. So I urge you guys to talk to your colleagues, other legislators, saying this is a issue for us, not for the disabled community, not for the people who are currently on CFC. This is for me. This is for you. We will have to get on Medicaid and benefit from CFC if we have a car accident or a catastrophic injury. What happens is when people are sent to nursing homes, they lose their homes. They don't only lose access to their families and their community and their work. They have to lose their homes. They have to sell their assets. They have to lose their income. It is so costly and catastrophic for people to be forced into a nursing home environment. I cannot wrap my head around how this policy could be justified saying that it's unsustainable. That's a choice that we're making. It's been sustainable for the last several years. It can be made more efficient. The justifications for getting rid of this policy are insincere and miscalculated and not transparent, I believe. The CFC program saves more to the state than the alternatives, which has not been articulated properly by the governor's office or by DSS. The idea that self-direction is a burden. The idea that self-direction is a burden for people with disabilities is insulting. And there are clearly easily modifications to the current program to make that more accessible for people who desire more care. Please do not do this for my sake, for your sake, for the people who are currently on it, and for all of Connecticut residents, not just the current disabled community. Thank you.
Thank you so much. Thank you for your testimony. Representative Hughes, go right away. Oh my God,
Thank you very much, Madam Chair, and thank you, Jonathan, for pointing out that this is our collective program that all of us could potentially one day need and are likely to in some form or another. And can you speak a little bit to why this is so crucial in the absence of a universal public healthcare program?
Sure. Listen, Connecticut is, I believe, the majority of states in the U.S., I think it's 40 states, don't have CFC. Right? Connecticut is, I think, one of 10 that has it. When I talk to families who are in a state that doesn't have CFC, It is a nightmare when they're struggling to navigate this. This is a manufactured problem. The idea that we cannot afford universal health care is itself an absurdity when we are the richest nation in the world. To then extend that to say that our state, which is one of the wealthiest states in the union, can't effing afford to guarantee that if you become disabled in a car accident, no matter where you come from, if you're working, no matter how long you've paid into the system, we're going to guarantee that you're not forced to sell off all your belongings, separate yourself from your family, quit your job, sell your home. Instead, we're going to force you into a private equity owned nursing home that's just going to be using you as a line item to balance their budget. I mean, it is insane. I mean, I can't stress enough the frustration. Like, I'm not on Medicaid. I couldn't get on Medicaid if I wanted to, but you know what? I'm a wheelchair user and I know that I'm one fall away. I am one trip, a bad fall off of a curb from having to leave my home with my wife, quit my job, and be forced into institutional care and impoverish myself because we don't have universal health care. And I'm so happy to be in Connecticut, or at least I was, because I thought there were safeguards against that. And if this goes through, those safeguards are eliminated for me and for every able-bodied person out there. So thank you for that question, Representative Hughes. And I really hope we take this to heart and you take your colleagues to task about how this applies to them and not just some abstracted disabled community.
Thank you for not for helping us not normalize this ridiculous system that we've chosen that excludes everybody, forces people onto, you know, GoFundMe to just survive or to sell their homes. That we've normalized that, and it's time that stopped. Thank you.
Absolutely. Thank you.
Thank you, Representative Hughes. Thank you, Jonathan. Good to see you. Thanks for your testimony. Is Russell Schwartz with us? Yes. Good to see you, Russell.
Yes, I am. Good afternoon, Representative Gilchrist, Senator Lesser, and members of the committee. My name is Russell Schwartz. I operate Avon Health Center and West Hartford Health and Rehabilitation Center, both family-owned, non-private equity nursing homes in Connecticut. I'm speaking to you on behalf of my opposition to Section 5 of House Bill 5040. I'm thinking the governor might take issue that they had the agency allow us to provide raises to the administrative nurses, then all of a sudden this bill comes along and it takes it away. I've already given the raises. The legislation clearly over the winter and fall spoke to giving nursing home increases to nurses. It didn't qualify which nurses, whether it was administrative nurses, floor nurses, or managerial nurses, but putting nurses against one another where some get increases and some don't is unjust and creates a animosity among staff that work together. There's just not the possibility that I could give raises to just some nurses and not all of my nurses. Teresa Sanderson, our administrator at West Hartford Health, submitted some nice testimony as well that I think speaks to this bill and why Section 5 should be rejected by the committee. Also excluded in the raises for the summer were my social workers, my recreation staff, my administrative staff. So the bill in and of itself gave raises only to a select population. I know that District 1199 was active in negotiating the increases with the state, and these raises just are pass-throughs to our staff. There's nothing that comes to the nursing homes way in terms of being able to fund other operational expenses. So again, I just want to speak in opposition of Section 5, and please think and please consider that for facilities that have already given their raises, what this would do in terms of unwinding it. I certainly still couldn't take the raises back from my staff, nor would I want to. And it was last week, I believe, that I signed settlement agreements with the Department of Social Services to allow for the raises for administrative nursing in the facilities, which had not been there previously. That's all I have for you. Thank you so much for your time and attention, and I appreciate it.
Thank you so much. Truly appreciate you being here today and for your testimony.
Thank you.
Have a great afternoon.
You too. Thanks.
Sal Murata.
Yes. Good afternoon. Senator Lesser, Representative Gilchrist, members of the Human Service Committee. My name is Sal Murata. I'm the owner of Ambassador Wheelchair Services in Rocky Hill, Connecticut. I'm here to speak in support of House Bill 5356, an act concerning non-emergency medical transportation. I have submitted written testimony, so I will be brief and touch on some of the points here. So Ambassador has been doing NEMT, non-emergency medical transportation, for the state of Connecticut Medicaid clients since 1991. We're primarily do wheelchair transportation, take patients to dialysis appointments, doctor's appointments, daily. Okay. And back in 91, I would like to highlight our base wheelchair rate was $29.52 for a one-way in-town ride. Today, 2026, that rate is $32.28. Okay. Over 30 years, and that's basically the increase that we've gotten. I mean, the rates, I think the state should really look into, when they negotiate these deals with the transportation brokers, I think what they're paying transportation companies really should come into play. And, our drivers make just barely over what minimum wage is. Minimum wage now is up to just about $17 an hour. All our employees are W-2 employees. They're employees. They're not independent contractors. So, I pay unemployment, taxes, workers' compensation, mandatory paid sick time. They get that. And, our rates have been pretty much, non-existent. I mean, we haven't had much of a increase. Insurance has gone up over time. The vehicles have doubled in cost. Okay. Back about 10 years ago, we were buying wheelchair vans for about $38,000. Van today is in the mid 80s. Okay. There's not many companies like us, like Ambassador, left. We're regulated by DOT and OEMS. If you go back probably about 7-10 years ago, you had many private ambulance companies also doing invalid coach wheelchair transportation. Now, I don't think there's really any doing any of the Medicaid work.
Can you sum up?
The other thing I'd like to talk about is the drivers, getting a driver's license. In the past, years ago, back 90s, a driver would go in to get a public service license. They would give the driver a license and then do a background check.
Could you please summarize?
Right now, what is happening, I mean, it could take up to 90 days to get a driver certified for a public service license. And sometimes by then, the applicant, has found another job. So need to get that fixed and, work with public safety, DMV, to see how we could get drivers more quickly licensed and certified. Thank you. Thank you for your time.
Thank you. Senator Lesser, go right ahead.
Thank you, Madam Chair, and good to see you, Sal. As you know, we've worked on this issue for a number of years, and last year passed some legislation through the state Senate, was not acted on before the end of the session by the House, to try to improve things for the delivery companies that are trying to work with our state's Medicaid program. Could you describe some of the obstacles you've had with MTM in terms of working with them? You mentioned that the license issue as being a particular issue, but you also mentioned the compensation rates.
Right. So any MTM doesn't get involved with getting the driver's license. There is some issues with getting things certified, which a lot of time that we spend getting them the information they need. But my main concern, you're right, is the rates. And what we're faced up against when you ask for an increase, there's issues where they'll go to another provider who could perform work cheaper. They'll give it to a lower provider. And there's providers out there, honestly, like I said, we're a W-2 employer. Okay. You have companies out there that have independents, have drivers not even making the minimum wage. And that's what we're up against.
Yeah, I hear you. And in fact, you might want to come back next week because there's a bill proposal out there that will allow 1099 employees to get health benefits. And I understand the idea, right? We want to make sure everyone has health insurance. But, if you're, my worry is that might just further encourage a misclassification of employees, which puts W-2 businesses like yourself at an increased disadvantage. So it's a conversation I'm going to ask of the proponents next week. But I hear all of those issues. And is the work that you're looking to do, is it strictly the non-emergency medical transportation, or is there other work that you do with Department of Social Services?
With DSS, it's just the NEMT. Ambassador does other work, other private work, so we could compensate our drivers, a little bit more on the private end. But with DSS, it's just the NEMT work.
Well, thank you very much. We got some work to do. Thank you very much.
Thank you.
Thank you so much. Have a great afternoon.
Thank you. Thank you. You too. Thank you.
Next up is Mark Spellman.
Good afternoon, albeit an icy afternoon. Committee Chair Senator Lesser, Representative Gilchrist, and esteemed members of the Human Services Committee. I'm Mark Spellman. I'm a psychologist in private practice in New Fairfield, Connecticut, and I'm testifying on behalf of the Connecticut Psychological Association. I'm testifying in strong support of Senate Bill 87, particularly the provisions limiting clawbacks to 12 months and providing for a reasonable appeals process and a clear explanation for those clawbacks. Clawbacks are a major problem for Connecticut psychologists. A recent survey we've done, which I included in my written testimony, shows that over 68% of us have experienced clawbacks, representing 124 separate incidents, over half of which occurred more than 1 year ago. So this 1 year limit really means a lot to us. Clawbacks can be terribly frustrating. Often we don't get an explanation for the reason for the clawback. The appeals process is murky at best. And what usually ends up happening is we repay the clawback ourselves. Most of these clawbacks are for in-network patients who could not have afforded out-of-network care in the first place. It's not reasonable for us to expect to go back and ask them to pay a year or two later. Eventually, the frustration of clawbacks drives psychologists out of panels, which is extremely unfortunate. Many of us really want to serve our community. We're willing to accept panel rates, but we're not willing to accept over and over again having to repay money from clients that were covered, we thought, but then are not, and it just comes out of our next reimbursement. And eventually, that demoralization causes us to leave panels. It's not just us. This is also true for Connecticut social workers. A recent survey, which I also included in my testimony, shows that 30% of Connecticut social workers are leaving panels, or at least considering it, because of clawbacks. In my mind, clawbacks are an everybody lose situation. We want to serve the community. We want to serve our neighbors. But eventually, clawbacks drive us out of networks. Then Connecticut citizens lose because they lose access to mental health care. And even the insurance companies lose because research shows that patients who don't get needed mental health care ultimately have higher medical costs. Everybody loses. So I really hope that we can get this bill through. This is probably my fourth time back to the legislature advocating for reduced clawback time. And please protect our ability to serve our neighbors, Connecticut citizens' access to mental health care, and saving the insurance companies money in the long run. Please support Bill 87. Thank you.
Thank you so much. Thank you for being here and for your testimony today. We're going to go back to number 45.
Madam Chair, I'm
Yeah.
sorry. It's Representative Dathan. I couldn't get my hand up in time. Just a quick question for the clawbacks. Does Medicaid do clawbacks, or is this insurance only?
In our survey, we got very few, if any, reports of Medicaid clawbacks. I mean, of course, occasionally they happen, but they're very rare.
Okay, so
I've
it'd
never
probably
gotten
be,
one.
yeah, okay. I was just kind of curious because I have never heard of that. So I was a bit surprised when you were talking about clawbacks.
I never
thank you
got
so-
one from Medicare. I never got one from Medicaid, but we get them.
Okay, thank you so much.
Thank you for
Madam
your
Chair.
question.
Sorry. Sure, thanks.
Thank you very much. Now we'll go to Jean Mills Araha.
Oh, sorry, didn't realize I could unmute myself. I'm Jean Mills Arana. I'm an elder law attorney with Connecticut Legal Services, and I'm presenting testimony on behalf of all three of Connecticut's legal aid programs and our low-income elderly clients, who include many people in nursing homes who participate in Husky C, SNAP, and Community First Choice. First, Senate Bill 328, requiring nursing homes to spend at least 80% of the funding received from Medicare, Medicaid, and other payments on the direct care of its residents. We think this will assure that most of the millions of taxpayer dollars provided to nursing homes will be used to fund much needed care for residents. Nursing homes frequently complain that they do not have enough funding for the care and residents' needs, yet increasingly they are being purchased by private equity firms who are investing purely to make money from the nursing homes. We do have a suggestion on the definition of direct care, which is in my testimony, just to add promoting socialization and personal care services so that it's consistent with section 19A563B of the statutes. Connecticut is not alone in seeking to use this technique to ensure funding is used properly. New York state law requires a fixed percentage of nursing home income to be used for direct care, and that statute has withstood challenges brought by 135 nursing homes. Secondly, I'd like to address the Husky C asset limits in Senate Bill 326. I agree with everything that's been said so far about the discrimination, both on the income and the asset side. And Connecticut definitely needs to stop this discrimination and also make it possible for our elderly and disabled population to afford to continue to live in their homes, which will only be a cost savings to the state in any event. Next, I'd like to talk speak in opposition to House Bill 5040, the governor's budget for health and human services, particularly with respect to two items. First of all, the failure to establish a state-funded food assistance program. Connecticut residents, over 450,000 of them, use SNAP benefits. And when last year President Trump signed HR 31, food benefits to all Americans and to Connecticut residents in particular have been slashed. A lot of Connecticut residents in all parts of the state are already hungrier and less healthy. They cannot pay less rent, pay less for a gallon of gas. So food budgets are going to have to be reduced, resulting in people having less food for their families. In all likelihood, they will also have lower quality food since they can buy larger quantities of poorer quality food. Food banks alone, as good a service as they provide, cannot solve this problem. And without a state-funded supplemental nutrition program like SNAP to replace the food dollars our residents have lost, too many people in Connecticut will be hungry and without basic, adequate, nutritious food. And lastly, I just wanted to mention, as many others have already mentioned, that we strongly oppose the proposed elimination of community first choice for all the reasons that have been articulated by so many people that spoke before me and which I address in my written testimony. Thank you for your time.
Thank you so much. Thanks for your testimony and for being here today.
Thank you.
We will hear from Luis Perez. Luis, you just need to unmute.
There we go. Thank you so much. Yeah, good afternoon, Representative Gilchrist, Senator Lesser, and members of the committee. As stated, my name is Luis Perez, and I am the President and Chief Executive Officer of Mental Health Connecticut. MHC is a statewide direct service and advocacy organization that has been supporting Connecticut's residents with their mental wellness for 118 years. As a past board chair of the Connecticut Community Nonprofit Alliance, as well as the former co-chair of Governor Malloy's Nonprofit Health and Human Services Cabinet, I am glad to testify today in support of SB 87. Today, I address you less as a provider and more as someone who led the very thing that this bill is trying to recreate. I was fortunate to co-chair the governor's cabinet with then Undersecretary M. Foley, and that made that cabinet a very different from either a task force or a study group because of who was in the room. We had 26 members, all Health and Human Services commissioners were appointed to the cabinet, the commissioners from DCF, DEMAS, DSS, DDS, and I would suggest that CSSD and DOC as a purveyor of services should also be included. The people who make the decisions were in the room. So when problems were brought up, we were able to resolve a lot of them without having to escalate them. I was sitting across from people who could actually do something about it, and they did. We set up 3 work groups: business practices, contract procurement, and nonprofit employment and training. Each one had subcommittees. This was not ceremonial. We got into the weeds on payment rates and whether they reflected what it actually costs to deliver services. We looked at procurement timelines because a lot of you may not realize this, but when the state is slow in executing a contract, the nonprofit is still expected to provide the services. So we end up floating the state's costs out of our own budgets. We put together guiding principles for the whole state nonprofit relationship around transparency, accountability, timely payment of it, all of it. And those recommendations went straight to the governor. It worked. And it was unfortunate that it ended, not because it failed, because it was never put into law. The administration changed and the whole thing, well, just went away. Years of momentum, relationships, institutional knowledge, gone. And the problems we were working on, they're still here. And sometimes, honestly, sometimes they're worse. Workforce shortages, rising costs, agencies asking for the same data in different formats with no coordination between them. That's why SB 87 matters. It takes something that was proven to work and makes it durable. It puts it into statute so that the next governor or next administration can't just let it lapse. And housing it at OPM is the right call. That's where budget, policy, and agency oversight all come together. One thing I would ask the committee to think about is who sits on the board or on the panel. Make sure that it includes small organizations, not just the big ones. Make sure that all geographic areas of the state are represented and that different industries are at the table. So thank you very much for your time today, and I hope you will consider my recommendations. Thank you.
Thank you so much. Appreciate your time and testimony today.
Absolutely.
James Hart.
Good afternoon, Senator Lesser, Representative Gilchrist, and members of the committee. My name is James Hart, and I serve as the Executive Director of the Epilepsy Foundation of Connecticut. I'm here today in support of strengthening SB 331 and HB 5040 to ensure clear, enforceable due process protections when step therapy and prior authorization results in prescription drug denials under Medicaid. Both bills expand the Department of Social Services authority to impose step therapy and prior authorization requirements. These tools may be legally permissible, but when those tools are used, patients must receive meaningful notice and a fair opportunity to respond before their care is interrupted. And right now, that protection is inconsistent at best. I'm going to drop my paper for a second here. I've been working with Mr. Taubman quite a bit, and he spoke so eloquently and in many ways very specifically to the issue at hand here. So I just wanted to use the rest of my time to give you a little more specific example of why we here at the Epilepsy Foundation are so concerned. So we have seen how quickly large numbers of medications can be reclassified under the recent rollout of DSS's preferred drug list. And when that happens, individuals who are stable on long-term therapies, they can suddenly face new authorization requirements or step therapy barriers. And I want to be very specific here when it comes to individuals living with epilepsy. We've worked quite a bit with our professional advisory board, and in this situation, the maintenance of seizure-free living is so delicate that any barrier to receiving medications can result in a seizure. When anti-seizure medication is interrupted, the consequences can include emergency department visits, hospitalization, loss of employment, loss of driving privileges, permanent injury, and in some cases, death. For us, though, now the core issue is notification. Too often, the first time a Medicaid enrollee learns that there's a problem is when they are standing at the pharmacy counter and being told that their medication has been denied. That is not meaningful notice. Federal Medicaid regulations already require individualized written notice and clear appeal rights when services are denied, reduced, or terminated. But in practice, pharmacy denials generated by automated systems frequently occur without timely, understandable notice. And I just wanted to mention that, just to give you an example, the recent rollout of DSS's preferred drug list, we reached out to our 6,000 families and individuals affected by epilepsy. As of yet, not a single one of them was aware of this, was aware of these changes in advance, and that can, as you can all imagine, meaningfully result in interruptions to care. As such, the language that Mr. Taubman submitted, we enthusiastically support. This does not prevent cost management. It does not eliminate prior authorization. It ensures transparency and continuity of care. When we're dealing with life-sustaining medications, interruptions should never be a surprise. On behalf of the epilepsy community of Connecticut, I respectfully urge you to strengthen these bills to ensure meaningful due process protections and to prevent avoidable disruptions of care. Thank you so much for your time.
Thank you so much. Senator Lesser, go right ahead.
James, thank you for your testimony. It's good to see you. Just a question, because we've had this back and forth with DSS and other forums, just understanding what it is that they're trying to do. So they've presented to us that the prior auth requirements are limited to certain classes of medications. And I think they've represented that that epilepsy drugs are not on that list, but I just wanted to make sure if they are, obviously that's quite concerning. And I just want to make sure I understand whether they are or they aren't.
Sure. So as great question, Senator Lesser. As per their bulletin and the updates that we've received thus far, there are still, I believe it's just over 20 anticonvulsants on that list, and unfortunately, that represents 19 of the 20 most commonly prescribed epilepsy medications. So, to be candid, our professional advisory board was aghast. Just because even in those, and even successful swaps over to generic drugs in that context can still lead to breakthrough seizures pretty frequently.
Yep, seems pretty bad. Okay, well, thanks for bringing that clarification to us. We will take a very close look at it. Thank you.
Thank you so much.
Yes, thank you so much for your testimony and for being here today.
Thank you.
Next is Alice Forrester.
Hi. Good afternoon, distinguished members of the Human Service Committee. I'm Alice Forrester, the CEO of Clifford Beers Community Health Partners, and I'm here today to urge your support for Senate Bill 87 to establish and support the Nonprofit Advisory Council within OPM. Nonprofits are not peripheral to Connecticut's human service system. As you've heard all day, we are the system. Over the past several decades, as Connecticut transitioned from state-run institutions to community-based care, nonprofit organizations became the primary providers of behavioral health, child welfare, disability, housing, and community support services. This model benefits residents because services are delivered locally, tailored to urban and rural communities, and provided at a lower cost than state-operated systems. But the structure also creates unique vulnerabilities that need very close attention. And Connecticut relies heavily on the nonprofits. We have high Medicaid penetration, complex administrative oversight, a high cost of living, and persistent workforce shortages. These factors create structural fragility. When reimbursement rates stagnate or fail to recognize indirect costs, the entire service system is strained. We operate under a different financial reality than for-profit providers. We both follow GAAP principles, but the governing question is different. For-profits ask whether an activity generates sustainable margin. Nonprofits must ask whether every dollar was spent exactly as legally restricted. As a result, nonprofits juggle multiple grants, cross-subsidized programs, and operate with far thinner administrative margins. Compliance costs and infrastructure are underfunded, and rate setting frequently overlooks the true cost of delivering care. What may look like inefficiencies often is structural misalignment, and that is why representation within the Nonprofit Advisory Council is so important. I support Senate Bill 87, and I do ask, because many of my colleagues have asked, to make sure that there are enough seats for providers on the council. It's very important for the majority of Connecticut's human services have a formal voice in policy, rate design, and administrative reform. I support this bill, and I think that Connecticut's residents really depend on our state and nonprofit partnership, and this nonprofit council will strengthen it. Thank you very much for your time and your consideration. Thank you.
Thank you so much. Thanks for being here. Seeing no questions, I'm going to go to Tammy W. From McGuire's Oil. You just need to unmute.
Okay. Can you hear me?
Yes, go right ahead.
I am Tammy Wozanowicz, and I'm the office manager as well as the managing partner for McGuire's Oil. We are a small family-owned heating oil company located in Preston, Connecticut. I'm here today to oppose HB 5355, an act concerning fuel pricing in the Low-Income Home Energy Assistance Program. Here we are again talking about the prices that we are allowed to charge customers under the Energy Assistance Program. DSS was mandated to make changes to this program, and they did so in a way that made things worse. Now they are back trying to repeal language that would eliminate the county differential for good and continue to make the situation worse. As you've heard in previous testimony, we were given two options, the margin over rack or a 35-cent discount off of retail, which is an extremely high discount off of retail pricing. We were only given an option to switch models in the first week of the program. DSS will not allow us to make this change now. As previously stated, the price is set by the commissioner and is always behind a day. The price that is put out on a Friday runs straight through the weekend into Monday. Then add in a holiday or perhaps a snow day, and you're days behind a possible increase that occurred on a Friday. The pricing is never accurate with the MOR either. That's another thing. It's never a 50-cent margin. As we're currently experiencing a really high market volatility right now, the price we are allowed to charge today at the Norwich MOR, market over retail, rack, sorry, it's 20 cents less what we can charge today than what we pay for the fuel. We cannot deliver fuel today, nor can we deliver it tomorrow, because at this morning's prices that came out, we're 25 cents under based on the prices that came out this morning. How can we operate like that? We're not in the business to lose money. So DSS is ignoring the other thing that's important. DSS is also ignoring how many fuel vendors have dropped out of this program over the years. In Southeastern Connecticut alone, we had 2 major vendors drop out of the program. Each of them held multiple companies under them. So we're talking actually 6 companies that dropped out at the beginning of the season. They said, nope, we're not going to do it. So when this happens, the customers, they all have to be reassigned to other heating oil vendors. We took on some at the beginning of the season, and we always try to help. But in January, we had to say no more. We can't do it. We were overwhelmed because guess what? Winter showed up in Connecticut this year. So as we try and work through things, and we are working 7 days a week, we are trying to make sure that all of our customers are taken care of, but we're small. We have 2 drivers, myself, and 1 other person in the office. That's it. And as stated by previous oil vendors on this call, we're all here to help work with our customers. Our goal is to get the oil to them. We want to keep them warm. I work very closely with my energy assistance customers as well as our action agencies every year and go above and beyond. DSS needs to understand that we're here, we're not an adversary, and this feels very adversarial. I respectfully ask that you reject HB 5355. Thank you.
Thank you. Thank you for being here and for your testimony. Next, Christine Cohen. Antonia Koloidis. No. Marlene Reisk. No. Yep. Lisa Davis.
Good afternoon, Senator Lesser, Representative Gilchrist, members of the committee. Thank you for giving me the opportunity to speak. I'm an attorney from New Haven who's focused on elder law and planning for families of individuals with disabilities for 35 years. So I'm submitting this testimony on behalf of the Connecticut chapter of the National Academy of Elder Law Attorneys and on behalf of all of our clients. I'm addressing bills 329 and 330, but first I would just like to add my strong support for the terrific testimony earlier today regarding any change in community first choice as a basic Medicaid benefit. I've seen it as an absolute lifesaver for my clients, and also in support of any removal of asset limits and raising of income limits. However, I'm just going to testify first about Senate Bill 329, which is really a very small technical fix on the income side, which would still be very helpful, even if income limits do not go up to stop the current discrimination, but it would still be a great help. It's just a few words, Senate Bill 329. And it's not really expanding Medicaid eligibility. It is just fixing a little bureaucratic glitch that we have for people with lifelong disabilities, like the individuals earlier with various severe developmental and other disabilities. What happens to them is when a parent retires or starts collecting Social Security or dies, their income goes up. So normally they would start out with SSI benefits, which are only $994 a month, which is well below the Husky C income limit. But as an adult disabled child of someone on Social Security, when that person collects or dies, they are entitled to either a survivor benefit if the parent dies of 75%, or a 50% benefit of the parent's amount if the parent is collecting Social Security. So typically what will happen is someone will be going along on SSI and Husky C, and then if their parent had some decent earnings, all of a sudden they're going to be getting, $1,500 or $1,600 a month. And suddenly they get a notice that says, you're not eligible, you've gone into spend down. You've heard the term spend down being used. And I'm not sure if you're familiar with that. We're used to that in the nursing home context. But what this means is that every 6 months, for them to qualify for Medicaid to cover anything, first they have to pay a deductible, and which is a huge headache and is sort of impossible to navigate if you're trying to get coverage for drugs or personal care services. There are workarounds. So in the event that even this little bill gets some sort of a fiscal note, people like me can solve this problem. If people will come to me and pay me, I can create workarounds. You heard from other people who are in a program called MedConnect where they work, and that's one of the workarounds this problem. But it is really quite ridiculous that somebody with this lifetime disability should be in that situation. And by excluding the income for people who get this child disability benefit, which is what that reference in the reference to 42 USC 402 D1G means, it'll be much easier.
Summarize.
So I'm very much in support of SB 329 as a simple fix to a problem in the face of all these other problems. And I'll just add another note to supporting SB 330 that deals with paying spouses to provide services. And I'll otherwise refer the committee to my written testimony.
Thank you very
very
much.
much.
Thank you for being here. Thank you for your testimony. Next, Maria Coton Skinner. Oh, okay.
Good afternoon.
Good afternoon.
Thanks ever so much for the opportunity to testify, and thank you for enduring the difficult weather while you do so. Really appreciate that. My name is Maria Coton Skinner. I'm a licensed clinical social worker, and I'm president and CEO of McCall Behavioral Health Network. And I'd like to testify for Governor's Bill 87, an act strengthening nonprofits. So we appreciate Governor Lamont's leadership in introducing this important legislation, establishing this nonprofit advisory board within OPM to advise the governor would create a meaningful and structured forum to identify and address the challenges nonprofits face as we contract with the state to deliver essential health and human services. This is one of those really wonderful things where we have solution-focused legislation, really without a fiscal note. A couple examples of where I think as a provider for the last 35 years, this could have a meaningful impact. There's opportunities to find efficiencies within oversight structures. So for example, McCall is accredited by the Joint Commission. We hold mental health, substance use, primary care, and psychiatric clinic licenses from DPH, as well as child and adolescent program licenses from DCF. Our substance use programs are certified by ABH. In addition, our clinical services are subject to extensive oversight and quality controls from DMIS, DPH, and DCF. For every clinical service we provide, there are authorization requirements tied to each client's coverage. This involves Carelon, as well as commercial insurers with whom we are credentialed. We're in network with all Connecticut commercial payers. We undergo site visits from the Joint Commission, DPH, DMIS, DCF, and ABH, and we submit numerous reports, surveys, and data submissions for each level of care. Now, while the intent for all of these processes is to ensure quality and safety, they are often redundant and administratively burdensome. Importantly, they don't consistently achieve their intended goal, which is to improve patient outcomes. The cumulative effect diverts time and resources away from direct care and innovation. More than 75% of the individuals we serve are covered by Medicaid. We recognize and respect that public dollars are being invested in the lives of people that we serve. And with that investment comes responsibility. Nonprofit providers are committed to being strong stewards of these funds. We believe accountability can be strengthened through alignment of quality measures, reduction of duplicative oversight, and collaborative development of outcome-based standards between state agencies and nonprofit providers. For example, McCall is currently engaged with an outside entity in a grant-funded analysis of our outcomes data and our payer mix to demonstrate the value of high-quality, evidence-based care to advanced value-based payment models. We can show that exceptional care is being delivered and that lives are meaningfully improved. Across Connecticut, nonprofit providers are delivering measurable value to residents every day. Senate Bill 87 provides an opportunity to formalize a collaborative framework that supports high standards of care, measurable outcomes, and efficient processes. Yep, almost there. I think my predecessors talked about how efficient the cabinet was under Governor Malloy, and this is an opportunity to codify that in this durable way moving forward. Thank you again ever so much for the opportunity.
Thank you so much. Thank you for being here today and for your testimony. Next is Alyssa Godudi. I didn't say that right either.
You did. You got me. Good afternoon, Senator Lesser, Representative Gilchrist, and members of the Human Services Committee. I appreciate the opportunity to speak with you and lend my voice to the many you've heard today in support of Senate Bill 87 and Act Strengthening Nonprofits. I'm Alicia Godudi. I'm the President and CEO of Edelbrook Behavioral and Developmental Services. Edelbrook is a 125-year-old multi-service agency specializing in serving those with autism spectrum disorders. We contract with many state agencies, including Department of Developmental Services, DCF, municipalities, school systems. We have licensure through the Office of Early Childhood. We receive Medicaid funding through Department of Social Services and really represent a cross-sector of the human service state agency funding entities. We support 400 young people and their families with highly complex behavioral and developmental needs through the help and amazing expertise of more than 650 employees in 27 locations throughout Connecticut. I know you've heard a lot of testimony about this bill. I want to lend my voice to support the establishment of the next phase of a nonprofit health and human services cabinet. 15 years ago, I had the honor of serving as a member of the nonprofit cabinet established by Governor Malloy, and I'm so thrilled to see this being raised by Governor Lamont now. 15 years ago, I can tell you this was one of the proudest things that I did as a human service provider, working with state agency leadership, working with colleagues, leaders of the nonprofit human service system to improve contracting practices, to streamline administrative requirements, address redundancies, improve infrastructure, consolidate contracting and reporting requirements, and start to think about something we don't do often enough on the human services side, which is planning and thinking about the future. We spend a lot of time dealing with the here and now, putting out fires, addressing crises. This group really served as a planning entity. It also served a unique role in building relationships. Many times us as providers, we are the ones that know that DDS does something this way or DCF does it this way. DMIS does something a different way, and we can share those best practices. This group was a venue for the state agencies to come together to talk about with their providers what's working, who's doing things really well, how can we borrow from that, and how can we do more of what's working and less of what we've done historically. Many times in the nonprofit world, we fill out reports and we're not exactly sure if those reports are actually used or if it's just an old requirement that no one ever remembered to go back and remove. So this venue, this group would really serve a tremendous function, helping us put our energy and our resources into what matters, serving individuals, and less in lack of meaningful reporting requirements, administrative burdens. And I couldn't be more proud to support this bill and really hope that you all will do the same. And please put some more providers on this committee and allow that you all get to appoint us, because that's really important. And we'd like you at the table too.
Great points. Thank you so much. Appreciate it. Representative Dathan, go right ahead.
Thank you so much. And just wanted to ask the speaker if they think that this council will also help nonprofits be able to illustrate the real cost to deliver services to our safety net. We all know that if the state was doing these services, it would cost a great deal more money. And I'm wondering if you see that this council could help the nonprofits sort of justify their rates that they're receiving.
Oh, I appreciate the question, Representative Dathan, and absolutely the answer is yes. One of the 4 areas that we focused on in this went on for several years, the governor's cabinet on nonprofit health and human services, but one of our focus areas was on financial sustainability. And we did a lot of data collection around the true cost of service provision and looked at what does that look like in the future and how are we adding to and strengthening communities across the state in an efficient and effective way. When this group went away, we kind of lost that mechanism to be able to collect that really important data, which is going to inform decision-making about system structure, service provision, and really how are we going to support those in need across the state. So I think 100% yes, that could be a very important and was a very important function of that group.
Wonderful. Thank you both so much. Thank you. Good to see you.
It's good to see you too.
Sorry. Sorry.
Oh, sorry.
Did I go out of? No, I was just trying to understand if this would also help the workforce and help identify workforce strategy in our state. But I can follow up with the speaker later because my reception isn't great.
It was one of the 4 groups. We had a workforce retention strategy when we did this in 2017.
Excellent. Thank you so much.
Thank you,
Madam Chair.
Thank you. All right. Simona Donra.
Good afternoon, Senator Lesser, Representative Gilchrist, and the members of the Human Service Committee. Thank you for the opportunity to offer testimony in strong support of HB 5357, an act concerning residential care homes. My name is Simona Donrach, Assistant Administrator at Westside Manor in East Hampton. We serve 41 residents, many living with significant mental health diagnoses. Without residential care homes, many of them would face homelessness. We provide 24-hour supervision, meals, medication administration, recreational activities, housekeeping, and daily support, all for under $100 per resident per day. That rate must cover staffing, food, utilities, insurance, maintenance, and compliance with extended state regulations. The problem is simple. Our reimbursement system is outdated and has not kept pace with inflation. Wages, food costs, utilities, and insurance continues to rise, but our rates do not adjust accordingly. When a bed is vacant, funding drops immediately, yet our fixed costs remain. Workforce stability is increasingly difficult, and administrators frequently cover extended shifts without additional compensation. In the continuous, homes will close. When that happens, residents move to emergency rooms, nursing homes, or homelessness, all far more costly to the state. HB 5357 makes necessary corrections by adding inflammatory adjustments, updating administrative salary caps, and modernizing fair rent calculations. These are not enhancements, they're sustainability measures. Residential care homes are one of the most cost-effective levels of care in Connecticut's system. Supporting HB 5357 supports vulnerable residents, stabilizes the workforce, and prevents higher downstream healthcare costs. I respectfully urge your support. Thank you for your time.
Thank you so much. Thank you for your testimony and for being here today.
Thank you.
Next, Lisa Leach. Is Lisa with us? Okay. So I'll go to Heather Latora.
Hi, Senator Lesser. I'm Rep. Gilchrist. Nice to see you and everyone else. Bringing it home again, I guess. There's a few more, maybe. Anyway, and to the whole Human Service Committee, my name's Heather Latora, and this year marks my 40th year working at Marrakesh, We're a human service organization that supports individuals with intellectual and developmental disabilities, autism, mental illness, acquired brain injuries, substance use disorders, those experiencing homelessness, youth in foster care, people who are unemployed and underemployed, and others who need our help. And today we support over 1,000 individuals across Connecticut, whether in group homes, private homes, community locations, workplaces, classrooms, throughout the greater New Haven, Waterbury, and Bridgeport regions. We employ 650 dedicated and compassionate staff, and we hold contracts with DDS, DMS, DCF, OWS. We receive DSS funding. We also support people through ABI and mental health waivers and operate HUD-funded state affordable housing units. I've seen this agency grow from 35 of us to over 650, working with my state partners. And I'm not there in person, unfortunately, because I had it, well, the weather too, but I just had a meeting with my staff to inform them that this year we will not be able to afford an agency sponsored 401k retirement contribution for this fiscal year. And it's due to the changes in how these resources are dispersed to us. And I truly hope we don't have to wait another 12 years, because we did have a 12-year stint before we could ever make a discretionary contribution again. As you can imagine, today is not a day I wanted to be in this role. So thank you, Representative Gilchrist, because you asked the question about current and future DDS funding and its impact on nonprofit and our workforce. It's essential to ask us questions. Now that you've heard from so many other, I just want to offer information that I hope adds something different to the bills I support. Regarding HB 5040, Section 4, I support Commissioner Barton-Reeves' recognition of the importance of the rate increases for the ICF IIDs. In her words, these increases are absolutely necessary, and they are. Our ICFs are in a fragile place. Just months ago, our board asked us to develop a plan to either stop the financial bleeding within 1 year or consider to stop these services. And many people don't realize that our ICFs are also able to support people who don't qualify for DDS services and therefore can't live in a DDS group home. Yet still they need this level of support. These homes catch people who fall through the cracks, and I know that matters to you as it matters to us. Representative Case asked whether these increases are only for DSP wages or for administrative wages, and I have to explain, we already increased direct care wages at our ICF IIDs to simply keep the programs afloat, even without the corresponding rate increases from DSS. These funds would finally help stop the bleeding and the ongoing deficit by creating what was necessary to keep the programs going and to match the DDS group home salary for direct support professionals. And regarding SB 87, an act strengthening nonprofits, I want to emphasize that nonprofits and state agencies have been longstanding partners. Connecticut needs a strong, competitive provider network. And one that is ready, willing, and able to serve. But in recent years, something essential has been lost. Waiting lists grow longer. Competition for RFPs have diminished. Years ago, when DDS released an RFP for youth aging out, dozens of proposals would come in. That level of engagement fostered innovation and ensured young people did not end up on waiting lists in hospitals or in inappropriate emergency placements. Recently, DDS offered 2 rounds of RFPs for 10 new CLA group homes. We were proud to be awarded 1, but I'm not confident that all the individuals have placements. The private sector should be a proactive partner, helping the state build a responsive, person-centered system that intervenes early and prevents crisis and ensures every individual receives supports they need and not end up on waiting lists. Therefore, you must include us in these discussions. Thank you for the opportunity to testify, and we urge your support for SB 87 and HB 5040.
Thank you so much, Heather. You threw us by saying you'd been there for 40 years. You have.
Oh, thank you.
Thank you for everything you do and for your testimony today.
Thank you.
Lisa, I believe Lisa is on.
I am. Thank you so much.
You're welcome.
Quite a challenge. Is it my turn now to go ahead?
Go right ahead.
Okay, great. So I am Lisa Leach. I'm the Director of Operations for Freedom Care in Connecticut. Wanted to speak to you today regarding SB 330 and We are in strong support of SB 330, which would allow spouses to be compensated for providing personal care assistance under the state-funded portion of Connecticut's home care program for the elderly. It recognizes the reality in long-term care. A spouse is often the primary caregiver and is the only consistently person available to provide care safely at home. I want to urge the committee to extend this same principle beyond the state-funded portion of the program, as limiting paid spouse caregiving to only the state-funded program will leave the largest driver of institutional long-term care costs, which are Medicaid nursing facility care, largely untouched. Connecticut's nursing facility system is heavily financed by Medicaid, and based on DSS data, it states that Medicaid is the funding source for roughly 3/4 of the nursing home care. Connecticut's OPM nursing facilities census indicate that there are over 20,000 nursing facility residents statewide, 73% of which are Medicaid. 82% don't have a spouse, but 18% do. This means that there's about 2,600 married Medicaid nursing facility residents who represent a meaningful pool of people who are or could be paid spouse caregivers and could be part of a safe transition home when clinically appropriate and desired. This cost difference is substantial. The AFL home care model is far less costly than Medicaid nursing facility rates. Allowing the spouse to be the caregiver can save the state anywhere between $6,700 and $8,800 per member per month based on the current AFL daily rates. This differential is large enough that preventing or shortening nursing facility stays can yield very significant savings while also aligning with what is most important to people, and that is aging at home. Other states already do this with structure and guardrails, so Connecticut doesn't have to be the one to break new ground. For example, Indiana's structured family caregiving model, under the waiver, guidance explicitly states that a spouse may serve as the caregiver. This demonstrates that paid spouse caregiving can be operationalized inside a Medicaid waiver framework with monitoring, service planning, and accountability. My request to the committee is to please support SB 330 and strengthen it to extend paid spouse caregiver eligibility beyond the state-funded portion to include the Medicaid-funded portion, apply SB 330's intent, training, and documentation standards across Medicaid HCBS so paid spouse caregiving is structured, monitored, and safe, and preserve and align cost guardrails within existing program requirements and waiver cost neutrality principles consistent with SB 330's existing cost containment network. I'm open for any questions.
Wonderful. Thank you so much. Glad you were able to get on.
Yes, thank you.
Don't see any questions. Thank you for your testimony.
I appreciate your time.
Too. And then Catherine Valeda.
Hello. Hi, everyone. Good afternoon, Senator Lesser, Representative Gilchrist, and esteemed members of the Human Services Committee. My name is Catherine Villeda, and I'm the Coalition Director for Husky for Immigrants. We're a statewide coalition of over 40 organizations advocating for equitable access to Husky Health for all income-eligible residents, regardless of their immigration status. Thank you for the opportunity to testify this afternoon in strong support of SB 327, Enact Expanding Medicaid, Emergency Medicaid Coverage. Emergency Medicaid is an important conduit in addressing coverage gaps from income-eligible residents who are systematically excluded from the most affordable healthcare coverage options, including Medicaid and Marketplace coverage. SB 327 provides a much-needed adjustment to expand the conditions eligible for emergency Medicaid coverage in Connecticut and would allow eligible residents to enroll in emergency Medicaid ahead of any emergencies. This will ensure that uninsured residents have better health outcomes and not be burdened with the administrative tasks to enroll for coverage when facing life-threatening chronic conditions. Emergency Medicaid allows states to also receive federal matching between 50 to 90%, depending on the medical situation. And in light of federal cuts, expanding the definition of medical conditions that would qualify under emergency Medicaid could provide the state a pathway to ensure that we're still receiving federal funds through viable avenues. I do want to acknowledge that the governor's proposed budget for the second year of the current biennium budget does eliminate some funding to set up an administrative system for people to apply in advance for emergency Medicaid. I would like to strongly suggest for the committee to sustain that funding as negotiations continue this legislative session. And I do also want to highlight that in our written testimony, we provide some recommendations on revisions that we would like to see on SB 327. These recommendations clarify some of the current bill language, promote some data protections, and offer various conditions that are covered in other states' emergency Medicaid coverage that are not reflected in the list provided in SB 327. Thank you for the opportunity to testify, and I hope you all have a safe travel this afternoon.
Thank you very much. You too, if you're going anywhere. Thank you for being here and thank you for your testimony. I think that is it. Is there anyone in the room who wants to testify? Seeing none, that concludes our public hearing for today. Thank you to all who testified and all the members who participated. Our next meeting is next Tuesday. Will be a public hearing, so we'll see you all then.
Thank you, chairs.
Thank you.